Section 18 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 10. Another fact. When he formed the intention to visit the schoolhouse, Robert was in Cincinnati, and he was then going unaccompanied by anyone except his brother Willie, who, as the party most nearly concerned, desired to be on the spot when the explanation was made and to confront all that should be brought against him. He did not ask Robert to go. He did not even consent that he should go, until his mother insisted on it so earnestly that he complied to gratify her feelings. If Robert J. Ward, Jr. is such a dangerous young man as the gentleman would make out here, this only shows that the prisoner wished to avoid all possibility of collision and difficulty. If a man contemplated murder, would he be likely in broad daylight to seek a point where he could be seen and heard by 50 witnesses, and there do the deed? Would any man in his senses take such a course? Gentlemen, it is opposed to every principle of reason. The presumption is perfectly absurd. Look at the subsequent conduct of the accused. We are told that the wicked flee when no man pursueth, but the innocent is bold as a lion. You have heard of the anxiety he felt for the condition of the wounded man, how, the moment he heard the voice of the officer at his father's door, he immediately came out and promptly surrendered himself up to await the proper judicial investigation of the affair. Had he intended to commit murder, it is reasonable to suppose that he would have taken at least some of the ordinary precautions for escape. But every circumstance of the case, the character of the man, his disposition, his acts both before and after the affray, and the harmonious relations of all the parties, all tend to refute triumphantly any presumption of malice. Gentlemen, I have been requested to correct a statement which you have heard, that Marshal White went with this accused to Colonel Harney's residence to ascertain the condition of Professor Butler. Such was not the case. When Robert J. Ward met the city marshal and an assistant officer on the street, he suggested that one of them should go and learn how Mr. Butler was, while the other went to his house to arrest the prisoner at the bar. Mr. White, however, knew the prisoner well, and from his knowledge of his character and disposition, had an abiding and firm conviction that he would make no attempt to leave the city. Hence he first went to the residence of Colonel Harney to inquire after Mr. Butler, and then repaired to Mr. Ward's house, where he found Matt, as you have already been informed. And for this, one of the most respectable and honorable officers of the city of Louisville is represented to you as conniving at the escape of a prisoner, because he was the son of a rich man. How much reliance is to be placed on such representations, you gentlemen can judge. Mr. White has been honored with the trust of the people because he is a faithful and zealous officer, and a high-toned and honorable gentleman. He knew there was not the least danger of any attempt to absent himself on the part of the prisoner. He knew that he was a man who, acting only as he deemed right and proper, would never fly, having no guilty conscience to accuse him. The result proved that he did know the accused, whatever the gentleman may say, and is not this alone a commentary on the character of this prisoner, which you have no right to overlook? He is no desperate ruffian, no midnight assassin, but one who, though he may have committed one unfortunate act, still retains in his bosom the proudest elements of a man and a gentleman in all the relations of life. My friend Mr. Harris thinks that inasmuch as I alluded to him before dinner as a sort of walking arsenal, I ought to do him justice by saying that he never carried arms, except when he had just occasion to do so. I presume that this is the case. I have confidence that he never carried a weapon in his life for any other than a defensive purpose, to be used only when absolutely necessary. And this, gentlemen, I also contend is equally true of my client. My friend has also made allusion to a scene in his juvenile experience. He tells you that he was once whipped at school, and that when he returned home and told his mother, she whipped him again, and then sent him back to the teacher with instructions to punish him once more. Well, he has endeavored to impress the fact upon your minds that a mother knows her son and understands every point in his character better than any other person on earth. And I have no doubt that in this case the general principle was true, and that his mother, knowing what was best for him and what he really deserved, acted accordingly. As he has related an episode in his personal history, I might give you an incident in my humble experience. I once went to school to a teacher who has since occupied distinguished positions in life, but who was a cruel and hard-hearted man. I have seen him lay 87 lashes on the back of a pupil, and there was not a dry eye in the whole schoolhouse. On one occasion, during the absence of my father, in punishing me, he inflicted such a wound on my face that when I unfortunately took cold in it, my jaw was swollen to twice its usual size, and I was compelled to carry my head on one shoulder for weeks. When my father returned, he learned of the occurrence, that I did not tell him of it, and he sought that teacher, and would have drubbed him soundly for his brutal conduct, had he not been prevented by his friends. There has been of late a great change of public sentiment on the subject of whipping, and it has been abolished, not only in the English and American navies, but also in all well-regulated schools. The world is beginning to learn that the sway of love is more potent than brute force. The gentleman may talk of universal principles, but there is no principle in nature more universal than the law that kindred blood will stand by kindred blood. Go into the forest, and even the lowest vermin in the range of animate creation will resent an insult offered to their kindred blood. The hen, the pheasant, and the gentle partridge, the wildest bird in our woods, will flutter around their offspring to protect them from impending danger, and punish any insult that may be given them. And I have somewhere read of an incident in which the sluggish and stupid pelican, when she saw her nest robbed, and her young taken rudely away before her eyes, while she had no power to protect them, with her beak tore out her own bleeding heart in agony and despair. I ask you if there can be a higher sentiment than that which, when the father is insulted or the child is outraged, prompts son or brother to resent it. Our feelings and our passions come from on high, and no human law can repeal the laws of the Almighty. As well might you command the waves of the ocean to cease their turmoil, the broad leaves to fall no more at the approach of the frost, the buds not to swell, and the flowers not to unfold in the warm breath of spring, as to attempt by any verdict that you can render to blot out from the human heart this kindred sympathy and kindred love. As long as man lives, the principle will exist, and it is right that it should be so. Would you have us dead and inanimate to every generous pulsation of the human heart, callous as marble, Ishmaelites on earth, with our hands against our brother and every man's hand against us? It cannot be. Blood will cleave to blood. What then has this man done? He sought to perform an act of justice, and he asked the explanation which was his due in the very mildest form. The gentleman will tell you that he ought not to have taken a weapon with him, but I contend that in his weakened and enfeebled state, an invalid weighing only 110 pounds, it was perfectly legitimate and proper under such circumstances for him to be prepared to ward off any other and deeper injury that might be done him. I ask you, when you go to your room, to consider his character, his antecedents, his conversation, all the circumstances, and then inquire if it is probable he sought that schoolhouse, intending to commit a murder, in the presence of 50 witnesses. I feel an abiding conviction from all the proofs in the case that he no more intended to use that weapon offensively than I now intend to draw a weapon from my pocket and plunge it into the heart of some man in this jury box. But they say he brought on the difficulty. Let us look at the facts. In the eyes of the law, words can justify no assault. He went for an explanation. He asked it in a gentlemanly way. That was the proper place for it. In the recitation room it would not have answered the purpose, but the boy might still have been proclaimed and believed by his companions a liar. It was not until all explanation was refused that Wood used offensive words, and even had he done it before, remember that they cannot justify an assault. What could he do? No investigation, no redress, no justification of the act. Was there any other course left than the one he pursued when he applied the appropriate epithets to his adversary? It is true that Butler was an unexceptional man, a very good man, if you please, but we are trying another good man, and after Butler had lived in the family so long, when he knew all its members to be his friends, after he had inflicted wounds deeper than those of the flesh, a stain upon the character and the honor, was not an explanation due? Would it not have been a simple act of justice? The prisoner did not assault him, did not waylay him, as he would have been likely to do had he only sought vengeance in blood. But he went on his errand of duty to his little brother, with the frankness of his nature, with the frankness of a man, directly to Mr. Butler, in a mild and courteous manner, as one gentleman always treats another. He asked the explanation which was twice so heartily refused. Then offensive language was used. He was attacked, and the result was produced which has brought us here. Can you believe, when he determined to perform a high and sacred duty, and simply place his little brother right, if he had been wronged, that his heart was under the influence of malignity and malice? Such extremes cannot exist in our nature. They are at war with reason and common sense. It is said that if a man brings on an assault by giving just provocation, he is not justified in repelling it. Now, that you may see what acts the law regards as evidence of intention to provoke an assault, I will read you the case of Richard Mason, from Russell, Volume 1, page 220. After relating the circumstances, the author says, in the foregoing case, it will be observed that the blows with the cudgel were a provocation sought by the prisoner, to give occasion and pretense to the dreadful vengeance which he meditated. And it should be observed that where the provocation is sought by the party killing, and in order to afford him a pretense for wreaking his malice, it will in no case be of any avail. Do the facts indicate that the provocation was sought here for any such purpose? The only satisfaction left the prisoner, after all explanation and justice were refused, was that of hurling back precisely the same insult that had been offered to his brother, and thus making the one offset the other. When this produced a collision, his acts did not indicate that he had given provocation that a pretext might be offered for wreaking vengeance, for he only used the weapon as a last and direful resort, in a case where there was no other alternative. Another case in point which will show how far manslaughter goes is that of Luttrell, reported in Russell, page 515. Having disposed of the charges of murder and manslaughter by citing the law and applying it to the facts, I will now take up this case of one of justifiable homicide. There are some instances in which the line separating it from manslaughter is hard to draw, but according to my humble conviction, there will be no such difficulty here. This seems to me beyond the shadow of a doubt. I believe it as clear a case as ever was made out, of a man killing in defense of his own life. Yet should any doubts linger in your mind, whether the act for which my client is now on trial was manslaughter or justifiable homicide, it will be your duty to acquit. In regard to the circumstances that render homicide excusable, Russell tells us, page 514, note, among equals, the general rule is that words are not, but blows are a sufficient provocation. And in Wharton, page 256, we read, there may be cases sometimes occurring, the very rare and dangerous application where a man, in case of personal conflict, may kill his assailant without retreating to the wall. The assault may have been so severe as not to allow him to yield a step without manifest danger of his life or enormous bodily harm, and then in his defense, if there be no other way of saving his life, he may kill his assailant instantly. You see, gentlemen, that there are instances in which a man is justified in killing his adversary, even without retreating to the wall. But such was not the case here. The prisoner at the time he shot had retreated to the wall, and if he was then in danger of receiving great bodily harm, he was justified in killing his opponent. In Russell, page 661, note, we find the principle laid down that, where upon the trial of an indictment for murder, the prisoner attempts to justify the homicide on the ground that it was committed in self-defense, he must show to the satisfaction of the jury that he was in imminent danger, either of death or some great bodily harm. This is the old common law of England, but here it has been modified and ameliorated in the case of the state of Tennessee versus Granger. Yeager, Tennessee reports. The principle was established that when in case of conflict, a man believes and has ground to believe that he is in danger of great bodily harm, he is justified in killing, whether he really was in such danger or not. His right to defend himself cannot be abridged, and if he has good reason to apprehend great danger from the facts by which he is surrounded, the homicide is justifiable. At the outset of arranging my proof, I wish to say that I do not propose to attack the schoolboys who have been introduced by the Commonwealth. I have kind feelings towards all of them. I believe them utterly incapable of stating a falsehood, knowing it to be such. But our object in bringing Mr. Allen and Mr. Gudgel to the stand was to show that before the occurrence, from the rule of school which prohibited turning around in the seats, and after it, by the unusual excitement and consternation which prevailed, by the drilling to which they have been subjected, and by reading everyday publications of what they were expected to state, the impressions now on their minds are many of them incorrect. We desired to prove that then, while the occurrence was fresh in their memories, and before any improper influence had been exercised upon them, they gave quite a different account of it. While we impute no improper motives to the boys, can anyone doubt for a moment that these gentlemen saw them at the schoolhouse, asked how the affair had happened, and were answered as they have related on the stand? That the boys do not distinctly remember them is not surprising, for you must have observed that few, if any of them, were able to recollect what boys were present at the time, and by whom Butler was assisted to Colonel Harney's. There are many other particulars in regard to which their memories are conflicting and imperfect, and I am sure, gentlemen, you are not capable of taking the life of a man on such testimony as this. We pursued the course we did in regard to these boys, merely to show that they could not give a perfect and credible statement, and detail the affair as it took place. All the facts of the case are important as throwing light upon it. If you believe this prisoner guilty as charged, I do not ask you to acquit him, but if you believe that he only performed a justifiable act, it is your solemn duty before God and your country to rescue him from a dishonorable grave. Appeals have been made to your feelings. We sympathize deeply with the unhappy lady you saw on the witness stand, and were I able to reverse the occurrence that has bereaved her, it would be the happiest and proudest act of my life. But the dead are gone, and it is your duty to see that you do the living no wrong. The most bitter anathemas have been hurled at our witness, Robert J. Ward, Jr. You have been told that he stood here a prejudiced and impeached witness, testifying on his own behalf, and that the halter was even now impending over him. He is not on trial here, but I must say that I consider his detention and confinement without warrant of law, and a wanton restraint on his liberties. Before they can make him criminal, they must prove that he knew it was the prisoner's purpose in visiting the schoolhouse to perform an unlawful act, and according to all the books, they must show that he aided and abetted the fact committed. I put it to you, canted gentlemen, whether he did anything of the kind. It is not consistent with law to believe a witness unworthy of credit when he states nothing contrary to reason and is corroborated as to all the principal facts. End of section 18. Section 19 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 11. In reviewing the testimony, I will begin with that of this witness, for he was present, saw all the facts, and gives a perfect and connected account of the transaction. Other witnesses give us broken accounts and disconnected circumstances, but he fills all the chasms they leave, and gives a perfect and rational history of the whole matter. In almost every particular, too, he is corroborated in a wonderful manner by the witnesses for the prosecution. He states that they entered the schoolhouse, Matt first, he second, and Willie last. That Willie went to his seat, while they remained standing. That Matt sent for Professor Butler, who came out, and they exchanged salutations. On these facts he is so perfectly sustained by all the other witnesses that none of them are questioned. He tells you, however, that while the conversation was going on, Matt had his hat in his left hand and was gesticulating with the fingers of his right. They have attempted to controvert this and show that his right hand was in his pocket during the whole time. But at least two of the other boys agree with Robert that Matt held his hat in his left hand. He goes on to relate that the prisoner said, "Mr. Butler, I have called to have a little conversation with you." And in substance, almost every one of the schoolboys testifies to the same thing. True, some of them understood the expression to be a little business, and others a little matter to settle, but they all agree perfectly as to the idea expressed. The first question which the witness relates, as asked by the prisoner of the deceased, is, "What are your own ideas of justice? Which do you think the worse?" etc. Now Purtle, who was unable to hear all the conversation, tells you that he caught the fragment, "ideas of justice." The boys have all testified to hearing the words, "little contemptible puppy." And Robert tells you that they were used by the accused when he asked his question the second time. The witness also tells you that he asked, "Why did you call my brother a liar?" Now Worthington testifies that he understood him to inquire, "Did you call my brother a liar?" And others make statements to the same effect, though there may be a slight variance in the language. Robert tells you that an explanation was asked and refused, and Knight, as you will remember, states that he heard Butler make use of the language, "I don't feel disposed," though he did not hear the connection. And so in every point Robert Ward is so perfectly and clearly corroborated by the witnesses for the prosecution that we have every reason to believe he has given a faithful and perfect history of the whole transaction. He heard some things which the others did not, but he was nearer to the parties than any other witness, and in his account of the conversation, the chasms and fissures that they have left are completely filled up. Worthington, it is true, states that the question asked of him, Butler replied he would not answer unless he could be permitted to explain, and Robert relates nothing of the kind. Now I wish to say nothing in disparagement of Worthington, but you must bear the fact in mind that he was further from the parties than any other boy who testified here. The distance could not have been less than 30 or 40 feet. Now, how is it, if Butler did use the language, that none of their witnesses, several of whom were within from 3 to 10 feet of the spot, heard a single word of it? And under such circumstances, I would ask if the witness who relates this utterly uncorroborated, is more worthy of your credence than Robert Ward, Jr., who is sustained by every one of the schoolboys who appeared on the stand. It is a matter of considerable importance to this case to ascertain who struck the first blow. They have endeavored to prove that it was done by the prisoner, but with what success you have seen. Their first witness on that point is Knight, and he, as you will remember, thought it was struck by Ward, because when his hand was up he saw it come down with a gesture, and noticed that the distance between them increased. Not to recall your attention to the fact that when this witness first appeared on the stand, he detailed all the conversation which took place between Butler and the accused, and then afterwards, on cross-examination, admitted that he only heard a few desultory sentences, but merely in view of the uncertainty and incoherency of his testimony on this identical point, I would ask if you feel justified in taking the life of a man on such testimony as this. Their next witness as to this is Dr. Thompson. Now, I will not imitate the example of some of the counsel of the state in regard to our witnesses, and because he is contradicted, charge him with perjury. He is a member of the church, seems to be a gentleman, and I presume he is one. I certainly shall not attempt to impeach him, even though he did refuse to state while giving his testimony whether he had weapons on his person. But what does he state? That Butler told him Matt Ward had come to the schoolhouse and cursed and struck him, that he struck back and was shot. Now you will bear in mind here that this destroys one of their own assumptions, and clearly proves that Butler did strike Ward, leaving only to be ascertained the isolated fact, who struck first. Professor Yandell, another gentleman of equal respectability and equal character, was on the other side of the wounded man at the moment when this identical statement was made, and he tells you that Butler raised his hand in representing the conflict after the lie had passed, in such a manner as to lead the witness to believe he wished to convey the impression that Ward had raised his hand in a threatening gesture, and that he, Butler, had struck him. Now here are two gentlemen equally credible, and of equal respectability, both witnesses for the prosecution, and I confront the one with the other, and ask if they have not signally failed to prove that the prisoner struck the first blow. On all such equivocal and unsatisfactory testimony, I conceive it your duty to acquit. As I said before, the first blow cuts an important figure in this case. If it came from the prisoner at the bar, it must be considered a material circumstance against him. But on the other hand, if Butler struck first and committed the first assault, and that assault of a severe and violent character, it must tend to exonerate and justify the accused. I humbly conceive we have corroborated Robert Ward on so many material points that you can entertain no doubt of his credibility, and he positively swears that before the shot was fired, Butler seized the prisoner, collared him, ran him back to the wall, and was beating him in the face. A violent assault is equal to a blow. Purtle tells you that he saw Butler's hand on Ward's shoulders. Pope, that Butler sprang towards him. Campbell, that he saw something in his manner or movement which convinced him there would be a rencounter. Crawford, that while Butler's right hand was on Ward's shoulder, with his left he seemed to be grasping as if for the pistol. Benedict, that Butler had told of him and pressed him back, and Quigley, that he pressed him back 8 or 10 feet against the wall and bent him down. This proves conclusively, I think, by their own witnesses, not only that there was a conflict, but that, in the very language of the law, the prisoner was driven back to the wall. Their hypothesis that Butler was grasping for the pistol is completely refuted by the physicians, who state that Butler told them he did not even see who shot him. Let the whole scene appear before you. Here is the prisoner, struggling with a man of twice his power, pressed back against the wall, struck in the face, beaten down towards the earth. The stoutest boy in school is just seizing a pair of tongs, as he says, to keep off Robert. But we all know that Robert had done nothing, and the accused must have supposed that he intended to take a part in the encounter. With that occurrence before him there, pressed down, confined and beaten as he was, however manly and honorable the purpose for which he visited that schoolhouse. In the name of high heaven, I ask you, gentlemen, if he had not good reason to apprehend great bodily harm. If you believe he had, it is your duty to acquit him. We have produced many witnesses here, witnesses of the highest respectability and the most unquestionable integrity, to show, in addition to all the other proof on the subject, that from the appearance of his countenance alone, after the occurrence, it was evident the prisoner had been struck. All the presumptions of malice in this case vanish, even before the Commonwealth's own witnesses, and it must be borne in mind that the very contiguity of the parties, the only fact which caused the fatal result of the shot, was brought about by Butler himself by the violence of his assault. I now come to this man Barlow, and it will require but little time to show how signally their attempt to impeach him has failed. He has testified that he saw Butler at Colonel Harney's after this event, and that in answer to his questions he gave him the clear and reasonable account of it, which he has narrated to you. And how did they attempt to avoid the statement? By contending that Barlow was not at the residence of Colonel Harney at all. So they bring Dr. Thompson, who testifies that he did not see him, but tells you that he was busily engaged in his professional duties. Next they introduce Knight and ask him, "Do you know Barlow?" "Yes." "Did you see him at Colonel Harney's?" "No, I did not see him, but I saw another gentleman there besides the physicians. I know him. His name is Rupius, and he resides in Louisville." Now, does it not seem a little singular, gentlemen, that this Mr. Rupius, who resides in Louisville, the only person present whose mind was unoccupied, and therefore the only one who could impeach Barlow successfully, was not brought here and placed upon the stand? It is not even a question of veracity between Barlow and Dr. Thompson, for the former is corroborated clearly both by our witness, Dr. Caldwell, and by their own, Professor Yandell. But in cross-examination, the gentlemen triumphantly tell you that they have shown by this witness the evidence of his own infamy. And how? It is true, they asked him if he had not said this to one man, and that to another, and some of the statements he frankly admitted that he had made, yet others he emphatically denied, and they never contradicted him on a single one of the points. And the very men they bring here to impeach him, Mays and Sullivan, testify that within half an hour of this transaction he met them in the workshop, and while he still participated in the excitement, and his most hostile feelings were enlisted against this prisoner, he told them precisely the same story he has sworn to hear. Was there any motive then for him to make false representations? Mrs. Crenshaw, too. You noticed the lady on the stand and saw that truth beamed from every lineament of her fine countenance. Testifies that within 2 hours after, he gave her the same account of it, with the exception she does not remember that he spoke of the scuffle. But we have established the fact that the parties were clenched, and there was a scuffle, so that is immaterial. Mr. Crenshaw proves the same fact in reference to Barlow, that he made the identical statement to him at the same time. And you will remember, too, that this is the very witness who, as they contend, was then so much exasperated against this defendant that he proposed to tear him from the jail by force and lynch him. "Ah, but," says the gentleman, "you are a poor man, a mechanic, and you went to the house of a wealthy gentleman." "Yes, you went, and told him a fact of the utmost interest, one that might save his son from disgrace, from degradation, and perhaps from the gallows. Now is there a single poor man in old Kentucky today, who being in possession of such a fact, and learning its importance, would conceal it, because the fellow being whose fate it might determine chanced to be rich? God save me from a wretch so lost to every sense of propriety, so recreant to every principle of honor. I would sooner trust myself to the tender mercies of a hyena than in his hands. But he played cards in jail with this accused. A mechanic sat down to an innocent social game with a man nominally rich, and therefore he must be perjured. Gentlemen, it is either too late or too early in this community from such a circumstance to conclude that one who has done this must be a toady or a perjured man. All that this man did was, when he learned that a fact of which he possessed might have an important bearing on the guilt or innocence of this prisoner, he went as duty told him, and made it known at once. He stands before you as a man of honor, of integrity, and of credibility, and never in the whole course of my experience have I seen a witness, when an attempt to impeach him was made, so triumphantly sustained and vindicated. The case, gentlemen, is with you. I have endeavored to consider it in all its bearings, so far as my feeble condition would permit. I have only sought to explain fairly both the law and the facts. And now, what are you called upon to do? Will you consign this prisoner, this unfortunate but noble specimen of young manhood, for the fatal deed of a single hour, to a dark and dishonorable grave? Or if not, will you inflict upon him that other but equally terrible punishment? Have you the heart, as he now stands, that fearful insidious disease preying upon him, with one foot on earth and the other trembling on the brink of eternity, to make him an outcast from the world and confine him in a felon's prison? It would be only to lay him on a couch of suffering and disgrace, from which he would never rise again. It would be only to banish him, during the short remnant of his life, from that kind mother who, with anxious care and fondness, has ever watched over him, the pride of her heart and the pledge of her first love, from that gentle, devoted young wife, who is bound to him by ties no less mysterious and vital than those which reunite the Siamese twins, and the parting of which must lay them side by side in one early grave. In the name of that wife, in the name of that mother, in the name of simple justice and of common humanity, I ask you to give him back his life. Mr. Wolfe stated that before the case proceeded further, he desired to call the attention of the court to a fact which had just come under his notice. It would be remembered that the conditions on which the court had furnished reporters with seats within the bar were that no testimony should be published by them until the conclusion of the trial. He held in his hand a copy of a newspaper, whose reporter had accepted the courtesy of the court, thereby giving a tacit promise to regard the injunction, but which, nevertheless, contained a report of the testimony which had been elicited during several days of this investigation. He alluded to the Louisville Courier, and desired to know what action the court would take on the subject. The court remarked that this was the first intimation it had received of the fact, but that it would hold the matter under consideration until the afternoon session. In the meantime, the argument might proceed. Mr. Gibson, for the Commonwealth. Gentlemen of the jury, it has perhaps never been the province of a jury in Kentucky to sit upon a cause of much importance as the one now upon trial. The position of the prisoner in society, the troops of friends that have thronged around him, seemingly determined to rescue him from the consequences of his crime. If human ingenuity, backed by all the appliances that wealth has at command, can effect their purpose. The array of counsel, 18 I believe in number, though only 9 of them are present at court, and among them names long distinguished in the history of this Commonwealth. The host of witnesses on the part of the defense, including a cabinet officer, 2 members of Congress, and a score of names scarcely less distinguished, all called ostensibly to prove a fact not disputed. The previous good character of the prisoner, the widespread celebrity that has been given through the press to the cause itself, and the deep enormity of the offense with which the prisoner stands charged. All these give to this trial an interest, such as perhaps no other trial in the West ever possessed. I feel that I am not merely addressing you, that I have for an audience millions of freemen who are watching with breathless interest the result of this trial, and who will hereafter sit in judgment upon your verdict, whatever it may be. This that the reporters who pens will send to every state and county and town in the whole country, the facts as they have been detailed in evidence before you, and the arguments of counsel to which you have listened, and have yet to listen. The nation will be as well prepared to pass judgment on the case as now you are, and it behoves you, as you value your reputation as men, that you should decide this cause according to the law and the testimony, unaffected by the strong appeals that have been made, and will doubtless hereafter be made to your sympathies, and unawed by the array of wealth and talent and celebrity that has been brought here to fright you from the path of duty. The learned counsel, who has just concluded, is very able, very ingenious, and he will permit me to add in all kindness very sophistical argument in behalf of the prisoner, attempts to account for the appearance of so distinguished an array of counsel by telling us that the prisoner's friends had learned that the cause was to be prosecuted by Mr. Corwin of Ohio and Choate of Massachusetts. I can sympathize deeply with the learned gentleman in being disappointed of that stern joy that warriors feel in foemen worthy of their steel. But in the meantime, we will try at least to give them employment enough to keep their weapons from rusting in the scabbard. You have heard much in the course of this argument about newspaper publications and the excitement under which the public mind of Louisville has been laboring in regard to this case. This has been spoken of as if it was criminal in the peaceful and law-abiding citizens of that city to recoil with horror at the perpetration of such a crime in their midst, as if it was a monstrous outrage that the newspaper should dare to publish the facts as they were proved on the examining trial. But that is all that is pretended to be charged upon them. It would be strange indeed, gentlemen, if such a man as William H.G. Butler could be shot down at the post of duty for no other offense than having faithfully discharged his duty, and while the long line of mourning friends and relatives were bearing him to his grave, while the shrieks of his maniac widow were ringing in their ears, the 70,000 citizens of that city, to most of whom he was personally known as one of the noblest and gentlest of our race, should have remained as calm and unmoved as though it had been a strange dog shot down in the streets. The horror with which the deed was viewed owed not its birth to newspaper publications. Never did the excitement in that city run higher than at the examining trial, amid the crowd which thronged every avenue to the police court, and that was before the publications were made. But that those publications were the truth, and nothing but the truth, you have abundant evidence in the fact that, though the same witnesses were brought here and sworn before you, whose testimony was published in the newspapers, no pretense is made by the defense that they have in the slightest particular deviated here from the statements made there. It only amounts then to this, that the citizens of Louisville have human hearts within their bosoms, that they are not stocks and stones, but men, and that there are at least 2 newspapers there that have independence enough to do that, where a wealthy criminal is concerned, that all newspapers do every day, when any poor friendless wretch steals a horse or passes a counterfeit bill. If it is wrong to publish the details of crime, why has no wise legislator introduced a bill prohibiting such publications? How many voters, think ye, such a law would receive in any legislative body of freemen? Or what man, after voting for it, would ever dare again to look into the honest faces of his constituents? We are told, too, that so fierce had become the excitement in Louisville that this prisoner was forced to come to Hardin County for justice. This is a matter, gentlemen, that I should have considered it improper for me to allude to, if it had not been thrown for effect by Mr. Marshall. Does it not strike you as strange, passing strange, that this young gentleman, who is so endeared to everybody in Louisville by his amiable, gentle, kind, and conciliating disposition, as sworn to by a host of witnesses. This gentleman, with whom, or of whom, Brother Seddon has had such hopeful conversations, is it not strange, I say, that he should have to fly from the spot of his birth, from the home where he was so surrounded by his numerous and wealthy and influential friends, to avoid injustice? But these are considerations that should have no influence with you. Certainly the fact that the neighbors and acquaintances of the prisoner, with whom and among whom he has lived all his life, believe him guilty, and furnish no testimony of his innocence, and yet the information of that fact has been volunteered before you by this council, as though they thought it matter entitled to weight in his favor. With what holy horror they would have raised their hands if we had gravely told you that everybody in Louisville believed the prisoner guilty. It is a consideration, gentlemen, which should have no weight with you in arriving at a conclusion of his guilt. But if it should so influence your minds, he will at least have his own counsel to thank for it. You have already heard something, and will doubtless hear more before the argument closes, about the employment of private prosecutors, and perhaps I had as well disposed of that subject before entering upon the merits of the causes developed in the testimony. It is, however, rather a matter personal to the counsel employed, that one having any legitimate hearing upon the issue which you are sworn to try. As a general rule, I would decline an employment to prosecute. I would certainly never be employed in any case where my convictions of the guilt of the prisoner were not so strong and clear as to leave no shadow of doubt upon my mind. That guilt, too, must be something more than a mere legal guilt, a guilt presenting no extenuating circumstances outside of a legal defense. But on the other hand, there are cases which every consideration of professional pride and duty forbid a lawyer to decline. The circumstances of this case are peculiar. The prisoner is not alone upon trial. The fair name of William H.G. Butler is involved in the issue. Had he done aught to deserve the death he received at the hands of the prisoner? Above all, did he die with a lie upon his lips? A verdict of acquittal in this case must answer these questions in the affirmative, and his surviving relatives would be recreant to his memory if they neglected any means necessary and proper to secure a fair and impartial trial of this case. If it be right for them to employ counsel, it cannot be wrong for counsel to accept the employment. And if from the unheard of array of counsel for the defense, and the untiring efforts of the numerous and wealthy friends of the prisoner, the relatives of his victim have reason, as they conceive they have, to fear that guilt may escape punishment, surely every consideration of duty to the dead, to a stricken widow and helpless babe, would dictate that to some extent these efforts on the part of the prisoner's friends should be met with corresponding efforts on the part of those whose sacred duty it is to guard the memory of him who can no longer protect his own fair name from reproach. Had this have been the brave and manly crime that Mr. Marshall has pronounced it, had the prisoner met the deceased in fair and open fight, warned and armed, I would never have consented to appear in the prosecution. Had he done this, or had he offered him one of the pistols he wore, and thus placed his victim on a footing of equality with himself, he could at least have stood up before a jury of his countrymen and said, I placed my own life upon the issue. I played boldly for the stake, and I won. Murderer though I may be in law, it was no coward deed. Such a man no considerations could induce me to prosecute. But when the assassination has no one redeeming feature about it, either in the causes which led to it, or in the manner of its perpetration, when the victim is an unarmed and unsuspecting man, and then a man, a cripple, deprived even of the ordinary means of defense common to all, and withal, one of the most peaceful, amiable, and gentle of men, when such a man has been so ruthlessly stricken down for having faithfully and honorably discharged his duty, and I am appealed to on behalf of his heartbroken widow and mourning brothers, when even the wail of his helpless babe seems to cry for justice, for its father's blood. I should despise myself if any considerations could for a moment cause me to shrink from what I consider the path of duty. End of section 19. Section 20 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 12. Before entering upon an analysis of the testimony and cause, permit me, gentlemen, to call your attention to a few plain and incontrovertible principles of law, upon which, as I conceive, this case must rest. I lay down these principles under the eye of the court, and shall read you ample authority sustaining them. First, if a man seeks a fight by giving a gross insult or striking a blow to bring it on, and in the fight kills his adversary with a deadly weapon previously prepared, or when his own life is in no danger, he is guilty of murder, no matter who struck the first blow. Second, if a man provokes a fight and in the fight is overmatched and kills his adversary, it will be manslaughter, even if his own life is in danger. Third, unless the defendant had no other means of saving his life or his person from great bodily harm, he has been guilty of manslaughter, even though there is no evidence of premeditated malice. These are the principles which I conceive must govern you in the verdict you will render, after applying them to the facts developed in the testimony. In commenting upon the testimony, I propose to consider it in two aspects. First, the case is confessed on the part of the prisoner and admitted in argument by his counsel. Second, the facts as they are presented by the whole evidence in the cause, as well that of the Commonwealth as that of the defense. I set out then with the assertion that taking the facts just as the defense claimed them to be, in every particular, and applying the law to them, the prisoner is guilty of murder, if you shall think his life was in no danger, and guilty of manslaughter, if his life was in danger at the moment he fired. To sustain this position of law and fact, I assume the facts to be shown from the testimony of the defense, coupled with the testimony of Gilmore, that is not controverted. First, that ill feeling toward the deceased existed in the breast of the prisoner as early as the day before the murder. Second, that in consequence of that ill feeling, and with a view to an anticipated difficulty, the prisoner, within less than 2 hours before he shot the deceased, purchased a pair of pistols, had them loaded at the shop, and carried them with him, concealed, to the place where he met the deceased. Third, that he went there so armed, intending to provoke a fight with Butler, and in that fight to kill his adversary. Fourth, that on meeting Butler in the schoolroom, he did everything that man could do to provoke a fight, and when stricken and unhurt, and before he had tested their relative strength, shot Butler with one of the pistols previously prepared. Fifth, that there existed no necessity for the act at the moment when it was committed. These facts I propose to establish from the evidence produced on the part of the defense, coupled with the uncontroverted testimony of Gilmore. If I should succeed in establishing the whole of the 5 propositions, an application of the law I have read to them pronounces this prisoner guilty of murder. If, however, on the last proposition you should differ with me and believe that his life was in danger, then, the first 4 propositions being true, he is guilty of manslaughter. My first proposition is that ill feeling existed in the bosom of the deceased toward the prisoner, and that the difficulty did not arise upon a sudden quarrel. It is hardly necessary to labor this point. His statements to his father and mother, and his conversation with his brother on the way to the schoolhouse, abundantly established the fact, and if further evidence is wanting, it is conclusively furnished by his conduct and language towards Butler in the schoolroom. Certainly there was nothing said or done by Butler during the interview to call for or account for the abuse and insults which were heaped upon him by the prisoner, and we are forced irresistibly to the conclusion that they were the result of personal ill feeling. If this proposition is not established, then human testimony can establish nothing. My second proposition is that with this feeling rankling in his bosom, and just before he went to the schoolroom, he armed himself with deadly weapons, with a view to the interview. The purchase of the pistols is not disputed, but we are told in explanation of the act that it is customary to carry weapons in Louisville. If the prisoner was going south, and last and strangest of all, that he purchased the smallest pistols in the shop, mere pop guns, as the council call them, playthings fit only for children to amuse themselves with, and that consequently could not have intended them for the fatal purpose they accomplished. Let us examine separately these three different, and, as I shall show, utterly inconsistent explanations. Has a general custom of carrying weapons in Louisville been proved? For the honor and credit of that city, I am proud to say that the reverse has been established. Mr. Prentice tells you that the persons who habitually, mark the word, who habitually carry arms there, are few in number, but that persons expecting a difficulty usually arm themselves. He adds that he has known persons arm themselves without any intention of committing murder, but it would perhaps be difficult for him to explain how he could possibly know with what intention the arms were worn. I submit to you, gentlemen, that the custom as proved, so far from showing that these pistols were not purchased with a view to the use afterwards made of them, furnishes very strong evidence from which to draw just the opposite conclusion. But he was going south. He was to be a traveler on steamboats, exposed to robbers. He was going to Arkansas, somewhat celebrated in times past for deeds of daring violence and desperate combats. But let me ask you, if such a pistol as that exhibited in evidence is the weapon a man would select to defend himself from the bowie knife or the revolver of a desperado, of what use would it be in a street fight? The best shot in the state could not be certain of hitting a man with it at 6 feet distance. No, gentlemen, it is fit for no such use. It was purchased for no such use. It is emphatically an assassin's weapon, easily concealed. It is fit only for the purpose to which it was applied in this case, to be placed against the breast of an unsuspecting man, and fired with deadly effect, but with an utter recklessness of all consistency. Counsel tells us that this weapon, that they said he had purchased to defend himself amid the dangers of southern travel, and from the bears and panthers of Arkansas, is utterly inefficient, a mere plaything, a pop gun that never was meant to execute any deadly purpose. If he thought it so harmless, why did he buy it? If he deemed it not deadly enough to slay the peaceful cripple in his schoolroom, could he at the same time think it sufficient to defend him against the armed desperado or the midnight robber? Their own arguments recoil upon them. The peaceable and quiet disposition of the prisoner, the fact that it is only usual to carry weapons in Louisville when a difficulty is expected, the nature of the weapon itself, just suited to the use made of it, and useless for all other purposes, all prove that the weapons were purchased to kill Butler with, and for no other purpose. But there are other facts connected with the purchase worthy of being noticed in this connection. He purchased no ammunition. If he had bought the pistols to take south with him, he would have needed powder, ball, and caps, as much as he needed the weapons themselves. There is no man of his age and intelligence in the West who does not know that a pistol, to be at all reliable, must be discharged and reloaded at least once in every 10 or 12 days. But he purchased no ammunition. He did not need it for the purpose he had in view. He first buys one pistol and has it loaded. When he takes out the money to pay for it, he pauses, hesitates, and inquires the price of the pair. Can you read his thoughts, gentlemen, during that moment of deliberation? He had prepared himself for Butler, but Bob was not yet back from Cincinnati with his bowie knife. Perhaps Sturgis might be there, or some of those little boys, roused at the sight of their beloved teacher's blood, might become dangerous. He might have to shoot little Purtle or Benedict. And so the second pistol was purchased and loaded. And so armed he starts upon his mission of blood. There is no reason for a shadow of doubt on this point. The pistols were bought with a view to the intended interview with Butler, and for no other purpose. Thus far, our way is clear. Ill feeling towards the deceased exists. An interview is expected, and the pistols were bought and loaded with a view to the interview. I come now to the third proposition that I seek to establish, that the prisoner sought the deceased with deadly weapons concealed upon his person, intending to provoke a fight, and in such fight kill his adversary. To prove this, I call to the stand the father, the mother, and the brother, an accomplice of the prisoner, their own witnesses sworn by them, and whose testimony they will not dispute, that the prisoner sought the deceased, and that he wore deadly weapons concealed upon his person, is not controverted by his counsel. Did he expect a difficulty, and did he intend to provoke it? Why say to his father, I am a young man, and it is proper that I should go. If he did not expect a difficulty, why those admonitions of his mother to be calm? Why did he say to his brother as they went to the schoolroom, don't interfere by word or action unless they both attack us? There is but one answer to all these questions. He went there expecting a difficulty. Suppose a stranger had been walking behind them on the street and heard their remark, what would he have inferred? Most certainly that the speaker was expecting an attack. The preparations that he had made, his conversation with his father, the injunctions of his mother, and his own conversations on the way, are of themselves sufficient to establish the fact. But if to them we add the ill feeling he entertained toward the deceased, and the whole scope of his words and manner after he entered the schoolroom, the evidence becomes wholly irresistible. But did he intend to provoke the difficulty himself? I say there is nothing clearer from the testimony than that such were his intentions. He had enmity toward Butler, but there is no pretense that Butler cherished any unkind feelings towards him. Then he had a motive to provoke the fight. Butler had none, and men never act without motives. Butler was a just man and a gentleman, the prisoner himself said to his father. Surely he could not expect an attack from such a man unless he provoked it. But I have shown that he did expect an attack, and therefore he must have intended to provoke. Men's intentions can only be safely judged of by their actions, and judging the prisoner's intentions on this head by his actions after he entered the schoolroom, no doubt can exist in any rational mind that he went to the schoolroom armed with weapons prepared for the difficulty he was intending to bring on. But did he intend killing his adversary? For what other purpose was the pistol purchased? Did he intend to frighten Butler with his weapons? If so, why hide them till the very moment of their use? Did he intend only to wound or cripple him? If so, why aim at his heart? Were they purchased to be used only as a last resort, when all other means of escape or defense had failed? No, for he used them at the very outset of the encounter, before he was himself more injured than he might have been by the rubbing of a coarse towel, according to one of his own witnesses, and before he had tested the relative strength of himself and his victim. Did he intend to fight Butler a fair fight? Were his intentions changed after he found himself engaged? If so, why had he the pistols there? And knowing he was not the equal of Butler in strength, why tell Bob not to interfere if he did not intend to use his pistols? It is likely that he went there intending to take a whipping from Butler. Certainly not. But he knew Butler could whip him, and yet he directs Bob not to interfere. The inference is irresistible that he intended to do just what he did do, shoot down his victim the very moment the difficulty provoked by himself commenced. Have I not thus far, gentlemen, truly represented the facts, and are not the conclusions I have drawn from them clear and unassailable? The existence of the grudge, the preparation to avenge it, the going to seek the victim armed with deadly weapons, the intention to provoke a difficulty, and in the melee to kill his adversary are, it seems to me, as clearly deducible from the facts proved by the defense themselves as intentions ever can be deducible from deeds. My fourth proposition is that on meeting Butler in the schoolroom, Ward did everything that man could do to provoke a fight, and when by his goading insults he had succeeded in so doing, while yet unhurt himself, and in no danger of life, or even bodily harm, he shot his adversary. And bear in mind, gentlemen, that I am now looking only to the prisoner's own testimony to support me in the positions I am endeavoring to establish. What says the prisoner on entering the room? Bob being the witness. I want to have some private conversation with you. Was the public schoolroom, in the presence of 40 boys, an appropriate place for private conversation? No, and Mr. Butler promptly requested him to walk into his private room. This Ward refused to do, and proceeded in the presence of the whole school to ask a question which was in itself an insult. Mr. Butler declines being interrogated. The question is repeated in a still more insulting form, which is the meanest, the contemptible pup who begged chestnuts of my brother, and then lied about it, or my brother who gave them to him. Mr. Butler answers, there is no such boy in my school. Can a milder and at the same time more appropriate answer be conceived? Then comes the next question, or rather demand. You have called my brother a liar, and must apologize. Must. Was Butler a slave that Ward should address him in the language of a master? Is life so dear that it is worth purchasing at the price of submission to an imperious demand like this? And who is the prisoner at the bar, that he should thus lord it over one his equal in everything but wealth? Were William Butler brother of mine, I would rather, 1,000 times rather, that he was sleeping in his bloody grave, with no stain upon his fair name, than have him living and dishonored by submission, such as was demanded of him there. He gave the only answer he could give without dishonor. I have no apology to make. Now, mark the deliberation which indicates a settled malice. Then you must hear what I have to say to you. You are a damned scoundrel and a coward. Did man ever use such language in Kentucky and not expect to be struck? Did Ward not expect it? Had he not prepared himself for that moment? Bob says he was struck twice and pushed back against the door, which same door, he admits a moment afterward, was open. And then the deed was done. A widow and an orphan was made. A young man in the first flush of manhood, just entering upon life's battle, with all life's hopes before him, was shot down like a dog, without the remotest chance being given him to defend his life. 2 pistols in the assassin's hands, and if by a miracle he should be able to escape them and get the better of his antagonist, there stood the brother, with a murderous bowie knife, ready to stab him in the back if necessary. He had no chance. None, none, none. Their plans were too well laid, too coolly carried out, to leave him the shadow of a chance for life. I have, I think, thus shown that he carried out, coolly and deliberately, the intentions with which he came to the schoolroom, that he deliberately provoked the encounter, and as deliberately shot his antagonist as soon as the affray commenced, without waiting till he was overpowered. I come now to the last point which I propose to establish, and upon which, turns the question whether he is guilty of murder or manslaughter. If he was in danger of life or great bodily harm at the moment of firing, he is guilty only of manslaughter, notwithstanding he provoked the difficulty. If no such danger existed, he is guilty of murder. Was he in danger of his life, or even of great bodily harm? Butler had no weapon with which to inflict either, and well the prisoner knew it. It was not his brother at hand to interfere and save him. No, gentlemen, he was in no danger, and no man knew that better than he did himself. He knew Butler's nature well, knew him to be a man who would not needlessly set his foot upon a worm. What marks of violence upon his person attest the force of the blows he had received? Was it the towel mark upon his cheek, that no witness ever saw or noticed until it was pointed out to him by the prisoner? If it was the effect of a blow, it must have been such a blow as a lover would inflict upon his lady-love with a rose. Look at that skin, more fair and delicate and effeminate than that of half the females of the country, and tell me then, if it could possibly have been more than a mere touch that produced an effect so slight. But his mother tells us his eye was watering. Let us in charity, gentlemen, hope that he was shedding a single tear over the writhing and anguished victim he had just left weltering in his blood. That one thought of the happy little home he had broke up forever, one half-formed regret for the widowed heart and orphaned babe his hand had just made, was struggling for existence in his heart, even while enjoying his proud triumph of having slain an unarmed and defenseless cripple without having incurred the slightest danger himself. Danger? He was in no more danger than if he had lain behind a log in the woods and shot his victim in the back as he passed, and he knew it. And if there was no danger, then the deed is murder, cold-blooded, deliberate, calculating, safe murder. I have thus shown you, gentlemen, from the confessed case on the part of the prisoner, from the very facts set up by the defense themselves, that ill feeling existed in the breast of the prisoner toward the deceased, that intending to have a hostile interview with the deceased, he armed himself with deadly weapons, procured for the particular occasion, that so armed he went to the schoolroom of the deceased, intending to provoke a fight, and in the fight to shoot his victim, that he carried out with marked deliberation the intention thus formed, that he did provoke a fight, and, as soon as it was commenced, before he was worsted or overpowered, before he had tested the relative strength of himself and his adversary, and when he was in no danger, his armed brother near, and no other enemy in sight, he shot the man who he went there determined to shoot, in the event he would not submit to be disgraced in the presence of his whole school. Apply the law as I have read it to you, to these facts, and if you are honest men, understanding the value of the oath you have taken, his guilt will be as clear to your minds as though God's own hand had written upon his brow the verdict that he stamped on Cain's. I have thus far, gentlemen, kept out of view the evidence on the part of the Commonwealth. I have taken the case just as the defense claim it to exist, and I think I have shown you that the prisoner stands before you guilty by confession. End of section 20. Section 21 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 13. Let us now look at the overwhelming mass of testimony on the part of the Commonwealth. Testimony that sweeps away even the broken reeds upon which the defense has sought to lean, and exhibits this crime in naked deformity before you. Before entering upon an analysis of the evidence adduced on the part of the Commonwealth, Let us for a moment glance at the nature, character, and position of the witnesses by whom we have proved our case. They are boys, honest, manly, open-hearted boys, whose countenances alone would win them credit in a land of strangers. Boys old enough to see and understand and remember facts, but too young to have been contaminated by intercourse with the world, too honest to speak falsehood, too guileless to conceal the truth. No traces of concert in their stories, and yet no contradictions. The man who would doubt their truth under all the circumstances ought to be forbidden by law ever to be a father. Look, gentlemen, upon this map, exhibiting a diagram, and note the position of each boy, and compare it with the story that he tells, and you will perceive that each one saw just what he might have been expected to see from his position, and that not one of them relates any part of the transaction that he could not have seen, situated as he was relatively to the parties. You have been told by learned counsel, however, that it is something very strange that some of the boys nearest to the parties did not hear the conversation, while others farther off detail it at length. I can see nothing in this, gentlemen, not easily explained by the ordinary everyday experience of our lives. Did you never sit with a book or a newspaper in your hand while conversation was going on around you, so that though you heard the sound, you heeded not the sense of what you heard? Have you never gone to church when you heard something that was anxiously occupying your mind, and sat the sermon through, and when you went home, had no more remembrance of text or sermon than if you had been asleep in the woods? These boys were engaged on their various tasks, some reading, some ciphering, some writing, and it is one of the circumstances that stamps their evidence with the unmistakable marks of truth, that, while some heard the whole conversation, some heard only detached sentences, and others none of it. There is yet no contradiction among them in any essential particular. Their evidence is in accordance with the nature of their position and the pursuits they were engaged in for the moment, and for that reason, if no other existed, it would be entitled to your fullest confidence. Never, perhaps, did attempts to impeach witnesses encounter more signal failure. So hopelessly has it failed, that counsel, with a boldness and in a better cause, would be worthy of admiration, now deny that they have attempted to impeach them at all. I will never complain of attempts to impeach a witness, where any ground exists to base the attempt upon. But to attempt to confuse a witness by intimating to him that he has told a different story out of court, and asking if he had not told this or that man such a story, when the counsel know that they have no evidence that he has, would be a most unfair course toward a man of good character. It certainly acquires no additional merit from being practiced on boys. Do you not remember that young Knight was asked if he had not told Dr. Caspari a different story from the one he told here upon the witness stand? The counsel was asked the question, must have known whether Dr. Caspari would swear that he had, and yet, when Caspari was on the stand afterward as their witness, they never mentioned Knight's name to him. So they asked Worthington if he had not told his mother something different from his statement here. He denies it, and yet they do not attempt to contradict him. They asked Minor Pope if he had not made a different statement at the examining trial. They knew that he had not, for the minutes of that examination were before them when they asked the question, and if he had done so, they would have proved it before they closed their case. Again, they attempt to impeach Benedict by some man whose name I can't pronounce, who tells you in a kind of oracular style that if he once sees and speaks to a man, he never forgets him, and in the next breath admits that he cannot recognize a single one of the boys he saw at the door. He tells you he met a boy in the street crying, and going up Chestnut Street, who said Butler struck first, and that he thinks he has seen the boy here, with a black roundabout and white hat on. Benedict was brought in, and he says he thinks he is the boy. But Benedict has no black roundabout on, and has not had one on since he has been here. Besides, Benedict went down Chestnut Street, and could not possibly have been the boy this witness met. They asked Worthington if he did not tell Mr. Allen at the schoolhouse door that Butler struck first. He says he has no recollection of seeing Allen there, and is very sure he never made such a statement. They call Mr. Allen to the stand, a very cautious and honest witness, with the air and manners of a gentleman. And what does he say? That he went to the door and shook hands with Worthington, that he asked if Butler had gone. The boys said he had, that he then asked the particulars, and received diverse statements from different boys, and that to some one of the answers to some one of the questions given by the other boys, he thinks Worthington nodded assent, but to what answer it was he is utterly unable to tell. So much for the attempt to impeach Worthington. It needs no comment. And little Purtle, with his honest, open, manly countenance, with truth written all over it, could not escape them. They bring a little boy named Jute, who says Purtle told him that Butler struck first. Now Purtle has never pretended to know anything about the striking, for he was not looking at them, and if he ever did say anything to Jute about it, he was only telling what he had heard. But Purtle says he never told Jute so, and I am satisfied that the little boy, Jute, is mistaken, and has confounded some of the numerous conversations he has most likely had with other boys on the subject, and has erroneously got the impression that it was Purtle who told him so. And yet, after all these efforts, gentlemen tell us they are not attempting to impeach the boys, and affect the virtuous indignation that we should defend those whom they say are not attacked. If they say they have not impeached them, I most cordially concur with them. But when they deny the attempt, they will pardon me if I differ in opinion with them as to what constitutes an attempt to impeach a witness. But the testimony of the boys stands not alone. It is corroborated by the dying declarations of the victim. Butler himself, standing upon the very portals of the grave, knowing that in a few short hours he must stand in the presence of his God, when all earthly hope had deserted him. Hope, man's earliest, last, and truest friend. Hope, that gilds the darkest cloud that lowers upon life's future, that lights up the gloomiest path that humanity is destined to tread, that stands by our cradle in infancy, plays with us in boyhood, sustains us in the stern conflicts of manhood, sits with us by the fireside through the wintry hours of age, and when life's battle is over, gilds even the grave with its glorious sunlight. Hope had deserted him. All earthly feelings were dead within that fainting heart. All, no, not all, not all. Love, undying love, immortal as the soul itself, still lived and reigned supreme. No thought of himself, no expression of the deep agony that was writhing his frame, no word of anger or reproach for his slayer. My poor wife, my poor child. Those words, at such a moment, speak the character of the man, and language more impressive and convincing than would have been the testimony of an entire cabinet and Congress. Can it be possible that such a man, at such a moment, with no motive to falsehood, could have spoken untruly? Will you give the weight of a feather to the testimony of 1,000 such witnesses as Bob Ward, swearing the halter from around his own neck, and contradicted by a host of other witnesses? Will you weigh it all against the declaration of that dying man? You will not. You cannot. You dare not. If you have human hearts within your bosoms, they would revolt at the bare thought of such treason to humanity. If you are men, living, breathing men, with souls to be saved or damned, reasoning like other men, you will be forced to believe the statements made by Butler, whether you will or no. You cannot doubt their truth. Let us, then, calmly and dispassionately examine the testimony as to those statements and compare and analyze it and see if we can arrive at a certain conclusion as to what the statement really was. Dr. Thompson says, and I give his statement in his own language from my notes. I asked him what their position was. He said they were clinched, that they had had some conversation, that Ward called him a damn scoundrel and struck him, and he struck back, and he received a shot, but did not see who shot him. Yandell and Caldwell were both present at the time the declaration was made, but neither of them seemed to have any very definite recollection of the language used by Butler. Thompson asked the question, and it is natural to suppose he would remember the answer. The other two were engaged in an examination of the wound, with their thoughts directed to it, and not to the conversation of the patient. It is natural that they should have no connected recollection of it, and such we find to be the case. Dr. Thompson, the man most likely to remember it distinctly, does so remember it. Yandell and Caldwell, who are not likely to have a clear and distinct memory of the words, or even of their general import, tell you themselves that they have not. Caldwell tells you he cannot give the words Butler used, that the idea he expressed was that he and Ward were engaged at the moment of the shot. This is certainly in exact accordance with Thompson's statement. He tells you further that Butler said he did not see who shot him. Thus, both Thompson and Caldwell contradict Barlow, who says Butler said that Ward threw his hand around and shot him. Yandell says that Butler said that Ward raised his hand and commenced an attack or something like that. He could not say positively what. Just such a recollection as might be impressed upon an inattentive listener by the very language that Thompson has detailed. And not only is there no conflict between the physicians, but Thompson is most clearly confirmed by the other two, to the extent that their recollection goes. But Barlow, they say, contradicts them, and at the same time is confirmed by them all. Very kind indeed in Doctors Thompson, Yandell, and Caldwell to confirm Barlow, at the same time that Barlow is contradicting them. And to most men the two things would seem rather inconsistent, not to say impossible. But according to Barlow's own showing, neither Yandell nor Caldwell were in the room. Can you believe, then, on Barlow's evidence, that the dying Butler made two different and contradictory statements about the transaction within 5 minutes of each other? Yet you are forced to believe it if you do not reject Barlow's testimony altogether. I have no desire to rake this man up from the depths of infamy to which the scathing analysis of his testimony by my associate counsel has consigned him. Nor should I have alluded to him but for the bold assertion of my friend, Governor Helmer, that he had been confirmed by Yandell and Caldwell. I will try, and if possible, avoid even the mention of his name hereafter. Let the dead rest. But we are told by counsel that Butler's declaration contradicts the boys, that Butler admits that he did strike Ward after being himself stricken, while not one of the boys remember anything of the kind. As much stress has been laid upon this point by the counsel who preceded me, it may perhaps be worthy of a moment's examination here. My belief is that the laying his right hand on Ward's shoulder is the act which Butler spoke of as a blow. To some extent it may be regarded as a blow, though given with the open hand. It would perhaps be very difficult to define the exact boundaries between a push and a blow, and I think the fair inference is that Butler has designated as a blow the same act that the boys has described in other language. But suppose I am mistaken in this. What more natural and easy than that the boys might see the first blow, and yet fail utterly to see who struck the second? If you ever witnessed a fight, and I think I may safely take it for granted that you have, you know well that it is easy for you to remember everything up to the first blow. But after that, everything is confused, and no man can keep the run of the fight. The astonishment of the boys at seeing their teacher stricken would naturally confuse and alarm them, and it is perfectly natural that they should not have observed the events that followed close upon the heels of that blow. This leads me naturally to another point made by the defense. Counsel tells us that these boys were too much alarmed and excited to notice accurately and remember correctly the occurrences they witnessed. When did that excitement and alarm begin? Not until the shot was fired. Up to that moment, they were neither alarmed or excited. There had been nothing to alarm, nothing to excite them, and all their testimony having any bearing upon the case relates to facts occurring before the shot, when they were entirely cool and collected, so much so that some of them paid no attention to the conversation till the words damned liar and scoundrel attracted their attention. This ground of objection, then, to the reliability of their testimony has no foundation in the facts of the case. We know that alarm and excitement renders us less likely to be accurate observers of events, but it never wipes out the memory of facts observed and noted in cooler and calmer moments. It accounts for Worthington's not remembering to have seen Allen come to the door. It might account for many discrepancies and contradictions occurring in the testimony as to the facts after the shooting, if any such discrepancies existed. But it cannot throw any cloud of doubt upon the relation of events that occurred in their presence, and before either alarm or excitement had disturbed their minds. Having thus briefly disposed of the attempts made to impeach the testimony of the boys, let us see what facts are proven, who proved by, and what opportunity the witness who proves the fact had of witnessing what he swears to. When the Wards entered, Matt said to Butler, "I have a matter to settle with you." This is proved by Knight, Pope, Campbell, Crawford, and Redding, and in it they contradict Bob. Well, not one of the boys gives the same statement about it that Bob does. This, I suppose, is one of the points in which counsel say that Bob is confirmed by the other boys, a strange sort of confirmation. The next thing that Ward said was the question relative to the chestnuts. This is proved by every boy who heard anything of the conversation. They all agree that it was asked but once, and that the word contemptible was used. Bob says it was asked twice, and denies that the word contemptible was used. This, I suppose, is another confirmation. Butler, in reply to the question, said if Ward would go into his room with him, he would give him a satisfactory explanation. Worthington, Pirtle, Pope, Crawford, and Redding all swear to this. Bob says that the answer was, "There is no such boy in my school." Another confirmation of Bob, I suppose, though not another soul in the house but himself heard any such words. And here let me pause to make a single remark. From the first opening of the testimony, the defense seemed extremely anxious to establish that there were no boys in Butler's room. We of the prosecution were somewhat mystified by this. We could not imagine what conclusion they proposed to draw from it, if it should prove to be so, unless that they would gravely ask you to believe that Butler wanted to lure the Wards in there and murder them both. But Mr. Marshall clears up the mystery. He says that if the prisoner had gone to the schoolroom intending to murder Butler, then he would have accepted his invitation and done the deed in the privacy of that room, where there were none to bear witness against him. Unfortunately for this very novel position, the facts show that there was a class in the room. Besides, we do not contend or believe that Ward went there with the fixed design of murdering Butler at all events. His fixed purpose was that Butler should either degrade himself by making a cowardly apology at his imperious command, or, refusing to do this, that he, Ward, would insult and strike him. If he bore all this without resentment in the presence of his school, then he would leave him a life no longer worth preserving. If he dared to resent either insult or blow, then his purpose was to slay him. That is the view we take of his intentions, and his refusal to go into the room is at once accounted for The whole school would not be witness of their teacher's degradation. All the boys testified that Ward refused to go into the room, and Worthington swears he said he did not come for an explanation. I come now to a most important fact. Knight, Benedict, Pope, and Crawford all swear that Ward had his right hand in his pocket when he entered the room, and kept it there till he drew the pistol and fired. Another confirmation of Bob you will perceive, who swears he did not have it in his pocket, either when he came in or during the conversation. Look now, gentlemen, at the positions on the diagram of these four boys, and you will see that each one of them could have readily seen the fact he testifies to. Knight noticed it from the window in Sturgis's room as he entered the gate, and having been, as he tells you, told by young Victor Ward that Matt was coming around to give Butler hell, he hastened into the large room and saw the prisoner enter with his hand still in his pocket. But we are told that it is very unlikely that these boys should have noticed the position of his hands. I cannot see it in that light. The position of his hands was an extraordinary one, his coat drawn up to let his hand in his pocket, and it kept there all the time of the conversation, was an incident likely to attract the attention of anyone. If we add to this the fact that the boys, from their knowledge of what Victor had said, from the fact that half an hour before a servant had been sent for Victor and his books, and from all the attendant circumstances, we're expecting a difficulty. You will perceive that there is nothing extraordinary in their having noticed the position of the prisoner's right hand on entering the room. But to return to the order of events from which I have digressed, to notice this fact relative to the position of the prisoner's right hand. I have shown that the prisoner entered, his right hand in his pocket, that his first words were, "I have a matter to settle with you," and followed it up by an insulting question, that he was invited by Butler to walk into a private room to listen to an explanation, but declined, saying he did not come for an explanation. I now proceed with events in their order. The next question propounded by the prisoner was, "Why did you call my brother a liar?" This is proved by Knight, Worthington, Pope, and Crawford. Bob states it entirely different, which is confirmation number 5, I believe. Worthington proves Butler's reply. I cannot answer unless I am allowed to explain. But these gentlemen who say they have made no attempt to impeach these boys say that it is very strange indeed that Worthington should have heard so much of the conversation while he was so far off, and that others who were nearer did not hear it. And by way of making it still stranger, they very coolly doubled the distance at which he really was. Mr. Marshall tells you that he was 40 feet distant. Look at the diagram, gentlemen. Just 7 benches separated him from the parties, and these benches are 3 feet apart. He was not at the utmost more than 25 feet distant, certainly near enough to have heard even low tones of conversation. If he was paying attention, well, those who were nearer, though they doubtless heard, he did not, and consequently do not remember. He swears positively that he both heard and noticed. Gentlemen say they do not mean to impeach his veracity, and therefore, of course, they must believe him. And when this mild, too mild by far, answer was given, what next? "You are a damned liar and scoundrel." This is proved by Knight, Campbell, and Redding. Bob, not willing to agree with anybody about anything, substitutes the word coward instead of scoundrel. That this insulting language was immediately followed by a blow is proved by Knight and by the dying declarations of Butler. That there was a scuffle and that Butler had his crippled hand on Ward's shoulder when he was shot, and that he was some 4 or 5 feet from the door at the time, is conclusively proved by Knight, Purtle, Crawford, Benedict, and Quigley. It is true that Quigley at first said Ward was pushed back to, or towards the door, but he afterwards stated that he did not see Butler step forward, and that Ward only stepped back 1 step, and was 4 or 5 feet from the door when he shot. And here comes in another fact, proved only by Crawford, who was the only witness in a fair position to notice it. When Butler had his right hand on Ward's shoulder, he was grasping with his left for Ward's right hand. Look at the map again, gentlemen, and you will at once perceive why it was this incident was not noticed by any of the other boys. Crawford was just in the position to observe it. The others were not. But we are told that this is inconsistent with Butler's statement, that he did not see who shot him. I suppose, then, that gentleman abandoned Barlow to his fate, for Barlow says Butler did see who shot him. I hope they will permit me to congratulate them upon having buried their dead out of their sight. But there is no inconsistency. Butler may have seen his hand in his pocket, and suspecting that it grasped a weapon may have, and doubtless did, try to grasp his arm, and yet not have seen the weapon when it was drawn. He did not see it. He said he did not, and I would believe William Butler's dying words, though an angel should contradict them. I have thus gone through with events in their order, up to the commission of the fatal deed. I have shown the malicious intentions with which the prisoner visited the schoolroom, his refusal to listen to all explanation, the insult followed by a blow, and when that was resented by a push with the open hand, for it was nothing more, the cold-blooded, planned, and calculated murder of Butler. End of section 21. Section 22 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 14. Let us now, gentlemen, look at some other facts. When the fatal shot was fired, when his victim was writhing in anguish upon the floor before him, his dying thoughts wandering far away to the loved wife and the little one at home. What next? Any expression of regret from the prisoner? Any indication of that remorse that would have rolled like an avalanche over his soul if the act had been unpremeditated and sudden? None, none, none. He coolly drew another pistol and points at the boys, prepared to shoot little Purtle, or Benedict, if they should approach too near, I suppose, while Bob, drawing his bowie knife, walks up the aisle, menacing the little boys at their seats. He denies this, but it is proven by Knight, Johnson, and Benedict. If no other evidence of premeditation were to be found in this case, it seems to me that the prisoner's conduct the moment after he fired, the absence of all expression of regret or sorrow, together with the conduct of his brother and accomplice, furnished the strongest indications that the act had been coolly planned, and the plan deliberately executed. I have now gone over the testimony in the two aspects in which I propose to consider it. I have first taken the case as confessed by the defense, placed it upon their own testimony, and I think shown most clearly the guilt of the prisoner of murder, or at the very least of manslaughter. Then passing to the testimony of the Commonwealth, I have, by such an array of unimpeached and unimpeachable testimony, as can but seldom be brought to establish any case in court, proved most conclusively the malice, the preparation to kill, and the killing without excuse or palliation, and in pursuance of previously formed intentions. For such a deed, the law has but one name, and that name is murder. And to meet this array of testimony, to break the links of the chain that binds this prisoner and this crime together, what facts outside of the current of events have been put in proof by the defense? The attempt to prove a custom of wearing arms in Louisville, I have already noticed. Instead of rebutting the presumptions arising from the fact of his purchasing the pistols, the limited custom, as proved, only adds to their strength. Another fact from which the counsel, in the utter dearth of every reasonable ground of defense, tried to argue a doubt as to the malice is that the prisoner was making preparations to go south with his family. I do not question the fact, but for my life I cannot see how it breaks the force of the presumptions as to the prisoner's intentions, deducible from his words and acts. The intention to go to Arkansas was formed before the malice had its birth. Is it likely he would go around and tell his friends, I am going to kill Butler, and therefore I must give up my trip to Arkansas? Whatever else he may be, the prisoner is not a fool. Does anyone suppose that he killed Butler with the intention of going to jail, or with the expectation that bail would be refused? It never occurred to him that his trip to Arkansas would be interrupted for only killing a schoolmaster. That, as I have said before, his determination to kill was only a contingent one, and he doubtless supposed that Butler would abase himself before him, though he was prepared to slay him if he did not. These considerations, it appears to me, deprive the fact of his intended journey to Arkansas of all importance in the cause. But we are told that there existed great disparity of strength between the prisoner and the deceased, and if one, who had not heard the evidence, should listen to the learned counsel on this point, they would certainly come to the conclusion that Butler was a modern Hercules. Strip it of all the ornaments with which gentlemen's imagination have enveloped this branch of the testimony, and what does it amount to? Butler was a young man of fair strength, weighing 130 pounds or thereabouts, with the right hand so crippled that he could neither close nor open it. Accustomed to gymnastic exercises, he had acquired that sleight which indicates practice, not strength, and could do things with his arms which the witness Joyce could not do, he being, as he tells you, uncommonly weak in the arms. Does this show that great disparity of strength that would place Ward in danger of life or limb from a conflict with Butler? The assertion is too absurd for argument. It is but a straw caught at by a drowning man. But the whipping, the terrible whipping. Mr. Marshall grew frantic over it, and Governor Helm, after devoting half an hour to it in the morning, came back again to it after dinner with renewed appetite. And all this about a fact that is not in testimony, that you only hear of through a double hearsay. Matt Ward's telling his mother what the boy Will had told him. The court admitted the testimony for the purpose, not of proving that there had been a whipping, but of showing the motive which Matt said actuated him in going to the schoolhouse. And yet counsel argued before you as if it were a proved fact that the boy had been whipped. You will remember, gentlemen, that when we offered to prove all about the whipping, we were stopped by the court. We were prepared to prove by the most abundant testimony that the boy had violated the rules of the school, and then denied the fact, and that for this double offense he was punished by a few light blows with a small leather strap. But, as I have before remarked, this testimony was excluded by the court, upon the ground that it had nothing to do with the case, and yet a large portion of the time of the two gentlemen who have spoken for the defense has been devoted to this fact, a fact not proved before you, and having no bearing upon the case if it was even in evidence. It proves neither justification, excuse, or palliation for the act, in law or morals, in this land or in any other land, where law reigns or order has any pretensions to existence. Possibly in the unwritten code of the Comanches, some precedent for such a defense might be found, but nowhere else. An attempt was made to get in testimony that there was an agreement not to whip the Ward boys. We were prepared to prove the contrary had it been necessary. Gentlemen well knew the testimony to be inadmissible, but they expected the offer of it to have its effect upon you. It was just about as much to do with the case as the book written by the prisoner, which Mr. Marshall flourished before you, and even threatened to read to you, that you might, as he had done, travel in fancy with the prisoner from the Danube to Mount Sinai. It is greatly to be regretted, gentlemen, that amid all the pious associations called up by a visit to that consecrated spot, the prisoner had not remembered at least one of the commands there given by God to man. Thou shalt not kill. If our young men are sent abroad to visit this spot, where the 10 Commandments were first promulgated, only that they may come home prepared to sin through the whole Decalogue in regular order, I can only echo the wish once expressed by Jefferson. Would that the Atlantic were a broad impassable gulf of fire. I come now to the great sheet anchor of the defense, moored to which they hope safely to ride out the storm. Character, character, character. Nothing but character. As though the history of our race was not darkened with the crimes of saints and model men. As though the most common conclusion to an account of a desperate murder nowadays was not the stereotyped announcement that the perpetrator had hitherto borne a most amiable character. Byron, the greatest judge of the human heart since Shakespeare, describes a remorseless pirate as being as mild a mannered man as ever scuttled ship or cut a throat. And in a note says that Ali Pasha was the mildest mannered man he ever knew. In such a case as this, gentleman, character is not entitled to the slightest consideration. Where the evidence is circumstantial, and the prisoner denies that he did the deed at all, their good character may come in to give preponderance in favor of the prisoner. But here, the case is proved by his own brother, as confessed by the defense, shows that his life has been one long scene of hypocrisy, got up to deceive his friends into the belief that he was kind, and gentle, and amiable. The gross insult offered by him to the deceased is fully as inconsistent with his character, as proved here, as would be deliberate murder itself. Mark the argument, gentlemen, for I do not wish to labor it. The proof of character, if it proves anything, would prove that he could not have acted and talked as Bob says, and as his counsel admit he did. But as in proving that, it proves too much. It proves nothing. We have been asked in triumph by Mr. Marshall, did ever man prove such a character before? Has he forgotten the story of Eugene Aram and his crime, upon which Bulwer's celebrated novel was founded? Is not the recollection of the trial and execution of Professor Webster of Boston yet fresh in the minds of every reading man? And Colt of New York, who cheated the gallows by committing suicide in prison? Did not each of these men show by testimony an unexceptionable character? And yet they were guilty. They too, with all the dark and sinister passions necessary to make a murderer, rankling in their bosoms, had through life managed to conceal from their friends their true character. For 60 long years had Webster borne concealed in his bosom the sentiments and feelings and instincts of a murderer, and his most intimate friends had never dreamed of it, till the occasion called them into action. The character and the opportunities of the prisoner has had, the want of all inducement to crime, born and raised in the lap of luxury and wealth, no wish ungratified, no desire unsated, no means of improvement spared. These but add, if it were possible, a deeper shade to his crime. Surely better things might have been expected of him, had it been some gaunt child of poverty and crime, born and reared amid the purlieus of 5 Points, taught vice and crime from his cradle, reared in ignorance, and taught from boyhood that his life was to be one long war with his species. Had such a one committed the crime, there might have been some palliation for him, and yet you would have hung him with as little hesitation as you would shoot an ownerless dog that had killed your sheep. Whatever you may do with the prisoner, you know you would have hung a poor friendless, homeless devil, such as I have described. No long array of the great and wealthy of the land would have crowded around him to shield him from the consequences of his crime. No 18 lawyers would have been found pleading for him. And yet, his mind early warped to wrong, his fearful temptations, his Ishmaelitish fate, all these would plead trumpet-tongued for mercy. But this prisoner cannot even urge in palliation the infirmities of his temper, for his counsel have taken care to prove that he was so gentle and amiable that it is utterly impossible he could ever have got in a passion with anyone or at anyone. I have now, gentlemen, gone over the testimony in the order proposed. I have first placed the case upon the prisoner's own testimony, and shown you that he stands before you a murderer by confession. I have next reduced to order, and placed before you the evidence on the part of the Commonwealth, placing events in the order of their occurrence, and adducing the testimony by which each event was proved, until the weight of proof is strong and clear and convincing enough to convict the holiest angel that ministers at God's right hand, were he on trial. With such testimony before you, with the memory of your oath that is registered in heaven, and the sense that you must feel of your obligations to society, you cannot say that the prisoner is guiltless, unless you are willing to take his crime upon your own souls, and bear through life a load of infamy that will shadow the heart stones of your children when you are in your graves. Will you go home to your neighbors and tell them that you have done a deed, the effect of which will be to license murder in this Commonwealth? That will make the path of safety sure and plain for the assassin. That will destroy all confidence in the laws, and drive the most peaceful to the habitual wearing of arms for their protection. That will, in course of time, convert Kentucky into one wide battlefield, and substitute the revolver and bowie knife for the adjudication of your courts. License such deeds as this by your verdict, in those strong ties of kindred of which my friend Governor Helm discoursed so eloquently, will supply the place of law, and, like the Indian mother, the widow of the slain will train up her child to hunt down the murderer of his father. If there be no redress by law for outrages so monstrous as this, if it indeed be true that the law sanctions them, let us at least know the fact. Were sister of mine so widowed by the assassin's hand, and no law existed to punish the murderer, I would counsel her to train up her babe to the high and holy duty that the law was recreant to, the duty of avenging innocent blood. The first word she taught him to lisp should be vengeance, and when his arm had grown strong and his heart bold, she should take him to his father's grave, tell him the story of a father's murder, place him on the trail of his father's assassin, and bid him hunt him through every avenue of life, as the bloodhound hunts his prey, until he had performed that duty in which the law had failed, the duty of punishing the murderer. Such must be the result, if juries in cases like this shall fail to do their duty, and their whole duty. If it were cowardice more base than words can characterize in you, to shrink from discharging that duty in this case, that you know you would perform, were this some poor and friendless man on trial. I desire to create no feeling against this prisoner on account of his wealth and position in society. All that I ask is that they shall not shield him from consequences that would most certainly follow did he occupy a humbler sphere in life. It is all folly to talk of justification, or even palliation. You know there is none. His counsel know it. His friends know it. He himself knows it. And if this crime is sanctioned by your verdict, it will be through influences that lie deeper than the surface of this cause. I will now, gentlemen, refer briefly to some of the points made by Mr. Marshall, and if there shall be neither order or regularity in this portion of my remarks, you will please attribute it to the fact that the power of reducing chaos to order is reserved to omnipotence alone. It was in keeping, gentlemen, with this whole case, that this prisoner should, through his counsel, insult the memory and trample on the grave of his victim. Not satisfied with the innocent blood he had shed, his vengeance not sated with the life of his victim, and the anguish of his broken-hearted widow, his counsel here in the face of God and the country insults the memory of the dead and wrings the hearts of the living by an expression conveying more bitter contempt and insult under the circumstances than could have been embraced in any other two words of our language. Mr. Marshall speaks of the murdered man as the puissant pedagogue. Oh, was it not in keeping with the act he was defending? A mere schoolmaster, Nothing more. What right had he to live if Mr. Ward thought it proper to kill him? This world was made for Caesar. Mr. Marshall devoted a considerable portion of his speech to impressing upon you the enormity of the offense committed by Butler in charging Will Ward with lying. What will he say then for his client, whose first words are coming into the schoolroom were to denounce as a contemptible pup and liar a little boy some 12 years old, who belonged to the school, and over whom he stood not in the relation of teacher? If it was right for Matt Ward to shoot Butler down like a wolf for what he had done, will it not be equally right for that boy's brother to shoot Ward if you should acquit him? Suppose you turn Ward loose tomorrow, and that boy's brother should come to him when he is alone, and maimed and crippled as he is now, and say to him, "You have called my brother a liar and a pup, and you must apologize." Mr. Ward would decline. The brother should insult and strike him, and then if Ward dared to raise a hand to defend himself, shoot him down. What jury would dare to convict him after Ward had been acquitted? And where would all this end? I answer, in barbarism. Mr. Marshall tells you that the boy who ate the chestnuts did not get whipped. I would like to know where he finds this in the evidence. No witness has stated it here. None dare state it. But the truth is he was whipped. And it was after he was whipped that Butler learned that little Ward was equally guilty. And that, to that guilt, he added the further offense of denying it. How could he avoid punishing him then, when he had just punished the other boy? All this is outside of the record. I have not myself traveled out of the testimony, except when it became necessary to follow gentlemen on the other side in their excursions of fancy. Mr. Marshall tells you that it cannot be that he had his hand upon his pistol, or he would have shot sooner. Good God! How much expedition would he expect? More than one witness tells you that the last words of the insult he gave were almost mingled with the report of the pistol. One witness says no time intervened, another that it was not more than 5 or 6 seconds between the giving of the insult and the shot. Yet Mr. Marshall is not satisfied with this. So bloodthirsty does he consider his client, that he thinks if he had had his hand upon the weapon of death, he could not have refrained from using it the moment he laid his eyes upon his victim. But we are asked why we have sworn Sturgis as a witness and not examined him, as though there was something strange and mysterious in it. Sturgis knew nothing of the killing, and was not summoned here to testify against his prisoner, but against his brother, who is not on trial. I hope the gentlemen's minds are easy now on the subject, and that no visions of Sturgis and his big stick will hereafter disturb their dreams or impair their digestion. In return, I hope gentlemen will permit me to remind them of a similar interrogatory propounded to them by my associate counsel, but in relation to which they have thus far maintained a dignified silence. Why was William Ward sworn and not examined? Were they afraid to trust the artlessness of childhood on that stand? There is an old adage, gentlemen, that children and fools speak the truth, and like most old adages, it has its foundation in human experience. I must be permitted to say that I admired their sagacity in keeping him from the stand. You, gentlemen, will draw your own inferences. Mr. Marshall tells you as matter of complaint that when Barlow was undergoing the ordeal of cross-examination, a low chuckle ran around the courthouse among the audience. I noticed, gentlemen, the fact. I differ only in the name by which I would call it, and the feeling to which I would attribute it. There is a feeling, thank God, in the great human heart of the masses that revolts with horror at the exhibition of palpable, unblushing, and unmistakable perjury, and that feeling will find vent, no matter in what presence the crowd may find themselves. You may chain the limbs and seal the mouth, and yet the heart will find some means of utterance, and all who hear will understand the meaning. It was no chuckle of rejoicing that broke from the honest lips and hearts of this audience as they listened to a story that damned itself in the very telling. It was an irrepressible outbreak of honest indignation. I am sorry that gentlemen's nerves were so shocked by it, but I hope that with proper care and attention, they will in due time recover from the effects of that chuckle. Mr. Marshall expended a vast amount of indignation upon the bare thought that it was possible for a man born in Kentucky to be brought or bribed to commit perjury. And yet, gentlemen, such things have happened again and again and again. We do not, however, believe or intimate that Barlow was brought by Robert J. Ward, Sr. If I thought so, be assured, gentlemen, I should not hesitate to say it. But believing otherwise, I will not do injustice to a gentleman whom I believe incapable of such an act. But that Barlow offered himself for sale, no man can doubt. He denies that he said to Mr. Ward that he was a poor man and could not afford to lose his time. But we prove that he told May and Sullivan that he did say so. And above all, Mr. Ward himself swears that he did, that he expects compensation enough to take him to California from someone. I have no doubt. I wish California joy of her intended citizen, and I will give him one little piece of advice, and not charge him a copper for it. By all means, let him change his name before he goes there. He will find the name of Barlow more inconvenient there than a blanket coat in August. Mr. Marshall travels out of the record again to tell you that never before has man been so visited and caressed in Hardin County as has the prisoner in the lonely cells of his prison, and that he had made half the county his friends already. Well, gentlemen, if by making them his friends he means that they are convinced of his innocence, I have only to say that those same friends keep very close at home and don't come near the courthouse. Outside of some half-dozen friends of the prisoner in town, I have yet to hear of the first man, woman, or child who has attended this trial who hesitates a moment in his opinion of the guilt of the prisoner. This is all out of the record, gentlemen, I admit, and should have no weight with you. But when the other side attempt to create the impression that everybody outside of that jury box is waiting impatiently for a verdict of acquittal, I have a right to tell you what my observation has taught me as to public sentiment in the county. But as to these visits at the jail, I too have heard something about them, and the manner in which they were brought about. But I did not dwell on the subject. What has it to do with this case, or the guilt or innocence of the prisoner? Less than nothing. It only proves, if true, what everybody knew before, that the people of Hardin County had warm and generous hearts, that they were willing to try and forget for a time the husband's guilt, that they might pay a passing tribute of admiration to the fond devotion of the wife, who strew, with a few fading flowers, the dark and thorny path his crime has destined her innocent feet to tread. End of section 22. Section 23 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 15. I have done with Mr. Marshall's argument. It reminded me of a brilliant piece of fireworks, with here a rocket darting up to heaven and losing itself from sight in the far void, and there a revolving wheel or Roman candle, challenging the wonder of the listening crowd, and lacking but one merit, applicability to the case. A few words from my friend Governor Helm and I have done. Most of the positions assumed by him in calling for a reply, I have already noticed at the appropriate stage of my argument, with which they had connection. The governor tells us in the outset of the argument that he himself was wonderfully excited against the wards when he first heard of this transaction. I thank him for his candor. I had heard something of that excitement, for it was not a light hit under a bushel. What changes come over the spirit of his dream? He does not tell you that the facts as he first heard them are different from those in proof. Ah, gentlemen, there are a certain kind of spectacles that have the wonderful property of making all things look just as the wearer wishes them to look, and that which was a weasel before becomes very like a whale when looked at through their golden rims. The governor tells you that never before in his life has he heard it asserted as law that a jury are bound to judge of facts without being influenced by feelings of compassion. He promised to show by abundance of authorities that such was not your duty, but he has cited but one case, that of Cain, as reported by Moses, in, I believe, the 2nd of Genesis. I have not the case in court, gentlemen, but have some recollection of the facts. The punishment of Cain was by an ex post facto law, and in our day would be unconstitutional. He had never been forbidden to murder. He violated no law, and there was reason why mercy should be extended to him. But there is another answer to it. He was tried by the only tribunal on the universe, in which can safely be trusted the attributes of both justice and mercy at the same time. His trial was God himself, not a jury of weak and erring mortals. The laws have vested the right to extend mercy in another tribunal. It is with justice alone that you have to deal. But the governor asked why it was, if Ward intended to kill Butler, did he not shoot him in the dark? I am afraid he has not altogether gotten rid of that first excitement, and that he has a worse opinion of his client's heart than even we of the prosecution have. But I have already stated more than once that we do not charge a fixed purpose to kill at all events. We charge a purpose to degrade by insults and blows, and a purpose to murder if those insults or blows were resented. You will perceive at once that such a purpose could not be carried out in the dark. But the strangest argument I have yet heard is this, and I might say with safety in any other cause, is this, that because the act is proved to have been committed in the presence of 40 witnesses, you are to disbelieve the statements of all those present, because forsooth it is improbable that the prisoner would do such a deed where he would be overwhelmed with the testimony of so many witnesses. In other words, the more testimony you have of a fact, the less you are to believe. If one witness swears to it, all right, you may believe. If two attest to it, you must begin to doubt. If it doesn't swear to it, of course it must be false. I have no comments to make upon a position so extraordinary. The governor makes it a matter of complaint that while we have crucified Barlow, we have made no assaults upon the distinguished array of gentlemen who have come here to testify to the prisoner's character. I can assure counsel that if there had been anything in the conduct of testimony of any one of those gentlemen that in my opinion called for animadversion, it would have afforded me infinite pleasure to have done them justice. But I must beg to be excused from violating my own feelings of right and propriety, merely to gratify counsel on the other side, and give them an opportunity of defending their witnesses. I have assailed the motives of the defense in bringing those witnesses here. I have told you that though the ostensible object was to prove character, the real object was to overawe you with the majesty of great names. But for this, the witnesses themselves can in no way be held responsible. When requested by Mr. Ward as an act of friendship to him to come here and testify in behalf of his son, it was their duty as gentlemen to do so, without inquiry into the motives of their request. I hold these gentlemen not only blameless in this, but I am free to say that a refusal on their part to come might in a certain event have been matter of lifelong regret to them. I desire to notice one authority quoted by Governor Helm this morning, that Tennessee case in which it is asserted that the cowardice of the murderer is a justification of the crime. I will not stop to comment upon the consequences that would result to society from the recognition by courts of a doctrine so monstrous. It is enough to show that it has no applicability to this case. Surely, gentlemen, after having proved that the client is a man of spirit, will not now take shelter behind the Tennessee case and allege that he was a coward and therefore justifiable. I have characterized this act itself as a most cowardly assassination, but I do not mean by that to charge that the prisoner is a coward. The proof is otherwise, and the very fact that he proved to be a brave man, and acted so different in this from the way in which a brave man should act, proves conclusively the most deep-seated, cruel, and calculating malice. When a brave man forgets his nature and his pride, and stoops to an act of cowardice, it shows some feeling at work in his heart, stronger than pride, and fiercer in its coolness than is anger in its heat. But we are told by the governor that Matt saw Campbell coming with the tongs. If so, why did he not shoot Campbell? But Campbell and the governor don't exactly agree about this. Campbell says he had turned around to get the tongs, but had not got them when the shot was fired. It is a small matter, but it is just as well to have it right. Perhaps, however, the richest expression that has fallen from the governor's lips in the whole course of his long and able argument was that in which he spoke of the clear statement of Barlow. It was clear, gentlemen, so transparent that not a boy in the house but could see through it. Why, I would have been willing to bet any reasonable sum that if the fellow's pockets had been searched when he left the stand, that story, written out in length, would have been found upon him. I have been practicing law some 15 or more years, and never in all my life have I seen a case of more palpable, self-convicted perjury than was exhibited in the clear story of that witness. I have but a few more words, gentlemen, and then the case, so far as I am concerned, will be with you. Never before in Kentucky have a jury had such an awful weight of responsibility resting upon them. The high position of the accused, the measureless enormity of the act, even the very spot selected for its commission, all add to the interest it has excited, all add to the responsibility devolved upon you. The example of crime has been set before, and in the very presence of a crowd of boys and youth, and the example of punishment should follow close upon its heels, that while the memory of the bloody deed haunts them through life, they will not also carry with that memory the still sadder one of the powerlessness of the law to protect life or avenge murder. Gentlemen, my duty is done. Yours yet lies before you. My earnest prayer is that you may be so enabled to discharge that duty, that this prisoner will have nothing to fear but from his guilt, nothing to hope but from his innocence. Mr. Wolfe, for the defense. Gentlemen of the jury, this cause has been so amply, and I may add, so ably discussed on the part of the accused. The ground has been so fully explored by the two gentlemen who preceded me, that but little is left for me to say, and I shall not attempt to disguise from you the embarrassment I feel, knowing as I do the distinguished character and ability of the counsel with whom I am associated. Under such circumstances, it almost seems like presumption to hope that you can be influenced by anything coming from so humble an individual as myself. But knowing as you do the great disparity between us, I trust you may receive what I have to say with that allowance which is due me. I presume for myself no power to afford you an intellectual treat, to regale you with a feast of reason and a flow of soul. But I do claim some degree of ability to discriminate whether statements are testimony or not, whether propositions are law or not, and during the short time I shall occupy in attempting to do so, I must ask your kind indulgence. I congratulate myself, gentlemen, that this trial takes place in a section where I see in the jury box only faces indicating hearts, in a fit condition for the duties and amenities of social life, and under the sway of no blind prejudice or unmanly bias. I congratulate myself that we were in a community where no improper influence has been brought to bear against this prisoner, that no men, with hearts black and bloodless, only able to communicate the fire by which they consume and are consumed, have here succeeded by the most foul and reckless misrepresentations in deceiving and exasperating the public mind, until they have excited to the last degree the feelings of a misled and infuriated populace against him. I thank God that this courtroom, this temple of justice, is closed against all such influences, and that in this jury box none of the wild cries of those who seek the young blood of this accused can reach your ears. You may think that I use strong language towards some men in the city where I reside, but if you know all the circumstances, if you are aware of the false and willfully distorted reports they have sent forth through the newspapers, denouncing the act for which my client is now on trial as a cold-blooded, premeditated, and unmitigated murder, a diabolical outrage unparalleled in the annals of crime, and exhausting the vocabulary for vile epithets to apply to him and his conduct, you must feel that it is deserved, and you cannot wonder at the prejudice they have fulminated against this young man, and the wild fires of passion and excitement they have lighted up through our whole country, until it was impossible for him to obtain there that fair and impartial trial, which is guaranteed him by the benignant genius of American law. Therefore has he come to seek it in Hardin County. I congratulate myself that the cause of my client is so just, we may rest it safely upon the law and the evidence, without calling to our aid the newspaper press, or any other improper and illegitimate influence. In the midst of those denunciations and attacks, he has uttered no word of reply, but has remained silent in his prison, with no desire to induce a prejudgment of his case, or excite improperly the public sympathies on his behalf. He has waited patiently for this investigation, uttering no murmur at the extraordinary persecution he has undergone, but with a firm conviction that at the proper time, as the laws of his country provide, he could establish his innocence to your satisfaction. Thus he comes before a jury of your country, gentlemen, and I am much mistaken in its character, if you shall refuse to dispense to him that justice which the Constitution of the United States and the Constitution of your own state guarantees every man. I shall not attempt to follow the counsel for the prosecution in a minute detail and review of their argument, for it is quite unnecessary and will consume too much of your time. But I must say that during a criminal practice of 15 years, a portion of which has been in an official capacity, I have never before seen such a course pursued as that adopted by the prosecution in this case. I would be distinctly understood that I make no such allusion to the officer who represents the Commonwealth in his legitimate capacity, for I believe no more honorable gentleman exists in this or any other state, but I refer to those who, not under the responsibilities of an official oath, have made such extraordinary appeals here, and such unparalleled attempts to excite unhallowed passions against the accused. Yet these men would have you believe that in appearing here, and pursuing this line of conduct, they are actuated by a sense of justice. One of these assistant prosecutors who has been endeavored to impress it upon you that he is under the influence of no other or less worthy motive, has proclaimed here a sentiment that must thrill every man before me with horror, for it is shocking alike to every principle of religion and every feeling of humanity. He has told you that were the training of the child of Professor Butler confided to his hands, the first word he would teach him should be vengeance, and the second, blood, that he would instill into his infant mind no other feeling so deeply as that of revenge, and would train him up to make it the great business of his life to follow like a bloodhound the track of the accused, and never to rest until he had found him and shed his blood. Gentlemen, how were you impressed with such a sentiment here in this temple of justice in this holy place? The announcement of it must be sufficient to convince you that this prosecution is not conducted from any sense of justice, but from mere vindictiveness alone. I will venture to say that such an appeal is wholly unparalleled in the annals of criminal jurisprudence. How illy does it comport with the old maxim of law that all men are considered innocent until proved guilty, and the ejaculation when a prisoner is confronted with the jury, God grant you a safe deliverance. A great deal has been said about the unfairness manifested on our side, but I call your attention to this as a specimen of the spirit evinced through this whole prosecution. You are asked to convict this man whether he be guilty or not, or threaten that the son of the deceased shall pursue him until he has imbrued his hands in his blood. When such sentiments are promulgated, I cannot believe them the result of calm, sober reflection. They can have been uttered only in the excitement of the moment. But do they not show that if the bosom of him who avows them is not black with such vindictiveness, his head must be weak enough to render him the tool of those who cherish it, men in whom my opinion bear no resemblance to any of God's creatures, except the very Cuban bloodhound of which he has spoken, and which is provided by nature with the bloody instinct to track its victim and to slay it. After all that has been said about our unfairness, I maintain that never in the world was there a more unfair and distorted statement of testimony made to a jury than that you have heard from the counsel for the prosecution. As I detail the testimony, should I make any error or misstatement, I am sure that your intelligence and your recollection will correct me at once. I appear before you, gentlemen, as the counsel for the accused. It is my duty and my pleasure to do so. The charge against him is that of murder, committed in killing William H.G. Butler, and to this charge he pleads not guilty. Let us first take a survey of the case, that we may see what aspect it presents. End of section 23. Section 24 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H.G. Butler, Kentucky, 1854, Part 16. On the day named in this indictment, the accused sought the schoolroom of Professor Butler, according to his own language, to seek an explanation of his extraordinary conduct. But what was that conduct? A little brother had been called a liar and severely whipped, in the presence of the whole school. The counsel for the Commonwealth who first addressed you has uttered a sentiment almost as shocking as the one to which I have just alluded. He tells you that the father was the only person to whom that explanation was due, that the brother had no right to demand it. From what section of the country could he have come, where he learned such a sentiment? I know not, and I care not. But if there be a spot on earth where the holy ties that bind brothers, heart to heart, are not recognized, and if he really entertained such a belief, he should be exiled there. According to this doctrine, a brother must stand by and see his little brother insulted, injured, and maltreated to any degree, with no right to interfere and protect him. The gentleman may tell you that is common law, but if it was the law in the earlier times, it is certainly repugnant to every sentiment of our nature. The little brother of the accused has been whipped. You have not seen that brother. He has not been brought before you during the progress of this trial. But he is a bright and beautiful boy. There is not one in your family whom you love more dearly, or who deserves it more, for a kind disposition or an open, noble heart. He had been publicly whipped and called a liar, a punishment to which in his estimation death were preferable, and he appealed to his elder brother to have his character vindicated. Gentlemen, I deny the right of the teacher to whip the child. This may seem like high ground, but I believe it is right and can be sustained. It is true that the parent delegates a portion of his authority to the teacher, but it is only authority to give moral instruction. Modern sentiment totally discards this right to flog by the teacher. He may use proper corrective influences whenever they are necessary, but he has no right to scourge the pupil as barbarians scourge their slaves. I repeat it, that so far as my feelings go, I am opposed to whipping children. I have two little boys as bright and beautiful, I believe, as Kentucky has produced. So far as my influence goes, I have always ordered that they should not be whipped at school. If they do wrong, I believe the parent is the only person to discriminate as to the nature and extent of the punishment which should be administered. Even if we go back to Greece, that glorious old republic, whose light will continue to shine through the historic page to the latest ages of time, we shall find that this brutal practice, this relic of barbarism, was ignored in their schools. Chastisement was then believed, as it really is, the father's prerogative, as so many incidents on this subject have been related by the gentleman. Perhaps I may be permitted to allude to one. Plutarch, in his celebrated Lives of Distinguished Men, tells us of one of his tutors named Ammonaeus, who, when one of the boys under his charge had done something wrong, took his own son and whipped him in their presence, to reprove them, and to show what he would have done had the laws of his country allowed it. Is whipping permitted in the colleges of our country? Certainly not. And you must remember this was a high school, where many of the pupils were very far advanced. Not a high school, as you have been invidiously told, because of the position in life of those who patronize it, for it is open to all who are able to pay the expense of tuition, but so-called from the nature of the branches taught there. A few years since, a student in the University of Virginia, while being punished by one of the teachers, retaliated and met force by force, and when the matter was investigated, the faculty sustained the pupil and not the professor, on the grounds that he had no right to inflict physical punishment. The brave seamen of our Navy were once scourged for every trivial offense, but Congress has abolished the barbarous practice as debasing and degrading to the character of a free man. In the British Navy, the same is true, and throughout this whole country there is a settled sentiment against this punishment. It should and it must soon cease everywhere. But notwithstanding this sentiment, the child had been flogged, and as we have a right to infer from the testimony of the mother, for the first time. Now, as the other gentleman in the argument traveled out of the record, I presume I may be allowed to do so. We desired to go into the cause and merits of this whipping. We called a man to produce the register of the school here, to know the ordinary deportment of this boy, but the man did not show himself, though his track has been seen more than once during this trial. I allude to Sturgis, but of this more hereafter. Not only has this whipping been described to you, but it has been shown to be the motive which induced the prisoner to seek the schoolhouse of Professor Butler. His purpose was to obtain an explanation of, or redress for a deep and damning insult that had been offered to his brother, that little brother who appealed to him for protection. Was this wrong? The explanation he sought was of the cause of that teacher's conduct in whipping and insulting the child. Does not this appeal to you as proper and right? Is there a heart in Kentucky when one bound to it by such ties has been outraged that would not have demanded redress? He sought this explanation, but how was he received? He asked it in a proper gentlemanly manner. Was it granted? No, it was promptly and peremptorily refused. You have it in evidence that Professor Butler was intimately acquainted with Mr. Ward, that he had for a long time resided in his family and been the preceptor of his children. This whipping was inflicted 24 hours before the explanation was sought. The distance from the schoolhouse to Mr. Ward's residence was not great, and I appeal to you, if under the circumstance it was not the duty of Butler himself to go around voluntarily and make an explanation. Just at this point, I wish to allude to the testimony of a single witness, Mrs. Harney. I do not stand here to impeach her. I have no doubt of her being a lady of the highest respectability and truthfulness. But does it not strike you as a little remarkable that in a thronged city of 70,000 people, at the busy hour of the day, in one of its most crowded thoroughfares, as she met a gentleman with whom she had seen only once or twice before, she should have scrutinized him so closely as to observe that his hands were in his pocket, and that he wore a firmer look than usual? Ah, gentlemen, there is a key to this. Butler was an inmate of her family. He knew that what he had done was wrong, that he had a right to expect it would excite the feelings of the family, and he had undoubtedly apprised her of the fact. If this were not the case, could there be any reason on earth for observing so closely the conduct of a gentleman who was almost a perfect stranger to her? Such is a general view of the case. Now let us look more minutely at the ground on which we stand. I argue that we are able to vindicate ourselves on the ground of self-defense. You, gentlemen, all recognize the great principle, coeval with our existence, not derived from the laws of society, but inherent and far above them all, the principle of self-defense. Were we deprived of this, there would be no other right worth having. The most responsible and important duties of life could not be performed. And when a man is brought into a position of danger, where his life is imperiled, or he has reason to apprehend great bodily harm, he is bound by his duty to God and society to exercise the right which nature has bestowed upon him, and defend himself, even to taking the life of his adversary. It is true that government professes to extend protection to the citizen, and that the citizen, on his part, is expected to support and submit to the government. It is true that there are legal tribunals to be appealed to when a wrong is done, but these tribunals and laws do not propose to furnish you with protection when your life and limbs are immediate and imminent danger. There would then be no time to appeal to them, and therefore society guarantees to every man, on such occasions, the right to protect himself. But I need not have reminded you of these truths. They are so well established that every man in the country is aware of them. Before we go further, however, let me call your attention to one or two points alluded to by the counsel on the other side. They contend that where a man procures a deadly weapon, and afterwards, becoming involved in a struggle, makes use of it by killing his adversary, it is a correct inference that he procured it for that very purpose. I deny the assumption in toto, and during this discussion I desire you to keep entirely separate the two facts they would thus connect. A man has a right to carry arms. I am aware of nothing in the laws of God or man prohibiting it. The Constitution of Kentucky and our Bill of Rights guarantee it. The legislature once passed an act forbidding it, but it was decided unconstitutional and overruled by our highest tribunal, the Court of Appeals. I contend that if I see proper, I have a legal right to arm myself from the crown of my head to the sole of my feet. When this right is guaranteed to a man, and he procures weapons legally, it is absurd to infer that he obtains them with intention to do an unlawful act. As an illustration, suppose you are about to go on a journey to Louisville with a large sum of money in your possession. Knowing the character of the road, that it is infested with robbers, you take the precaution to arm yourself before you start. On the way you meet a robber who attacks you and would deprive you of your property. You resist and slay him. You have a perfect right to do so and protect yourself. And will the fact that you obtained weapons before you met him indicate any improper or unlawful intention on your part? Again, Suppose from threats that have been made or some other cause, you believe you have reason to apprehend an attack from some enemy. You procure arms that you may defend yourself against him. But before you meet, or he makes any attempt to harm you, you become involved in contact with some other man with whom no previous trouble had ever occurred. If he attack you, and you slay him during the affray, even if your conduct is blamable, you cannot be indicted for murder, because you procured arms not with malicious intent, but for the legitimate purpose of defending yourself. Even if you procure weapons for an unlawful purpose, to fight a duel for instance, and on the way to the field being attacked, you defend yourself by slaying your adversary, the act is a justifiable one. Your conduct in procuring arms for the purpose you did was unlawful, but does that make it unlawful for you to use them in your own defense? My object is to show that when a man arms himself for a general purpose, there is no rule of law by which it can be converted into a special one. That if he does obtain weapons and uses them lawfully afterwards, the procuring of them was no crime. If Mr. Ward procured pistols before the conflict, and during the conflict, unfortunately slew Mr. Butler, I say unfortunately, not that I deem the act a guilty one, but because the loss of human life under any circumstances must cause a pang of regret to the hearts that are left behind. If during the catastrophe he acted only according to law, the fact of his procuring the pistols cannot make an act unlawful which was otherwise justifiable and proper. Before I proceed in the discussion of this case, I desire to lay down a few principles of law for your government in considering it. In regard to the amount of evidence necessary to convince a jury of the guilt of a prisoner, it is well established principle that the evidence must exclude every other conceivable hypothesis except the one of his guilt. If room is left for the existence of any other belief, the evidence is insufficient. In this case, before you can convict, the hypothesis that the accused killed the deceased in self-defense must of course be totally excluded. The proof must be sufficient to satisfy the minds and consciences of the jury beyond a reasonable doubt of the guilt of the prisoner. To be convinced beyond a reasonable doubt, the assurance must be so great that you would not hesitate to act upon it in matters of the highest concern to your own interest. Such is the law in regard to the amount of proof required. Now, gentlemen, you have it in proof that Ward went to the schoolroom of Butler to obtain an explanation, that Butler steadily and persistently refused the explanation which was due, that in default of receiving it, Ward denounced Butler as you have heard, whereupon Butler seized him and assaulted him in such a manner as we contend he had reason to apprehend great bodily harm, and that therefore he is not responsible for the death of Butler. One of the gentlemen for the prosecution admits he does not believe that the accused sought the schoolroom determined to kill Butler at all hazards, and thus refutes their own presumption of malice. Again, he tells you that Ward had reason to expect a blow after using the language he did, that no man in Kentucky would receive such language without giving a blow, and yet he reads law to you to show that no language whatever will justify an assault. It seems to me that he sets at defiance even his own landmarks. It has been told you in triumphant tones that a man's house is his castle, that Butler was in his house, and therefore Ward had no right to go there. The general principle is a correct one. The law makes my house my castle, and not even my best friend has a right to cross its threshold without my permission. But this rule only extends to the sanctity of the private dwelling, and by no correct reasoning can it be carried further. It is true that I have no right to enter your house without your consent, but there is a tavern across the street. I have just as much right to enter that as the owner has, and he has no right to expel me. But even if a man enters your private dwelling unbidden, you have no right to expel him, except in the manner prescribed by law. If you attempt to put him out by force without having first used gentle means, and are killed during the conflict, The act will not be murder. I may seek your house for money you owe me. I may go to buy produce or any other legitimate errand, and have you a right, because you see fit to take umbrage at something I say or do, to seize me by the nape of the neck and kick me, like a dog, from your threshold. By no means. You have no right to resort to violence until I resist. I maintain that in this case, Ward had a perfect right to seek the schoolhouse for the transaction of any legitimate business, that the errand on which he went was proper, and that when Butler attacked him, he violated the principles of law and made it right and justifiable for Ward to resist. I maintain that the accused did not cause the difficulty, that his character, habits, and circumstances of the case all preclude the possibility of it. I maintain that there was no deliberate purpose on his part to kill or to do any great bodily harm. The law states that such intention is to be inferred where the prisoner makes declarations of intent to kill, deliberately and advisedly denounces vengeance, declares that he will have the blood of his adversary, or makes direct preparation for the conflict. Is there any proof of such a state of facts here? I have shown, remember, that unless the accused acted unlawfully during the conflict, the fact of him procuring weapons previous to it can be in no way connected with and have no bearing upon the case. The law says that the man attacked must be driven to the wall before he is justified in taking the life of his adversary. It is in proof that the prisoner was driven to the wall. They have read law to show that no words whatever can justify a blow, and even according to this, their own law, though I believe it is contrary to the law of God, Butler was the first aggressor. By this law, Ward might have stood and cursed him all the day, and he would have no right to resent it. Judge Kinchlow called attention to the subject in which he had referred in the morning, the publication of testimony contrary to the order of court. He observed that the character of that order had been misrepresented. In making it, he explicitly made the distinction and applied it only to those reporters who accepted the courtesies of the court by taking seats provided for them inside the bar. Upon other reporters, he had attempted to lay no injunction whatever. The reporter for the Courier, who was present, Mr. George W. Cole, he had every reason to believe was a highly honorable gentleman. He had at first accepted a seat under the order of the court, but since this testimony had been published, the judge had received a note from him, resigning his seat, and stating that when he took it, he did so in good faith, assenting to the order, and that when he delivered his reports to an agent of the paper who was now present, he had given them under the express condition that the order of the court should be respected, and that they should not be published until the case was concluded. That agent for the paper had also stated to the court that he forwarded the reports to the office with precisely similar instructions as an act of justice to the proprietors. Perhaps it was right for him to state, however, that the copies which had reached town were only stray ones, the regular bundle having been withheld, as it was presumed that the publication should exert no influence in the community where the trial was progressing. A similar case might never again occur in the state of Kentucky, and the court thought it best to take no further steps in regard to the matter. Mr. Wolfe, resuming his argument, Gentlemen of the jury, I endeavored in the argument which I submitted to you before the adjournment of court to inform your minds in regard to a few of the principles of law applicable to the case, while considering the question of murder. I desired you to understand them as fully as possible, because it is on the law and the facts that we wish to try this case. And while I utterly repudiate and deprecate the idea that you should disown one of the noblest sentiments of our nature, that you should lay aside all compassion and all mercy, forget that you are fathers, and forget that you are men. I stand here with the proud consciousness that my client has nothing to fear at your hands, if you consider his cause upon the law and the evidence. According to the definitions of the books, murder contains three elements: There must be a killing. A reasonable being must be killed, and the act must be done in malice, either express or implied. You have heard murder fully explained, that malice is an essential ingredient, and that if a man kill another with no provocation, or a very slight one, it is murder. But why? Simply because in such cases, malice is implied by law. All these principles of law that relate to the crime of murder are to be taken separately, and you must remember that self-defense, whenever it is proven, outweighs the crime. You have been told by some of the authorities that if a man be in fault, and his fault cause the difficulty between him and his fellow man, in which the latter is killed, it is murder. But this is to be taken with great caution. You have also heard it read from high authorities that when A meets B, with no malice in his heart, and a fray ensues, and A, being driven back to the wall, kills B, he is justified in the eye of the law if he does it in self-defense. On this point the law is perfectly clear. But they contend that if you have been in fault at all, when you are attacked, you must not avail yourself of the right of self-defense, which is guaranteed to every man alike by the laws of nature and of human society. Does this seem reasonable? Suppose a man assails you in your absence, or defames the character of your wife or daughter. You seek him, or inadvertently meet him, and denounce him as a scoundrel and a villain. If he attack you then, have you no right to defend yourself or resent the insult? In this law, in Kentucky, and in this Union, I deny it. It has been said here that in the case of assault, where your life is not in danger, you must seek redress only in courts of justice. If a man meets you in the public street and lays the cowhide over your back till he has no strength left, your life may not be in danger, but you must therefore wait and seek justice by bringing suit against him for assault and battery. Is such a law here? Why, they gainsay the very proposition of law they lay down in this case, by admitting that when the lie is given, he who gives it must expect a blow. As I have said before, we plant ourselves here on the great principle of self-defense, that principle without which we cannot discharge the duties we owe to ourselves, to society, and to God. The law defines self-defense as that principle by which a man may protect himself against an assault. An assault, remember, does not necessarily include a battery. There are circumstances under which the raising of the hand is an assault. The law justifies a man in the case of a sudden brawl in killing the man who insults him, after he has retreated to the wall or some other impediment, and is in danger of losing his life or receiving some great bodily harm. This is the grand principle, and any contrary law could never be enforced or administered. It would be execrated and spit upon, as contrary to every principle of our nature, and to the laws of God himself. Through tenderness to human life, the law only allows the man who is assaulted to slay his adversary after he has retreated to the wall or some other impediment. The prisoner at the bar strictly complied with this injunction, and only took life when reduced to the last alternative. And this, says the author from which I have just been reading, is a doctrine of universal justice, as well as of municipal law. I am sure that I may here leave this point, for I believe every man in this jury box understands the principles I have laid down, that where, in case of extremity, there is danger that a man's life may be taken, or his person mutilated or enormously injured, he is justified in using whatever advantageous aids he can procure, in protecting himself and, if necessary, in taking the life of his adversary. An important point in this case is the comparative strength of the parties. Where one was so unusually weak and feeble, it became more necessary for him to make use of these adventitious aids than it would otherwise have been. End of section 24. Section 25 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 17. If we turn from English to American authorities, we may see how the law is administered here on this subject. In the case of Selfridge in Massachusetts many years ago, charged with murder, the principle was decided and has since been universally recognized as law that it is not necessary for a man really to be in danger of death or great bodily harm, but that if he has reasonable grounds to apprehend such danger, he is justified in killing his adversary, whether it existed or not. To illustrate, suppose a man is very hostile to you and has made threats to do you bodily harm, and you know it. You see him point a gun at you as if about to shoot. Now it may be that the gun is empty, and that he only makes the movement to excite your fears, but you are justified in slaying him the moment you see it. This is in accordance with common sense as well as with law. You have good reason to apprehend danger. How absurd the other principle which would compel you to go up to that gun, examine it, and ascertain how many fingers of charge it contained, before you could take any measures to protect yourself. In the case of Granger in Tennessee, this principle was also established, and it is one that must appeal to reason and humanity. The cruelty with which the law was administered in former times shows that the world was in a degraded condition, and that human rights were not properly appreciated. There was a time when there was no less than 140 offenses punishable with death. In those days, if a man broke down a mound in a graveyard or disturbed a fish pond, it must cost him his life. But now, those rigid rules have been ameliorated by a more genial and civilized code, which goes a bowshot further than these musty old English books, and places a higher value on human life. It is the American doctrine of self-defense. The gentlemen have alluded to cases not recorded in the books, and as they have furnished the precedent, I relate a few. Near Boston, in this state, Stout was tried for the murder of Bullock. During a political campaign, the former, who was a Democrat, set up a flag which Bullock pulled down. Stout would have shot him at the time, but his friends held his arm. Bullock went to a grocery where he spent the day, and when he was returning home at night, he stopped at the house of Stout and called for a whiskey. Stout refused to give him any and ordered him to leave the house. He would not obey, and Stout took his gun and shot him. He believed from the previous conduct of Bullock that he had come there to do him bodily harm. He was weak and small. Bullock was a large, strong man, and therefore the homicide was held to be justifiable. In the Jefferson Circuit a few years ago, Coon was tried for the murder of Schaefer. The latter had insulted Coon's wife, and Coon went to obtain redress. He told Schaefer of the insult, whereupon he raised his arm, as Coon thought to strike him, though it afterwards appeared that his hand only contained a small piece of wood. Coon then plunged a file into him, and it immediately proved fatal, yet the jury sustained his conduct. The case of Owen, charged with the murder of Hare, caused so much excitement in Louisville a few years ago that it was necessary to obtain a change of venue to secure a fair trial. The parties slept in the same bed. In the morning, Hare missed some money and accused Owen of taking it. Owen asked an explanation. It was refused, and he prepared himself with the pistol before they met again. Hare, I believe, also had a pistol, but Owen shot him and was acquitted on the ground that he had a right to obtain redress for the injury done his character. 5 or 6 years ago, Louisville was boiling over with excitement, and some prisoners were in danger of losing their lives while going from the courthouse to the jail. They sought a change of venue, obtained it, and were tried and acquitted. I allude to the Wilkinsons from Mississippi. One of them was on his way to be married to a young lady in Bardstown, and while they were in Louisville, they went to the shop of a tailor on business and became involved in some trouble with him. The tailor and his friends afterwards came around to the Galt house, where they were stopping, and assaulted them. In the melee, 3 of the assaulting party were killed, yet the prisoners were acquitted, for it was believed by them that they were in danger of great bodily harm. These, gentlemen, are Kentucky cases, and as well as the ones in Massachusetts and Tennessee to which I have alluded, appeal to reason and support the principle that it is not necessary for a man's life to be in extreme danger, that if he has good cause to believe it in peril, or to apprehend great bodily harm, he is justified in taking the life of his opponent. I have now, as I apprehend in a tedious manner, endeavored to show the law is applied to this case. I have cited the authorities to point out the difference between murder, manslaughter, and justifiable homicide, and I plant myself on the fact that we are sustained here by the principle of self-defense, that great principle which is recognized and respected by every citizen of Kentucky and every citizen of the United States. I will now refer to the testimony which has been addressed, but first permit me to allude to the gentlemen who have spoken on behalf of the prosecution. I do it with no disrespect, but if we would seek a parallel for their course, I know of no place where we would be likely to find it, unless we go back to the celebrated case of the Kilkenny cats. If they do not bear a remarkable resemblance to those famous animals, in view of the fact that they have completely eaten each other up, I am very much mistaken. The gentleman who spoke yesterday, Mr. Harris, joins in the anathemas that have been hurled at the devoted head of our witness Barlow, and following the example of the great H.X. Talleyrand of this prosecution, who denounced him as a liar at an early stage of his testimony, assures you that he does not believe a word he uttered, that Barlow never saw Butler, but obtained all his information in regard to the case from the schoolboys. Now the Herculean effort of Mr. Carpenter's speech was to prove that Barlow did not visit the schoolhouse at all, that he never saw the boys, and that those boys never gave any one the account of the transaction which Barlow has detailed here. We perfectly agree with the gentleman on one point, that this witness did not obtain his knowledge of the affair from the schoolboys, though we contend that they gave a history of it, in general terms similar to that which he received to 2 of our other witnesses, Allen and Gudgel. I only allude to the fact to show one of the many discrepancies between the counsel for the prosecution themselves. The gentleman has given you a scriptural illustration, comparing himself to David, who, as he tells you, went out to fight against the Philistines, armed only with the shepherd's sling and 7 smooth stones. Now we, I presume, according to his comparison, are the Philistines, but the gentleman seems to be rather unfortunate in his biblical recollections. He must remember it was against Goliath that young David went, and that it was Samson who fought with the Philistines, slaying 3,000 of them in one day, and that too with the jawbone of an ass. And I can only express a devout hope that I am not to meet with a similar melancholy fate, and be ruthlessly slaughtered here by the same dangerous weapon. In speaking of the testimony of the schoolboys, I would not be misunderstood. I allude to them in no disrespect, for I know them well. Their character is above suspicion, and they are sons of the first and the best families in our city. I honestly believe that there is not a single one of them capable of a willful misstatement of facts. But, gentlemen, there is a power behind the throne, which is greater than the throne. There is a man by the name of Sturgis, who, though a superintendent in the school, though he was present on the ground at the time, is not here. His testimony, it would seem, must have had some pertinence and some importance, but though he was subpoenaed to be present, he has not dared to darken these doors. I contend that he has infused ideas into the minds of these boys during his intercourse with them that have given an impression calculated to confuse and mislead their recollection. I contend such misrepresentations have been so often made to them as to render it impossible, however good their intentions and unimpeachable their integrity, for them to appear before you and give a correct, faithful history of the occurrence. And this man Sturgis, he who gives so exalted an idea of his courage by stating that when he saw his friend killed and he made his way out of the nearest window, who, when he reached Dr. Caspari's office, instead of asking them to send for a physician, might far more appropriately have said, I am the rider of the wind, the stirrer of the storm. The hurricane I left behind is yet with lightning warm. For if he had not kept in advance of the lightning on his flight, it was only because nature neglected to provide him with the ability to do so. This man, I must believe, has instilled into the minds of the schoolboys ideas not consonant to their calm judgment and their unaided recollection. Knight, Campbell, Benedict, and Quigley were the only pupils who were facing the parties and saw the transaction. The fact is an important one, for they corroborate to a great extent our witness Robert Ward, who has been so violently and unreasonably assailed. Now the testimony of Knight as to the conduct of Butler is contradicted by all three of the others. Campbell tells you that when he heard the lie given, he knew from the character of Butler there would be a difficulty, and intending that Butler might have the advantage of Matt Ward and whip him, he turned around to pick up the tongs and keep off Robert. Contemporaneously with this movement, and while his back was to the parties, the shot was fired. But what did Quigley see? I maintain that he saw a great deal. He testifies that he saw this prisoner pressed up against the wall by the deceased, and Benedict corroborates him, adding that he was bent down towards the earth by Butler's grasp, or giving that idea, if not expressing it in the same words. These, you should remember, are the statements of two witnesses for the Commonwealth, who stood with their faces towards the parties and saw the whole transaction. Campbell, it is true, has involved himself in the statement that Butler moved towards Ward, but he confesses that his back was turned, and that he only judged this was the case from a noise on the floor. Therefore, Knight is the only witness who can be said to contradict Benedict and Quigley in these important statements at all. I ask you, gentlemen, as I stand here in this temple of justice, with a full view of my responsibilities as a man and a lawyer, if I have not stated their testimony fairly. Worthington, it would seem from the history he gives of it, heard every word of the conversation, except when the lie was given. Yet does not this look a little singular, when he was at least 20 or 30 feet from the parties, and Pope, Campbell, Purtle, and Knight, who were much nearer, the latter being within 4 feet, only heard broken portions of it. I certainly do not charge him with willful misstatements, but gentlemen, you know what boys are. You know that in such a school there is always a leader, some juvenile Ajax, whose words when he speaks are echoed by all, and whose statements are adopted, impressed upon the mind, and believed to be true. On this principle I account for the inconsistencies of the school boys, but we have enough from them to show the general facts that Matt Ward and his brothers visited the schoolhouse, Willie being the last to enter, that Matt called for Butler, who came out, that Matt approached him, bade him good morning, and he bowed, and that when Matt desired a little conversation or an explanation, he invited him into his private room. The latter fact, you will remember, was first positively stated by Knight, though on the cross-examination he admitted to the court and jury he did not hear a single word of it, but that he had since received the impression. He spoke as confidently as any of the witnesses, yet he did not intend to tell a lie. He did not wish to perjure himself, and the statement only shows the fact I am contending for, that there is a power behind the throne greater than the throne. It is said that even men may repeat anything, however absurd, until they really believe it. And so with these boys, what they have stated they honestly believe. One point in the testimony of young Purtle is so remarkable that I would call your attention to it. He tells you that he caught the words ideas of justice early in the conversation. Now, what does Robert Ward say? That the first question asked by the prisoner was, Mr. Butler, what are your ideas of justice? And so this young man, whom they have attempted to impeach here, is corroborated from first to last. You must know, from the fact that have come before you, that he is detained in jail unjustly. And when the gentleman said that he stood, even now, with a halter around his neck, he made a proposition alike insulting to reason and to law. A man who does not know the law better than to believe this should study it long by the midnight lamp before he appears to practice in a court of justice. I deny the statement that if Matt Ward is acquitted, Robert must escape. Ipso facto, it is not law. In a few particulars, Robert Ward is contradicted. For instance, he tells you that the prisoner held his hat in his left hand and gesticulated with the right, while some of the boys state that from the first, his right hand was in his pocket or muffled in his coat. Now these boys were engaged in their studies when the parties met. I apprehended no difficulty, and I ask if it is not a remarkable fact that they should notice the position of a gentleman's hands when he entered the schoolhouse and appeared as gentlemen ordinarily do. Can you recollect whether your own hands were in your pocket or not when you came to that jury box an hour ago? Can you remember how mine were disposed when I rose to address you? And yet they testified thus minutely in regard to so trivial a fact, which transpired months ago, under no circumstances likely to cause extraordinary scrutiny. And this is only a part and parcel of the scheme of that power behind the throne, and its confederates, who are determined to be glutted in the blood of this interesting and innocent young man. They ask why William Ward was not introduced, and tell you that he saw the whole transaction. Now their recollection is very strange. They remember a great deal of testimony that I think never was given, and they seem to have forgotten a great deal that certainly was given. You must recollect it as appearing in proof that during the conversation between the parties, Willie was so earnestly engaged with young Johnston that they did not hear a word of it. It is easy to perceive, therefore, that Willie would give no testimony in regard to it. Yet because he is not introduced here, we are charged with suppressing testimony, and you are told that you must believe Robert Ward a perjured witness. I return to them and ask why Sturgis was not introduced. If I were allowed to do so, I would explain that he appeared as a witness in the examining court, and there made such statements that he is ashamed to appear and give testimony in the case again. And Dr. Caldwell, after they had subpoenaed him and brought him here, why did they neglect to call him to the stand and compel us to introduce him? A witness so important and so intelligent could not have been left out by accident. The secret lies in the fact that he fully corroborates Barlow. Yet the gentlemen talk to us about suppressing testimony, when this is the manner in which their whole case has been conducted, from first to last. As I said before, I do not bring aught against the honorable representative of the state, but I allude to these emissaries of blood, these men who profess to act from patriotic motives, when they are in reality only ministers of the vengeance of others, and the shekels of silver may be heard to rattle in their pockets. It is true that Robert Ward has been in jail for 6 months, but it is equally true that in order to be an aider and abettor of the crime charged in this indictment, he must have known the object and intention of the prisoner to be murder, even if such were his intention, which the testimony utterly precludes, and which I utterly deny. Suppose I meet you in the street and without telling you my purpose, take you with me to an enemy and kill him before your eyes. Can you be justly charged with aiding, abetting, and countenancing the act? Assuredly not. Yet in this case, and on such grounds, when his brother's life is in danger, they would have excluded Robert Ward from testifying because his name is in the indictment. But thanks be to God, it was before a judge who not only possessed too little hardness of heart, but too good an understanding of the law to make such a ruling. It has been related to you that when the parents returned from Cincinnati, the mother was told by the prisoner that her little boy, the darling of her heart, had been whipped and called a liar in the presence of the school. I know not what others may think, but I have 6 children, and I will never allow one of them even to call another a liar. Can you wonder at the feelings of a parent's heart when told that his child, the noble boy, his pride and his love, over whom he watched fearfully in sickness through the long vigils of the silent night, and in whom he hopes to live again, when he sleeps beneath the sods of the valley, has been publicly injured and disgraced? I endeavor to teach my children to love one another, and when they err, I take them apart and kindly tell them of their fault. Do not attempt to disgrace and degrade them in the presence of the family. Thus I hope they learn to regard their father as a friend in whom they may confide, an adviser on whom they can rely, and his house of refuge and a home in all their childish sorrows. You have heard the circumstance under which it was done, and I ask you if there was anything wrong in the act of this prisoner when he went to seek an explanation. Even admitting that he armed himself with the pistols, he knew that Sturgis, who was his enemy, was much larger and stronger than himself, and as Willie expressed it, had a big stick around there, and had he not the same right to take precautions for self-protection that any other man has? Look at the manner in which it was decided that Robert should accompany the prisoner. He knew that he was weak, utterly unable to sustain himself in conflict, yet he apprehended no difficulty, and it was not until his mother had repeatedly urged it upon him that, to gratify her, he impatiently told Robert to get his hat and come. On the way he assured him that he expected no difficulty whatever, that he had always found Butler to be a just man, and believed he would do what was right. Therefore he cautioned Robert not to interfere by word or deed. But Willie spoke up and reminded him of the stick, and then he repeated the injunction not to interfere, with the proviso, unless both Sturgis and Butler should attack him at once. And what does the conversation on the way indicate? Robert tells you that they met Lucy Stone in bloomer costume, one of these singular women who would exchange places with men and assume the breeches as the first step thereto, and that their conversation turned to the singularity of her dress. Does this denote a heart bent on mischief and filled with malignity towards a fellow man? On the contrary, does it not comport perfectly with the previous declarations of the prisoner that he apprehended no difficulty whatever? When Ward saluted him, Robert tells you that Butler bowed rather stiffly, and in answer to the questions that were put to him, he replied haughtily, "I will not be interrogated, sir." And when he utterly refused an explanation, Matt told him that for calling his brother a liar he must have an apology. The gentlemen have spoken as if the whole case hung on this point, and have denounced it as the language of the master to the slave. But you know the term must is used very frequently in cases where a wish merely is expressed. No imperious demand made, and Robert assures you that in this instance no particular stress was laid upon it. Then, when all explanation and apology were at last denied, he availed himself of the only satisfaction left, and denounced Butler as a scoundrel and a coward, even according to their own version of it, that the language he used was a liar and a scoundrel. How is the case altered? His little brother had been called a liar, and his heart was still bleeding from the injury and disgrace. There was no other way to vindicate him. Every peaceful expedient had been tried, and there was no other alternative. But the moment this is done, Butler springs at him, seizes him, forces him back to the wall and strikes him twice more in the face, and then he fires the shot. In the language of the decisions I have alluded to, had he not good reason to apprehend that great bodily harm would be inflicted? We have proved satisfactorily, by witnesses of the most honorable character, that even after the pistols were purchased, the prisoner was making preparations to leave on the following Monday for his plantation in Arkansas. We have offered this proof to show that his mind was engrossed, and contending that it could not have been so, had he then been under the influence of a heart bent on mischief, and contemplating such a diabolical act as the one that is laid to his charge. Butler was shot, was taken to Colonel Harney's residence, and there laid on the floor in front of the fireplace. Dr. Thompson was sent for and came to attend him. And here I must call your attention to a single fact. The counsel on the other side had contended that Matt Ward must be considered guilty because he purchased the pistols before he visited the schoolhouse. But when Dr. Thompson was brought to the stand, I asked the question whether he now had pistols on his person, and I think, with all due respect to the court, though I submitted readily to its ruling, that the question was legitimate and should have been pressed. There is no law against wearing arms, nor can the admission that he does so disgrace a witness. But the court decided that he need not answer it, and that I thought the witness grew up nearly as large as Satan and represented by Milton when the angels opposed his entrance into the gates of paradise. I contend that this sustains my position that arms may be worn with no violation of law or intent to do an unlawful act. Dr. Thompson is a member of the church and a teacher in the Sabbath school, yet I infer from his refusal to answer that he carries weapons. Mr. Allen, if the court please, I wish to inquire whether that is a legal inference. The court, it is not. Mr. Wolfe, true, but it is a rational inference. I consider the act neither unlawful nor disgraceful. In the British courts it would be a penal offense, but in this country the law is different, and this witness who, as I contend, we have a right to presume wore arms himself here, takes the stand as if he would say, "Dispel these clouds, the light of heaven restore. Teach me to see, and Ajax asks no more." Well, Dr. Thompson comes here, and he makes a very strong statement. I believe him to be a gentleman of honor, but I also believe that his feelings are so deeply interested in this case that they may have warped his judgment and his recollection. He tells you that Butler, in giving an account of the occurrence, said Ward came to the schoolhouse and cursed him and struck him, that he struck back and was shot. We contend that this was not the nature of the statement made by Butler. It is contradicted by several witnesses, among others, Barlow, on whose devoted head so much excited feeling and virtuous indignation have been vented by the counsel for the prosecution. Now I maintain that Barlow was a good man, as good as Dr. Thompson or anybody else. It may be that among the ruffle-shirted young men who promenade the streets of Louisville, with canes in their hands and an M.D. attached to their names, a poor carpenter who shoves the plane at $1.25 per day is not considered so respectable as they. But you, I am sure, wholly repudiate all such sentiments. Who is this Barlow? He is an honest mechanic, who works steadily at his business, and who has proved as good a character here as any man could desire. And we have shown that he stated precisely the same facts he has detailed to you to various persons, within an hour after the event occurred. Where could he have learned them then, if his statement be not correct? End of section 25. Section 26 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 18. Another witness for the prosecution, Dr. Yandell, who was with the deceased in company with Dr. Thompson and on the other side of him when he made the statement, tells you that Butler said, while they were engaged as I contend in that very scuffle of which Barlow and Quigley and Benedict and Robert Ward have all spoken. He struck Ward, and Ward shot him. And on being asked, did he say that Ward struck him at all? The witness replied, I did not hear him. He thought from the manner in which Butler raised his hand, he meant to indicate that Ward made a threatening gesture, but did not hear him say he struck at all. Dr. Caldwell also states emphatically that Butler told him when he was given the lie, he struck the prisoner for it. Now, here are two gentlemen of the most undoubted respectability and most honorable positions in life, gentlemen whose integrity is above all question, and yet they corroborate Barlow and contradict Dr. Thompson. Are you prepared to discredit them? But Barlow testifies that Dr. Thompson carried his case of instruments in his hand from the schoolhouse to Colonel Harney's, and the doctor tells you that he did not, that he never does it. And Mr. Carpenter assures you that Dr. Thompson is no quack, no charlatan, who must advertise himself by exhibiting the instruments of his profession as he walks the public streets. Are you to suppose that in such a case a physician would stop to consider so trivial a matter? Are you to suppose that when a dying man is in need of his services, Dr. Thompson must pause and carefully adjust his case of instruments in his pocket and button his coat over them, that they may not be seen, before he goes into the street, lest he should be considered a quack and a charlatan? Then how is Barlow discredited? I appeal to you if he is not fully corroborated, and if he did not prove here by reliable witnesses a better character. I speak only of his reputation for truth and veracity, not of general character, than even Dr. Thompson himself. If my recollection is perfect, 5 or 6 witnesses testified to this for him, while only 1 or 2 gave the same testimony in regard to Dr. Thompson. And has not all this insult and reduction of Barlow been utterly unjust and without cause? Then, gentlemen, how stands the case? This accused, this wan and feeble man, this invalid who, though 5 feet 10 inches in height, weighs only 110 pounds. With the sanction of his family, went around to the schoolroom of Professor Butler to ask an explanation which was justly his due. The man he visited was far his superior in strength, and though they have argued that one of his hands was disabled, we have shown that he possessed extraordinary muscular power, and that there was no reason to prevent him from striking a heavy blow. A dispute occurred. The explanation was refused. All apology and satisfaction were denied, and he then took the only redress in his power by denouncing Butler as his little brother had been denounced before. Then he was attacked, pressed back against the wall, struck and bent down, as you have heard, and he fired the fatal shot. They tell you he must have visited the schoolhouse to do a diabolical deed, with a heart bent on mischief and vengeance. His disposition utterly precludes the idea. We have brought here men that you respect and esteem, men you have honored by your confidence and support, and they all prove it wholly at variance with his character. Men have flocked here from all parts of the Union. The farm has left his plow, the mechanic his workshop, the lawyer has left his office, the doctor and the editor theirs, the soldier has come from his post, and the statesman from the halls of legislation, all to tell you that this young man is incapable of such a deed as they ascribe to him. One taunt that has been made here fills me with horror. The gentleman speaks of the visit of this accused to the holy mountain, where the will of God was first revealed to man, and advises him to go back and see if the Decalogue he there read, there be a command to do no murder. Now, gentlemen, I will read to you from this volume what he wrote from that sacred mountain, to the mother from whom his earliest impressions were received, and you shall judge whether it is the emanation of a heart capable of such a fiendish and wicked act as the one that is laid to his charge. He says, I stand upon the summit of Mount Sinai. What endless food for memory and association in the thought. To trace the course of Moses up to the sacred mountain, to visit the scene where our Lord deigned to hold converse with his servant, to feel yourself on Mount Sinai, upon which rests all that is earliest learned in childhood and most dearly prized by man, is worth a lifetime's weary pilgrimage. I forgot fatigue, anxiety, and all the weariness of the desert. I could only remember that I was upon Mount Sinai. Go there, if you would feel as you never felt before. Go read, as I have done, the Decalogue upon the very spot where Moses received it from the hands of the Almighty. Enter the cleft in the rock into which Moses fled as the glory of the Lord passed by. Remember that fearfully sublime scene, when there were thunderings and lightnings and a thick cloud upon the mount, when Moses brought forth the people out of the camp to meet with God, and the Lord descended upon the smoking mountain in fire, when the voice of a trumpet sounded long, and waxed louder and louder as Moses spake. And God answered him with a voice, and tell me if memory treasures another emotion like this. I have wandered with delight over the battlefield of Wagram, where Napoleon brought to his feet the most powerful monarch of the world. Leipzig had a melancholy charm for me at the spot where fortune united with allied Europe to put down her petted favorite. I felt a deep interest in gazing upon the plain of Waterloo, where that gigantic power expired, which had toppled kings from their thrones and made emperors tremble. These, thrillingly interesting as they were, are but scenes in the destiny of a man. Great as he was but mortal. But Mount Sinai is hallowed by the presence of God himself. It is the first scene connected with the salvation of man through the intervention of his Maker. After toiling to the highest peak of Mount Sinai, a mile and a half above the level of the sea, I gazed on every side upon widespread desolation. Far as the eye could reach, there was but a succession of sandy valleys and dark bleak mountains. It is a spot divinely chosen for the delivery of those two great tables which, for so many centuries, have formed the basis of all law, human and divine. Apart from every other nation so far removed from all the vices and follies of men, he brought them to Mount Sinai to hold communion with his chosen people through his prophet. There was nothing in the surrounding scenes to distract their thoughts or to harden their hearts against his counsels. No idolatrous neighbors to lead them astray, no worldly pleasures to amuse, no beauties of nature to attract. Bleak and desolate, Mount Sinai seems a spot made for an interview like that between the Almighty and Moses. The vast solitude by which it is surrounded had prepared the hearts of the people, by its immensity, for the reception of the holy charge about to be given them. In a desert waste so boundless, they had experienced a sense of their own littleness, and been bowed before the power of the Lord. All in the holy mountain itself is silent, barren, and desolate. Not a sound was heard, no living thing was seen, no verdure decked the granite crags of the mountain. All seemed to have been blasted by that dazzling halo, upon which no man could look and live, and the rocks which were scathed by the sacred lightnings of God appeared freed from nature's laws, and refused to yield like common earth the refreshing beauties of vegetation. The 10 Commandments have never seemed so impressive as when I read them amidst the rugged scene of their production. Their simple eloquence and powerful brevity were in accordance with the unadored grandeur of all around. Stripped of the worldly ornaments of elocution, like those towering rocks that bear no flowers, they startle us into admiration by their very boldness. Their elevated tone and imposing diction soar above all rules of rhetoric, as the gloomy majesty of the mountain scorns the soft beauties of foliage and flowers. Surely nothing less than divine eloquence could condense into 320 words the laws by which empires are governed and nations saved. Their brevity is beauty. Their eloquence is the absence of all show. It was the evening of the 11th day from Cairo, after a long and fatiguing march that our caravan entered the immense valley in which the host of Israel encamped before the mount. The sun was hidden from view, but his parting rays still played about the highest peak of Sinai. Never shall I forget the feelings with which I looked for the first time upon the sacred mountain, thus illuminated by the rays of declining day. All else around was dark. Deep shadows enveloped mountains and valley, but a gleam of light, like the Christian's hope, still rested upon the summit of Mount Sinai. The heart that could gaze unmoved upon a scene like this must be callous indeed. With me, every feeling was hushed into awe. I almost feared to advance. There was something so terrifically grand in the history and appearance of the mountain that I felt transfixed to the spot. Something in its frowning aspect seemed to forbid nearer approach. I felt my own unworthiness to do more than look upon it from afar off. Permit me, gentlemen, to read you one more extract from his Letters from Three Continents. The letter is written from that scene of the deepest interest to man the world has ever known, the Mount of Calvary. A man's deep emotions on visiting the Church of the Holy Sepulchre are chilled, not smothered, by the glaring glitter of the tasteless ornaments and images that load the hallowed spots within. I turned at once to Calvary and mounted the steps where our fainting Savior toiled up the rocky hill, when, turning to the women that bewailed and lamented him, he said in mournful forgetfulness of his own sufferings, "Daughters of Jerusalem, weep not for me, but weep for yourselves and for your children. For behold, the days are coming in which they shall say, Blessed are the barren, and the wombs that never bare, and the paps which never gave suck." I stood upon the spot where our Lord was nailed to the cross. The rock in which the cross was planted was before me, and amidst the gloom and silence of the dimly lighted chapel, I could almost imagine the fearful scene of the crucifixion, when the sun was darkened and the veil of the temple rent in the midst. I could almost see the two malefactors that were crucified with him, on either side one, and Jesus in the midst. I could hear the hootings and revilings of the enraged multitude, and that beautiful sentiment of forgiving meekness. "Father, forgive them. They not know what they do." I could see the crowds of women that had followed him from Galilee, beholding afar off, and witnessed the fierce determination of the soldiers. I could hear that cry of mortal agony, my God, why hast thou forsaken me?" And all was over. What could be more impressive than such recollections in such a place? My heart was softened even to weakness, and I could almost have wept, for that religious fervor which even the most worldly may feel on Calvary was blended in my heart with the feeling of earth most akin to heaven. A son's devotion to his mother. The Bible, from which I read the mournful story of the cross and passion, was her parting gift. It flooded my heart with hallowed associations. Thoughts of her and of heaven were blended in my soul, and purified each other. It recalled the never-to-be-forgotten instructions of my early childhood, when, leaning upon her lap, I heard from her loved lips explanations of the holy events of which I now read, upon the very spot where they occurred. It recalled the recollections of later days when side by side we sat in the village church. The exquisite music of those simple hymns that we sang from the same book seemed again to swell upon my ears, and I was a child in feeling once more. And whatever may have been my course since, those early impressions of piety have never been effaced, and the religious associations connected with those blissful days of innocence I now found had not died, but only slumbered, and but required a sacred spot like this to start into life, linked with a mother's holy name. Gentlemen, it is impossible that a heart like that of the prisoner, depicted in these lines, is capable of entertaining malice. His devotion to his fellow men, his devotion to his mother, his devotion to his God, all forbid the idea that he is capable of entertaining malice against any human creature. The act with which he is charged was the result of dire necessity, It was not an act of willfulness. Gentlemen, the fate of my client will soon be committed to your hands. What a responsibility will then rest upon you. Life or death is involved in the issue. What inexpressible joy a verdict for life will bring with it. This beautiful word will to him, as well as to those who are bound to him by such tender ties, present scenes of happiness and gladness. But oh, what gloom, what sadness, what misery would a verdict of death bring with it? That young and beautiful wife, the partner of his former joys, the participator of his woes, to know that her husband is to be assigned to an ignominious grave. That mother whose life has been a life of devotion to him, to have her heart riven by sorrow that can never be subdued. That family and wide and extended circle of friends, of which he is the rose and pride, to be crushed down forever. I cannot anticipate such a result. The evidence will not warrant such a verdict, and such a one will not, cannot be rendered by you. The achievements of this young man in the field of literature are part and parcel of the greatness of Kentucky. The emanations of his mind have added fresh glory to the history of our state, which the patriotic devotion of his ancestry had already rendered so illustrious. Shame not the history of our state with the pronunciation of guilty, because neither justice, law, nor humanity demand such a result. I have done. Mr. Crittenden, for the defense. Gentlemen of the jury, I agree with the counsel who have spoken on behalf of the prosecution as to the importance of this case. Its magnitude can scarcely be overrated. The state has an interest in it. It is not a desire for vengeance. The state seeks no vengeance against its own citizens, but its interest is a paternal one, like that of a father in the midst of his family. Its interest is that its laws may be administered, and that its citizens shall receive from that administration a just and merciful protection. The defendant has an interest in it. He has everything at stake: his life, his liberty, his character, and the feelings and sympathies of those who by ties of friendship or of nature are associated and allied with him. All these are at stake, and you are the men who have been selected to arbitrate and decide this mighty issue. Gentlemen, we all cause to rejoice that we live under a government which guarantees to every man the right of trial by jury. Without it, no free man can be touched in life or liberty. For ages this right has been the inheritance of our race. Our progenitors established it in the old world, and our fathers have struggled for it as a thing indispensable to the security of their lives and their liberties. You may wonder why it is they have been thus solicitous to preserve this right of trial by jury. You may inquire why they have not rather left it to the courts to try men who are charged with crime. The judges on the bench are usually able and honest men of superior wisdom to those who ordinarily compose a jury, men with greater knowledge of law and men of undoubted integrity. It is not so much from any distrust of the judges, or fears that they might be swayed improperly that this right has been preserved, but from a deeper and wiser motive. It is not because the people are equally learned with them, but because they are less learned. It is because the law desires no man to be molested in his life or liberty until the popular sanction has been given to his sentence, and his cause pronounced upon by a jury of his peers. The court is expected to render all necessary assistance in stating the law, but his cause, in passing through the minds and hearts of his equals who are trying it, will be divested of all nice technicalities and subtle analogies, and decided on its simple merits and according to the dictates of reason. The life of a man should be taken on no other judgment. You may lay down the law like a problem in Euclid. You may take one fact here and another there, connect this principle and that proposition, and then from one to the other reason plausibly and even logically that a man should receive sentence of death. But it was to avoid all this that this glorious right has been kept inviolate. It was to bring the accused face to face with his accusers, and to suffer only a jury of his equals, with their warm hearts and honest minds, to pronounce upon a clause involving his life or his liberty. This, gentlemen, as I understand it, is the object of jury trials. Were cases left to the judgment of the courts, a man's destiny might depend on some subtle and difficult question of law. But now it is different. When you consider a case, it is divested of all such questions and appeals to you as able to judge of the facts, as familiar with the passions and motives of men, as those who will rest it on its simple merits alone, and will only condemn for reasons that are sure and solid and satisfactory to your own understandings. You are a jury of Kentuckians, and I have too much respect for you, too much respect for myself, in this important case to deal with you by means of entreaty or flattery. But I may say that I have confidence in you, and that I look forward with sanguine hopes to the verdict you are to render. I expect you to do your duty manfully and firmly, and I expect you to do it, notwithstanding all that has been said to the contrary, mercifully. I expect you to do it on principles compatible with public security, and it is my duty to show you that you may acquit the prisoner at bar on such principles. The accused is before you in a house of Kentucky justice, and all vengeance must cease to pursue him. At this threshold, this is his sanctuary. Here the sway of the law is potent. Here the voice of justice, justice tempered with mercy, is heard. That voice which falls in sounds of terror on the guilty heart, but whispers in songs of seraphs, peace and joy to the innocent. The case, gentlemen, is one that demands all your attention. Thus far it has engrossed it, for I never have had the honor of addressing a jury in any case who have given during its whole progress evidence of more patient and unwearied attention. I am consoled by the belief that you know the evidence as well or better than I do, and I only ask that you will weigh it carefully in all its bearings and influence, making the proper discriminations, earnestly striving to ascertain the real motive of this accused, and then render that verdict which is demanded by your oaths and the laws of your land. End of section 26. Section 27 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 19. I will first proceed to an examination of the evidence and will then endeavor to bring to your attention the law I believe applicable to it, and I hope to satisfy you that the law, when applied to the facts, entitles the defendant to a verdict of acquittal, a verdict which, under all the circumstances of the case, would cause Mercy herself to rejoice. What, then, is the case briefly stated? William Ward, a boy of 15 years, and a scholar in the Louisville High School, returns home during the absence of his parents, and informs his elder brother that he has been unjustly and severely whipped by Mr. Butler, the principal. And though I could have borne that, brother, he says, I could not well bear to be called a liar before the whole school, my companions and my equals. I wish you would go and see Mr. Butler about it. It is 4 o'clock in the evening when he gives his brother information of the chastisement he deems so cruel and unjust, accompanied by such an appeal. That brother, the prisoner at the bar, determines to go around at once and ask an explanation. But supposing the school to be dismissed and the teacher not present at that hour, he concludes to wait until the following morning. Then the parents have reached home, but as the occurrence took place during their absence, he obtains the consent of the father to go around and ascertain the reason of it. He goes, and in a conflict in which he becomes involved, the death of Mr. Butler ensues. This is a general view of the case, but it is necessary for us to examine it more particularly. The purpose for which he went to the schoolhouse was undoubtedly a lawful one. If a child is whipped, particularly when the chastisement is so severe as to leave marks upon the limbs, I ask if it is not only lawful, but in fact a paternal duty to go and inquire the cause and learn why such punishment was administered. Certainly it is, and it is equally lawful and proper for the brother to go, especially when, as in this case, he has the consent and sanction of the father. The accused then stood in the place of the father and had the paternal right to go on an errand that took him to the schoolhouse. This point I consider settled. Why, then, are we to infer a malicious and wicked motive on his part for doing that which is clearly lawful and justifiable and proper? The correct presumption would certainly be that the motive was as good and lawful as the act itself. It is contended that he went with malice, but you have heard the testimony on this point. You have heard that of Mrs. Robert J. Ward, given in a tone and manner that must have carried conviction to your hearts, and you know what inducements and reasons there were for the defendant to seek an interview with Professor Butler. You have heard that the parents had just returned from Cincinnati, when the watchful eye of the mother observed Willie at home, and she asked why he was not at school. The little fellow, still mortified at the memory of his own shame, burst into tears and replied, "Brother Matt will tell you." And that brother did tell her, adding, "I had designed to have gone around to seek an explanation last night, but the hour was so late that the school was not in session, so I postponed it until this morning." When the father proposed that he should go, the accused replied, "This occurred while you were away, and I was here. And I think, father, you ought to let me go." And in fact, during the absence of the father, the accused was the head of the family. It was decided that he should go, and then Mrs. Wood indulged in one of those maternal anxieties and apprehensions that so often rise in the heart of the mother. He endeavored to quiet them, but when he was at the door, she suggested that Robert should go with him. He had made no request of the kind. He was not desirous of the company or assistance of his brother, but on the contrary, when it was urged upon him, replied, "I apprehend no difficulty. Mr. Butler is a gentleman, and as I only ask what justice demands, I am sure he will do all I desire. Gentlemen, I think this is no unimportant fact in tracing the motives of the prisoner. Even at last, when he submitted to the proposition that his brother should go, it was with impatience. He was reminded that Sturgis was his enemy, yet he went, knowing the justice of his intentions and fearing neither Sturgis nor anyone else, only acceding to the request of his mother to quiet her own apprehensions. This, I think, is a fair statement of the case. I desire to learn why and wherefore he went to the schoolhouse, and what were the motives that actuated him. And I think every circumstance speaks out that there was no wickedness in his heart, that he not only went to do what was proper and lawful, but to perform a duty that devolved upon him. Did Mr. Robert Ward apprehend difficulty? Certainly not. He knew Butler, knew the object and feelings of the accused. He swears to you that if he had even conjectured difficulty might ensue, he would have gone himself. And that mother, can you believe that when she parted with him at the door, she thought she was sending her son on an errand of blood, a mission of revenge? The idea is too horrible to contemplate. Neither the father nor the mother expected the least difficulty with Butler, though the prudent apprehensions of the latter suggested that there might possibly be some interference on the part of Sturgis. But Ward and Butler were friends. They had mutual respect for each other. Well, they left the house, Willie going along to get his books, and Robert at the instance of his mother. What was the conversation on the way? It may tend to throw some light on the question at issue. The testimony of Robert Ward, gentlemen, may require after more attention than I can give it at this point, but for the present it is sufficient to state that he did not know that his brother was armed, and that he had not the least expectation of difficulty. On the way, Matt tells him. It was not all detailed here, but this was evidently the burden of the conversation. I am going to seek explanation and apology for an injury done to Brother Willie. I did not want you with me. You are young and hasty. You do not know the circumstances of the case, and you might act indiscreetly. I apprehend no difficulty. Butler is a gentleman and do what is right, and I desire you not to have a word to say. It was as much as to say, I would you were at home, Robert, but now you are here. Do not interfere by word or deed. But little Willie, who has heard this injunction, says, Our brother, but Mr. Sturgis is there. Not Butler, but Sturgis. And you know he has a big stick. Matt replies, Why, I shall have nothing to do with Sturgis. My application is to Butler. Then he turns to Robert and adds, If, however, Sturgis and Butler both attack me, you may interfere. He conjectured the possibility of this only to soothe the feelings of the little boy. He had already made Robert passive, but listening to the suggestion must excite his anxious and brotherly apprehension. Therefore, he said, if such a thing does occur, which I do not expect, you may keep off Sturgis. Does this look like an intention to commit murder? On the contrary, do not all these circumstances go to exclude the idea of any hostile feeling, any malignant purpose, or any design to attack or do an unlawful act on the part of the accused? Further, to prove that there is no possibility of malice, we have shown you how he had been making preparations for several days, and even on that very morning to depart for his plantation in Arkansas. His mind was not bent on mischief, but engaged in a legitimate and proper channel. All the facts go to negative the presumption of malice, or of any wicked purpose. But he had been told, and he knew before, that Sturgis was his enemy. He knew that by some remote possibility the visit might lead to a collision and combat with him. He was very weak, utterly unable to resist any attack that might be made upon him, and therefore it was right for him to arm himself. Is it to be inferred because a man purchases a pistol and puts it in his pocket that he intends to commit murder unless it is indicated by some subsequent act? You are often in town, perhaps, and if you purchase a rifle there, will that fact subject you to any suspicion? But in town, the procuring of pistols is neither more remarkable nor more improper. It is true that when he buys pistols, a man may do it with an intention to commit murder, yet when he does an act which may be accounted for lawfully in 1,000 ways, but by a possibility may be improper and unlawful, is it right for us to conclude that he must be actuated by the worst possible motives that can be conjectured? In such a case, we were but accusing spirits indeed. What would be the condition of human society? What the relations of man to man were this doctrine carried out? A man may arm himself for a case of probable danger. He may do it with view to no specific occurrence, and he may do it in self-defense. Who can object to it? The Constitution guarantees to every man the right to bear arms. No law takes it away, and none ever can. The right of self-defense is an inherent one, given by God to man. It is our own natural right, and as Blackstone says, no human legislation can ever take it from us. But how nugatory and vain you render this right, if, when in pursuance of the laws of his country, a man arms himself for any possible contingency and remote danger, you impute to him unlawful motives and subject him to every sort of imputation of murderous intent. This precaution on the part of my client indicated no intention of violence. It may have indicated a purpose to defend himself in case of attack, but nothing more. Will you cast aside the 1,000 other natural constructions and adhere to that irrational and unsupported one, which makes him criminal? That were alike unreasonable and inhuman. But take all the circumstances and weigh them carefully, and you will see the motive as clearly as you see the act itself, and you will see no design to take life or to violate the laws of the land. Then what was the remainder of the conversation on the way? They met a young lady in bloomer costume and talked of the peculiar nature and fashion of that dress. What a subject for the conversation of a man within a few steps of the point where he intends to commit a malicious and cold-blooded murder. One of the gentlemen who addressed you for the prosecution announced, in the course of his argument, his disbelief that the accused purchased the pistols with the design to commit murder, or went to the schoolhouse for that purpose. If he did not, he had no criminal intentions. But within half an hour after, the gentleman, becoming more deeply engaged, says with violent gesticulations, Ward purchased those pistols with the intent to murder Butler. Thus he assumes contrary positions, and as both of these declarations are made by the same author, I suppose I have a right to receive which I please. I will choose the one, then, that I believe takes the only reasonable and truthful ground, that he had no such intent. But I will go no further on this point. I think it is fully established that the purpose for which my client visited the schoolhouse was a proper and lawful one. So far, then, we find no offense. When he entered the door, he was free from all malice and all criminality. Did anything occur there which made him a murderer? This is the next question for you to consider. You have heard the testimony as to what transpired at the schoolhouse. No one was there except Matt, Robert, and the pupils. Willie was in the room, but so engaged that he knew nothing of the interview. To prove the nature of that interview, 13 boys have been introduced here by the Commonwealth. Now, gentlemen, before I say a word as to the testimony of these pupils, I wish to have my position clearly understood. The counsel on the other side, with a triumphant air, have come forward and volunteered in defense of the truthfulness and veracity of these boys, but their services have been in advance of any occasion for them. They have only defended what is not attacked at all. Not one of the counsel for the defense has ever intended or sought to impeach the character of these witnesses. It may be asked, then, what circumstances justify us in the ground we assume as to their testimony. It must be remembered they are but a set of boys, and that they are testifying in regard to a circumstance in which their teacher was killed. They must have been under the influence of excitement and fright. The time which the accused spent in the schoolroom was at most not more than 5 or 10 minutes. When he entered, they were engaged in their studies, and it was contrary to an explicit regulation of the school to turn around and look up when strangers came in, and when so unexpectedly like a flame from the earth, this fearful occurrence broke out in the stillness of the schoolroom. What must have been the panic of these boys? You can imagine as well as I. It would not have startled men, the calmest and firmest in this jury box or this courtroom. Benedict, I think, gives a very just idea of the condition of all of them. He says, I was so much frightened that I couldn't think of anything or see anything hardly. And whatever the gentleman may contend, I believe this was the state of all the boys in the room. They may have seen Butler and Ward during the conversation in the early part of the interview, but this is all they saw clearly. One fact alone is sufficient to diminish the weight of their testimony. Not one of them heard all the conversation perfectly. The one or two are confident that they did. They are contradicted by the others who heard words and sentences which never reached their ears. No two of them give the same account of it, but on the contrary, there is much inconsistency and contradiction. It is evident that no one of them saw all the acts or heard all the conversation that passed, and this, in addition to the general panic that agitated their minds and confused their recollections, renders it impossible for them to give a fair and perfect history of the occurrence. Ah, say the gentlemen, but the panic was all after the firing of the pistol. Before this, up to the very moment when it took place, they can remember distinctly all that occurred. Is this rational? Is it according to the philosophy of the human mind? Was not the whole mind agitated and stirred, so that the things both immediately preceding and immediately succeeding were thrown into one mass of chaotic confusion? There is no other reasonable inference from the facts. Here, then, a parcel of schoolboys are brought up under these circumstances to testify in a case of life and death, to testify in regard to a conversation partly heard and acts partly seen. It becomes important that you should know with just how much confidence and with just how much allowance to receive their testimony. Supposing the fray were to occur here now, in this crowded courtroom, and the life of one of the parties to be suddenly taken, how many of the men who were present and witnessed it could give a correct and faithful account of the occurrence 5 minutes after it transpired? You know the character of the human mind, and you know that very few could do it. Transfer it in your minds, then, to the presence only of a parcel of frightened schoolboys. And after months have passed, do you believe they are capable of giving a full history of the affair, detailing all the events in the precise order in which they occurred, and even descending to the minutiae of the position of the hands? The mind, and particularly the youthful mind, under such circumstances is in a state of chaos, and the memory and the imagination combine until it is impossible to unravel the tangled web and come at the simple truth. I believe these boys to be intelligent and honest and high-minded and incapable of any intentional misrepresentation. But I believe at the same time that they are incapable of narrating the simple, uncolored circumstances of the case, and of giving testimony on which the life of a man ought to depend. Another thing, these boys from 11 to 18 years of age, since the occurrence of the principal fact we are investigating, have been the scholars and under the tuition and training of Mr. Sturgis, with all their natural sympathies on the side of their teacher, with all these other circumstances tending to give their minds a bias. They have been, from that day to this, under the authority and instruction of Sturgis, the enemy of Mr. Ward, the pursuer of this prisoner. You who understand the affairs of men will see the impossibility of a fair and faithful narration of the event from them under such circumstances. We well understand how this man, they not knowing it, by a word properly thrown in or a statement repeated until they were familiar with it and received it without question, may have exercised great influence and control over the feelings and recollection of these boys. He is their teacher and guardian. They are under his charge, and though he was sworn here as a witness for the Commonwealth, he was not introduced upon the stand. Put all these facts together, and it is your business, where the facts are not all known, but a few of potent character are established, to infer the others, weigh them carefully in your own minds, and then judge for yourselves of the probabilities in regard to the character of the testimony of these boys are not all in favor of the assumption I have made. Now let us examine the testimony, after the able manner in which it has already been reviewed and considered. It would consume too much of your time to enter into a minute repetition of its details, but I think I may safely say that from beginning to end, now 2 of these witnesses have perfectly agreed that their statements contain numerous discrepancies and contradictions, that the account of no one of them is probable and satisfactory, and that they all show, from their disjointed nature, they only contain portions and fragments of the facts that occurred. If there be any one thing in which there is more concurrence than on other points, it is with the statement that when the parties had exchanged salutations, Ward immediately asked, which is the more to blame, etc. Now, would not this be a most extraordinary manner for one gentleman to commence a conversation with another? 4 or 5 of them agree on this point, and if you receive their testimony, you must conclude there was no other introduction of the subject but that these were the first words uttered by the prisoner. Is it reasonable? Does not the very awkwardness of the question asked in such a manner indicate a chasm here, something which did not reach their ears, some preliminary, if not for the sake of ordinary courtesy, at least to give a comprehensible explanation of the business? And what says Robert Ward on this point? He tells you that Matt first informed Butler he desired some conversation with him, and after declining to enter the private room, giving as a reason that the event of which he wished to speak had occurred there, went on to inquire what were his ideas of justice, and then propounded the question mentioned, which in that connection came naturally enough. Thus, in the very commencement, Robert Wood gives you the only natural and satisfactory account of the conversation, and this fact alone is sufficient to show you the fragmentary character of the information possessed by the other boys. I know Robert stands here in a position which, by the law, exposes him to imputation, and it is your duty to weigh his testimony carefully, and not to receive it unless you perceive in it intrinsic indications of truth, or it is corroborated by other witnesses of whose veracity you can entertain no doubt. In this case, we call the witnesses of our enemy to corroborate him, and contend that even by them he is so fully sustained as to be entitled to your belief. One of the largest of these boys, and one who heard more of the conversation than any other witness who deposed for the Commonwealth, was Worthington. Yet he did not hear Ward make use of the term liar at all, and this he corroborates the statements of Robert. Again, Robert tells you that the accused introduced the conversation in a natural and reasonable manner by asking, "Mr. Butler, what are your ideas of justice?" Now, how is it that of these 13 boys, 12 leave this entirely out in their history of the conversation? How is it that, if their opportunities for hearing and seeing were as good, and their recollections as perfect as you are asked to believe, they all disclaim any knowledge of this language? But let us turn for a moment to the testimony of little Purtle, who frankly confesses he did not hear all that was said, and who is one of the finest and most intelligent boys in the whole school. He tells you that the first words he heard from the accused were something about ideas of justice and chestnuts. You must observe that the connection of subjects is a very singular one that would not be likely to be suggested to the mind of a schoolboy or anyone else, unless he had distinctly heard it. The minuteness with which this trivial point is recollected seems to give it more weight, and to indicate in no unimportant degree the truthfulness of the testimony given you by Robert Ward. Crawford corroborates him by the fact that he did not hear the lie given. Benedict states that when interrogating Butler, Matt asked, "Which is the worst, the boy, etc.?" though all the other scholars state that he used the term puppy. Now Robert tells you that when he asked the question the first time, he did so in the words detailed by Benedict, but that when no answer was given, he repeated in some irritation, and then changed the phraseology to "the contemptible little puppy." Though the particular may seem trivial, yet I think all these minute facts combined will enable you to form a correct opinion as to the general character of his testimony. Quickly confirms him. He tells you that Ward was forced back by Butler before the pistol was fired against the wall and the door. Is not this a corroboration that when Sturgis came out of his room, Robert told him to stand back? Not that he told him to come on, as related by some of the other boys. A statement of Quickly as to the condition to which Butler had reduced Ward agrees exactly with that of Robert, word for word. Campbell, however, contradicts Quickly in regard to the language used by Robert to Sturgis, and there are other contradictions between the boys on various points. I might pursue the subject further, but I believe it is unnecessary. I think I have demonstrated that but little reliance can be placed on the testimony of these schoolboys, because they do not agree, because of their numerous contradictions, because however pure their minds may be, it comes to you through all these circumstances of diminished credit, combined with the fact that they have been so long under the care of Sturgis, the enemy of Ward, and by that enmity, as I verily believe, the cause of the unfortunate event which occurred. End of section 27. Section 28 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 20. Let us look at the testimony of Robert Ward, and after what has been shown you, I think it is not asking or saying too much to claim that this is the only testimony which has brought order out of disorder, given the only connected and reasonable account of the whole affair, a consistent history of the events that transpired, natural in their course, and leading directly to the results that actually occurred. You have been told that according to the testimony of this witness, the accused told Butler he desired a private conversation with him, but no such word was used, as your own recollection of his language will readily assure you. It was a public investigation he desired, and when invited into the recitation room, he declined, saying, "No, Mr. Butler, the occurrence of which I wish to speak transpired here, and this is the proper place to talk of it." Could there be anything more natural or more proper than this? There the boy was whipped. There he had been called a liar. And there were all his companions who had witnessed the whole transaction. Butler might have said, "Here are the boys. They witnessed the occurrence. They know all the facts of it, and they shall be called up and the truth of the matter ascertained to your satisfaction." What was it they wished to ascertain? Merely whether Willie gave the chestnuts before or after the recitation order. If before, he had done no wrong and deserved no punishment. If after, he had violated the regulations of the school and was culpable. So upon that fact the whole question depended. What remained then for Butler to do but to call up the boys, investigate the matter thoroughly, and if he had done wrong, make that atonement which was due the injured feelings of the little boy? Would not a father have done the same? If in a moment of unreflecting haste and anger he had whipped his son and called him a liar, and the boy had afterwards come to him, asserting that he had done him a wrong, and desiring him to examine the evidence carefully and satisfy himself that this was the case, would he not have done it? With an overflow of paternal feeling and love, would he not readily go into the investigation and gladly learn that even though he had acted hastily and wrong, his opinion of his son was unjust and incorrect? If the request had been preferred to a stranger, even he should have acceded to it as an act of simple justice, and in view of the paternal relations of the teacher, in view, too, of the intimate and friendly relations of this teacher, when the proper person came to ask it, there should have been no assumption of dignity, no buttoning of the coat and haughty refusal to be interrogated. Would it not have been more in accordance with reason and justice, more in accordance with the real character of the excellent Mr. Butler, even if the question was propounded in a manner not exactly agreeable to his feelings, to have replied, "I will gladly do as you desire, and if I prove to have been in the wrong, no man living shall be more prompt to make the necessary atonement." Suppose he did see a little irritation in the manner of Mr. Ward, and suppose the method of propounding the question was not exactly compatible with his taste and feelings. As a good man, as a just man, as a prudent man, ought he not to have said, "I see you are irritated. I know your feelings are aroused, but let us fairly examine the case, and then, if we find I have been in error, I shall be proud to repair the wrong I have done." Would that have misbecome Professor Butler? Would it have impaired in any degree the proper and helpful discipline of the school? Not according to my conception of the matter. But unfortunately he did not take this course. When his attention is first called to the matter, he buttons up his coat and replies, "I am not to be interrogated, sir." Ward insists upon it. "Mr. Butler, I ask a civil question and I expect a civil answer. Which is the worst, the contemptible little puppy who begs chestnuts and then lies about it, or my brother William who gives them to him? There may be some objection, perhaps, to the language used here. The phraseology of the first question was better, but an answer was refused to it, and repeating it in a stronger form does not increase the criminality of Mr. Ward. He is assured that no such boy is there. Then that matter is settled. But why did you call my brother a liar? For that I must have an apology. As if to say, I have a just right to an apology under the circumstances. It is my due. I have no apology to make. Is your mind made up on that point? It is. I have no apology whatever to make. Then you must hear my opinion of you. You are a scoundrel and a coward. And here let us pause for a moment to examine the relative position of the parties at this point. The accused had gone to the schoolhouse for an explanation which was his due. It was utterly refused him, and thus that question was closed. He had then sought an apology, but that was denied him in terms equally emphatic, and that matter also was settled by the reiterated assurance that no apology whatever would be made. Then he used the language he did, and there, as I apprehend, the demonstration closed on the part of Ward. That was all he intended. He felt that his brother had been abused, insulted, and outraged, and when all other redress was superciliously denied, he took the only satisfaction that was left him by applying these terms to Butler. Do the circumstances indicate that he intended to follow it up further? I think not. In the natural course of events, he had retaliated, and there the matter must conclude. There he would have left it to rest forever. The next step was taken by Butler. They tell you he was an amiable gentleman, and there is no doubt of the fact, but they tell you also that he was a man of spirit. The facts show that he commenced the combat. Wood had reached a point where there was nothing more for him to do, but he was seized by Butler, whose hand grasped his collar or cravat, crushed back against the wall, bent down towards the earth, struck twice in the face to the certain knowledge of the only witness who saw the whole transaction, and then, but not till then, he fired the pistol to free himself from his assailant. This account of the transaction is perfectly corroborated by Quigley, as well as related by Robert Ward. Do you not believe it? Do you not see how it would occur in the reasonable and natural order of things? Even their own witnesses tell you that they knew Butler would not take such language, that when they heard it applied to him they expected a difficulty. This is the case proved by a portion of the testimony, and I think fully established by the better portion of it. I believe, then, we have clearly settled it, that the first assault was made by Butler, that he promptly and fiercely pursued it until he had placed his defendant in a position where he had a good reason to apprehend the most serious bodily harm, in a position of extreme suffering and extreme danger. Again, does anyone doubt that this was a sudden and casual affray, unexpected by either of the parties, 5 minutes before it occurred, after some conversation in which it is true harsh language was used? But it is a settled principle that no language whatever can justify an assault. Wood was suddenly assaulted and attacked, and then at a time when he was in great peril and suffering, he fired the shot, fired it, as we contend, in self-defense. The only means of protection he used were the pistol. It is not in proof that he struck a single blow. You see his form, and you can perceive there the most palpable indications of the truth of what you have been told by so many witnesses. His extreme weakness and delicacy. Do you think it probable that one with such a form, in so feeble a condition, would engage hand to hand in conflict with a man of ordinary strength? And according to the testimony of Mr. Joyce, you will remember that Mr. Butler was a man of unusual muscular power in the arms. The only pretense of a blow from the prisoner is founded on the testimony of one of the boys who saw him bring his left hand down with a gesture and thought he struck because he then saw Butler move from him. I do not speak of this to impair the testimony of the boy, but merely to show you another indication of the existence of those circumstances and influences that render it impossible for these schoolboys to give a faithful and perfect account of the transaction. Can you believe for a moment that a man in the physical condition of this prisoner, in his sober senses, would attempt to combat with anyone? Even with his right hand, it would be the most perfect folly for him to attempt to give a blow that would injure a child. And do you believe that with his left, he could give one that would cause a man in his full strength and vigor to fall back? It is utterly impossible. And with this fanciful exception, not one of those 13 boys saw a blow given on either side. That there were blows cannot be doubted. Butler himself stated it distinctly to everyone with whom he conversed in regard to the affray, before his death. And on such conflicting and uncorroborated testimony as this, you are asked to take the life of a fellow being. Gentlemen, I think I have stated the case fairly. I have certainly endeavored to do so. I have spoken of the testimony as it was given, according to the best of my recollection, and I believe it clearly establishes the fact that this prisoner was reduced to a condition where it was right and lawful for him to avail himself of any means of defense and protection that were within his reach. Now, what is the law that applies to the case? I shall not trouble you with much of it, and I will endeavor only to call your attention to that which is strictly applicable. Many cases have been cited for your consideration, some of them involving nice distinctions and subtle questions of law, in regard to which even lawyers and judges have hardly been able to satisfy themselves. Is it to be expected, then, that from sources such as these, you must reason and analyze and deduce the law it is your duty to act upon in a case of such magnitude as this? I think not. I think no conscientious man will desire to do it, and I am quite sure that you prefer to know something of the simple principles on which this great crime of murder is founded, and the circumstances and elements that go to make up its different degrees. I contend that according to all principles of law, the facts which have been developed in this case prove the fact for which the prisoner at the bar is arraigned to be neither murder nor manslaughter, but justifiable homicide. Though the words of the law may not be known to every man, yet the statutes thereof are written in his heart. You know what malicious killing is, what killing in the heat of blood is, and what killing in self-defense is, and your own judgments as well as your own hearts tell you that there is a wide difference between them. In morals and in law, the criminality of men's conduct depend on the circumstances under which they act, and the motives by which they are actuated. There is nothing more simple than the principles of common law on the crime of murder. Malice is the essential ingredient. It may be caused by some difficulty and grudge, but it must be indicated in that wicked state of mind, that distempered and depraved condition of heart, which show them to be bent on mischief. When a man kills another, under such circumstances and from such instigation, that is murder. But had this accused any such grudge or malice towards Professor Butler? None. If he had had ill feeling toward anyone, it was toward Sturgis, his enemy. For Butler he had no sentiments but those of friendship and respect. In his own language, he had always found him a gentleman and a just man. The act cannot be murder. But manslaughter, this is another gradation of the crime. When, in an unpremeditated difficulty, without malice or forethought, in the heat of passion, one man kills another, it is called manslaughter. The crime is not so aggravated as that of murder, as the malice does not exist, yet it is not excusable. For the heat of passion is no justification for trifling with human life, but the law, making allowance for the weakness and infirmities of our nature, considers this an extenuation and reduces the offense to manslaughter, where parties are engaged in combat on equal terms, and there being no occasion to resort to such means with self-defense and protection, one kills the other. He is guilty of this crime. But where a man in sudden affray is beaten or assaulted in such a manner as to peril his life, or place him in danger of great bodily harm, when there is no other way of escape, he has a right to kill his adversary, and the law calls it justifiable homicide, killing in self-defense. The law is very tender of human life, and therefore homicide, even in self-defense, is spoken of by the English authorities as excusable rather than justifiable, and thus the definition of it given by Lord Bacon is a blamable necessity. Yet though blamable, it is a necessity and it excuses and acquits the party. It is described as that whereby in a sudden broil or quarrel, a man may protect himself from assaults or the like by killing the one who assaults him. But it must not be used as a cloak for a revengeful and wicked heart, for we are explicitly told that we may not exercise it, but in cases where sudden and violent suffering would be caused by waiting for the intervention of the law. Language cannot be plainer than that of this distinguished author, Judge Blackstone, and this, he says, is the doctrine of universal justice, as well as municipal law. It is another principle equally well established, that except in cases of extraordinary violence, where it cannot be done without subjecting him to enormous peril, a man must retreat to the wall, or to some other impediment which he cannot pass, before he may take the life of his adversary. Gentlemen, I shall trouble you with but few more extracts from this or any other author. You see in what justifiable homicide consists. You see that you have a right to kill when you cannot otherwise escape death or severe bodily harm, but that you must exercise this right only in a case of extremity, only in sudden affray, only when subjected to a condition where you can no longer defend yourself but by killing. It is not every blow that necessarily gives the right to take life, if the person be not injured, the blows not severe, and the parties not unequal in physical strength, or the one who is assaulted may retreat without further harm. The homicide is not justifiable. Cases have been read to you that if a man provoke a contest himself, for the sake of obtaining a pretext to carry out the malignant and wicked purpose of his heart, and during it kill his opponent, it is not excusable, but is murder. I think you readily perceive, however, that this principle is totally inapplicable here. If A pursue B with malice, seeking an opportunity to kill, and provoking a quarrel that he may do so, carries out his purpose, the act is murder. Mr. Gibson read to you yesterday a case of this kind, but there the defendant sought no quarrel, no combat, no difficulty. He sought a reconciliation. With what propriety, then, do the gentlemen attempt to confound in your minds cases where men are seeking to exercise the malice of a wicked and revengeful heart with such a one as this? They have no connection whatever. End of section 28. Section 29 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 21. It is a well-established principle, Wharton's American Criminal Law, page 311, that no words will amount to an assault, And page 313, that no words will justify an assault. Mr. Ward had made no assault. It is true he applied appropriate words, but they neither constituted nor justified one. The gentlemen have told you here, and their witnesses have testified to it, that Mr. Butler was a man of courage, who would not receive such language without giving a blow in return. I do not complain of them for showing that he was a man of spirit, but I do contend that they have no reason to look to the law for any justification of his conduct. He had no right under the circumstances to take redress into his own hands. The principle is laid down in so many words. He was first in fault. He made the first assault. Ward was forced back until he could retreat no further. In the literal language of the law, he had been driven to the wall, and there pressed back and bent down and beaten in the face by his adversary. He shot him. Now, gentlemen, have I not brought this case not only within the principles, but within the exact words of the law relating to justifiable homicide? And I have not done it by relating to subtleties and technicalities, but I have proved it on the natural and eternal principles of self-defense. We are told that where there is any other probable mode of escape, without losing life or receiving serious injury, a man is not justifiable in killing. True, but I am not aware that any such possibility existed here. The prisoner was confined and beaten, as you have heard. Campbell was just taking the tongs to give his assistance if necessary, and Sturgis also was in motion. I will say no more about the extreme debility and feebleness of the accused, for you know it and can perceive it. You also know, notwithstanding the assumption of the prosecution, that Butler was a man of more than ordinary muscular power, that he had been for years in the habit of practicing, both in the gymnasium and out of it, those exercises that tend as directly to develop and strengthen the muscles of the arm as the habitual wielding of the blacksmith's hammer. The many excellent qualities of the deceased, and his virtuous character, I freely admit. I deplore his death. The ill-fated circumstances that led to it are all before you. That death has been the effect of circumstances, unfortunate circumstances, but without any premeditation or malice on the part of the accused. The same circumstances which show that his hand inflicted the fatal blow show, from the nature and suddenness of the occasion, that there was none of that malice or wickedness which alone could make it a crime. His character, too, pleads, like an angel's voice, against such an imputation upon him. In his state of feebleness or irritation, he may have naturally overrated the violence and injury with which he was threatened, and the necessity of protecting and defending himself by shooting the deceased. But surely a man in such a condition is not to be sacrificed for a misjudgment of the exact degree of the necessity which warrants him in such a defense. You will make all just and humane allowances on this subject. You, sitting here in quiet, solemn consideration, must yourselves feel some difficulty in deciding the exact degree of violence with which he was threatened, and the lawful extent of the defense which it justified. How, then, are you to expect him to decide these questions in the strife and passion of the moment? The decision in Tennessee, to which your attention has been called, establishes the principle that if a man, from good reasons, believes his life or his person to be in danger, he has the right to kill. He must act upon the instant or not at all, in the heat of passion and conflict, and when his means of observation are limited. The real question here is whether Matt Ward, in his feeble and reduced condition, did not apprehend, and that from good reasons, that he was in danger. If he did, there was no guilt, no criminality, and he deserves an acquittal. The gentlemen for the prosecution have spoken of the declarations of Mr. Butler on his dying bed. Now, the inquiries of Dr. Thompson were made for the purpose of ascertaining a medical fact. He desired to learn what was the position of Butler when he received the shot, and Butler replied to him that they were clenched. The arm of Professor Butler was raised, and it was then found that the probe followed the wound, at least for a short distance when before it did not penetrate at all. This demonstrates anatomically, naturally, necessarily, that Butler and Ward must have engaged in combat when the fatal event occurred. Why was the hand of Butler raised if he was not engaged in a struggle? This is the legitimate inference from the testimony given by Dr. Thompson. But Barlow was present at the same time, and while Dr. Thompson was engaged in taking out his instruments and preparing to attend to his professional duties, he, with a curiosity perfectly natural, inquired how this had happened. A man had been shot down under peculiar circumstances, and it was not strange that Barlow should follow him to Colonel Harney's residence and ask how it had been brought about. Butler replied, "He gave me the lie and I struck him for it. Then he shot me." According to this, Butler admitted that he struck the first blow. It is true, he was provoked by the language used, but you have been reminded that neither those nor any other words justify a blow. But the counsel for the Commonwealth contend that Butler could never have made these statements, simply because Dr. Thompson did not hear them. The doctor himself, however, has told you that there were 5 or 6 persons in the room, and you can judge for yourselves whether a physician under such circumstances, when his mind was engaged with his professional duties, would be likely to recollect very accurately. Barlow states that he was there, and he was there. He has minutely described the position and clothing of Butler, spoken of the brandy sent for by the physician, and by relating many other facts trivial in themselves, has demonstrated beyond a doubt that he was present. The conversation Butler held with him was in answer to a direct question to ascertain his history of the occurrence. His reply to Dr. Thompson was to state the scientific fact of the position of his hand. Well, Barlow has been spoken of in strong terms here. He has been terribly denounced, and if any words could justify an assault, the language that has been applied to him would certainly do so. But it cannot. Lawyers, as well as other men, have their own peculiar privileges, and I am sure I have no desire to see them diminished. Of the course of the counsel for the prosecution, I admire the most that of Mr. Gibson. Mr. Carpenter's abuse of this witness seemed to be spontaneous. He rejoiced at an opportunity to exercise the peculiar talent he possesses for that style of argument. But Mr. Gibson tells you that he considers it out of place, that he will not indulge in it, and maintaining that the witness is perfectly annihilated, magnanimously informs us that he will not trample on the dead. I never saw this Barlow before, but how does he appear to you? What impression has this man left whom the lawyers, not the law, not the court, but a few lawyers have so earnestly attempted to degrade in your estimation, have cast a ban upon, and excommunicated so peremptorily from the society of all good men? I care very little for his testimony. We had other evidence sufficient to establish the facts he has proved. But I believe all the attacks to be gratuitous and unjust. He may in some respects have acted foolishly. He may have been imprudent, but we have every reason to believe that he is not dishonest. Within half an hour after it occurred, he told Mays and Sullivan of his visit to Colonel Harney's and the conversation with Butler, and soon after this he related the same fact to Mr. and Mrs. Crenshaw. Yet Mr. Carpenter tells you that he fabricated the story because he was fascinated with the idea of associating in a wealthy and aristocratic family, because he sought to obtain a view of the interior of the house of Mr. Robert J. Ward. How do they reconcile this with the fact that he then made the same statements, which he has made here to 3 witnesses of the highest intelligence and respectability? He stands confirmed, as far as a witness can be confirmed, and if any stain has been cast upon him here, it has only been by the lawyers who have made him the subject of their abuse. He has proved the most unexceptionable character by the mayor of Louisville and other gentlemen who are above imputation. In the eye of the law and of his fellow citizens, he is perfectly credible, and so far as any testimony he has given in this case is concerned, he may be relied on by you as safely as any other witness who has testified in it. These statements of Butler to which Barlow has deposed accord perfectly with the testimony of Robert Ward. You could expect no details from a man under such circumstances and in such a situation as Butler. He only gave a general description of the occurrence, but Robert has given you the details. And Professor Yandell, who was present at the same time, does not tell you, like Dr. Thompson, that Ward came to the schoolhouse, cursed him, struck him, and shot him, but gives quite another account of his statements. He speaks of him raising his hand, as he thought, to indicate that the accused had elevated his in a threatening manner. But you all know how common the habit of raising the hand in conversation is with some men. Dr. Thompson, it seems, heard no word of those statements which were made to Professor Yandell, and the discrepancy between them is not surprising, for as they were engaged at that moment, the cause of the occurrence was a matter of secondary importance, not one of peculiar interest to them. Here, gentlemen, I beg leave to recur for a moment to the circumstance which I must confess has surprised me. It was the general evidence of the schoolboys that Ward entered the house with his right hand in his pocket and gesticulated with the fingers of his left. Is it not wonderful that a fact so immaterial, so little likely to attract attention, as the circumstance that a gentleman had his hand in his pocket, and which of the hands he had there, should be remembered with so much accuracy by so many of these witnesses, so long after its occurrence? But you perceive that it has been made a matter of considerable magnitude here. No doubt Sturgis thought it was important to show that the right hand was on the pistol all the time, as if in a sort of conspiracy with it, to act jointly at precisely the proper moment, and rather than destroy this hypothesis, they would have you believe that if the accused struck a blow, it was with his left hand. Now you can readily perceive why they would like to keep the right hand of Matt Ward on that pistol during the whole time. And I have no doubt that these boys have ever and anon heard the statement made in so many conversations, held for the purpose of assisting their memories, that they are now convinced the hand really was in that position, and that they saw it there. Again, they contend that Butler struck, if he struck at all, with the left hand, and therefore that the blows could have inflicted no injury. Now, if his right hand had been so long and so utterly crippled, as they have attempted to show, it must certainly have been a non-combatant, and the left hand must have learned years before to perform all the offices of the right. Thus their presumption is effectually destroyed. You have been sitting here, gentlemen, for 8 days. Can you tell whether your hands were in your pocket when you came in this morning, or on any other morning? Can you tell the position of the hands of any of the counsel as they rose up to address you face to face? As you have been seated at home in your own house and visitors have entered, can you recollect the position of their hands? Yet a fact so trivial and unimportant at the time, one which could then be of no possible interest, for no difficulty was apprehended until Butler had collared Ward, is related with this minuteness. I would suppose that not another human being in the form of a man have entered that schoolroom, in regard to whom so many boys can recollect distinctly the position of his hands. Whether the hand was in his breeches or his coat pocket is not a matter of so much importance, and therefore not remembered so well. Gentlemen, you must be convinced that the recollection of such a fact under such circumstances is utterly impossible. And he gesticulated, they say, with his left. Why should he not let the right hand to do the right hand's work? Why should it be kept on that pistol? The idea is absurd. All the circumstances show that he at first expected no difficulty. Who believes this? Who does not know that, however unconscious of it the boys may be? This is the work of a strained imagination, supplying the place of a strained memory. Sturgis, as you have heard, had administered a whipping to the boy on a former occasion, the facts of which we desired to introduce here, but we were not allowed to do so. Is it not probable that, instigated by his enmity towards the wards, when he heard of this punishment, he advised Butler to refuse all explanation and investigation? The circumstances of the case, the position of Butler and Ward, their friendly relations, the just and reasonable demand that was made, all show the refusal to have been inconsistent with his character and his heart. Is it not a rational inference, then, that he may have been prompted by the sinister, subterranean motives of another man, who desired to minister to his own anger and ill-feeling? I think it was not like Butler, when he was asked such a question by a man he knew so well, and esteemed so highly, to button up his coat and answer haughtily, "I am not to be interrogated, sir." But it was like Sturgis. Gentlemen, I am consuming much of your time, but I believe the case is clearly comprehended by you. I think I have made up the facts and made out the law. I think you are satisfied that the pistol was not fired, so far as can judge, until there was no other way of rescue for the prisoner from the peril of his life or of great bodily harm. I think you understand the principle that the law holds all such bloodshed justifiable, though blamable, yet excusable. This, then, is the condition in which the prisoner stands, and upon these plain facts and these great principles, I think I may base my argument. But there are other points in this case to which I feel it my duty to refer, notwithstanding the circumstances we have made out. This young man has been persecuted and denounced from the first as one of the vilest of men and of murderers. He has been held up to the world as the perpetrator of a deliberate and diabolical outrage, an act of fiendish malignity, for which there was no particle of mitigation. For months and months he has been thus pursued, with misrepresentations and revilings. This version of his case has been spread upon the wings of the wind, through the columns of the press. Now, it matters not in effect whether these publications were made from the basest of motives, or in all sincerity and truth, by those who were deceived by his persecutors. They were made. These rumors have gone abroad, anticipating the result of this trial. But you see how little his real case is like the one that has been represented to the world. His only refuge is in your verdict. Through all this persecution and these revilings he has passed. Now, thank God, he waits the decision of your calm judgment. I said his persecution was over, but through those associated with the prosecution of this case, with my friend Mr. Allen, it all seems to have been concentrated here. The first of them, Mr. Carpenter, was eloquent in denunciation of the prisoner. What necessity was there for this? It is his duty to convict upon the law and the testimony. But what right has he to turn from you to the accused, and assure him, if you do not feel warranted by the facts of the case in finding him guilty, he will be pursued through all time by some horrible monster the speaker's own imagination has conjured up? What unsolicited and perfect insolence to persecute a man, and in case the prosecution cannot be sustained, to threaten him with a fate as cruel as any verdict you can bring. Is this practicing law according to its spirit? Is it necessary when a prisoner is in the custody of the law, his hands and his tongue tied, for a prosecutor to feed his little vengeance in such a manner as this? Sir, it is intolerable. It was never equaled. Let us come to a later instance, from our brother and our friend Mr. Gibson. Was such language ever heard before? Should a man when on trial for his life be denounced as a damned villain, and his act as a damnable crime? Is not this a singular and improper course to pursue towards an unfortunate prisoner? Is it not a light cruel to him and disrespectful to the jury? Your duty, gentlemen, is too responsible to suffer you to think of the subject in such terms. There is no congruity between your solemn thoughts and such language as this, and I have no fears that you will allow it to influence them. My friend, Mr. Gibson, is a man of great impulses, and when not excited, of generous impulses. In an early stage of his argument, he tells you, more in accordance with the facts, more in accordance with the love of justice existing in his own manly heart, that he believes the accused sought the schoolhouse of Professor Butler without an intention to do violence. But afterwards, when his feelings are more excited, when his impulses are brought up to the prosecuting point, he declared in tones that vibrated through this courtroom his belief that he went there to play the part of an Italian assassin. Is not this a little inconsistent? At one time he tells you that he shall be glad to see it done, if you can find any satisfactory grounds for his acquittal, and again, that if you do acquit him, he shall believe all the tales he has ever heard, that justice has fled from the borders of old Kentucky. Furthermore, he would have the bereaved mother train the child of the deceased to follow the track of this prisoner, like a bloodhound, and never rest until his hands were red with his blood. What? Would he have that mother with her heart softened by premature sorrows? Instill into the tender mind of the child such horrible instincts as these? Did he really mean this? I am sure he did not, and I only allude to the fact to show with what fierceness and ardor this prosecution has been pursued. It has been carried on with a persistency and passion that would not even allow its conductors to keep within the bounds of propriety or consistency. I now remember another of those flights of Mr. Carpenter, to which, as it involves something more than mere words, I would call your attention. Not satisfied with urging you to do it, in pursuance of what he deems your duty to yourselves and to society, the gentleman asks you to convict this man that it may be an event of joyful remembrance to you when you appear before your Maker. He assures you it will be a great solace and consolation to recollect that, when a fellow man was brought before you and his fate consigned to your hands, you convicted him. He would have you tell the judge of quick and dead, when you stand at his tribunal, how manfully you performed your duty by sending your fellow man to the gallows. He apprehends that it will go a great way to ensure your acquittal there, and your entrance to the regions of eternal bliss, if you are able to state that you regarded no extenuating plea, took no cognizance of the passions and infirmities of our common nature, showed no mercy, but sternly pronounced his irrevocable doom. I understand that it would be more likely to send you in a contrary direction. I understand that a lack of all compassion during life will hardly be a recommendation there. I understand that your own plea will then be for mere mercy. None, we are taught, can find salvation without it. None can be saved on their merits. But according to Mr. Carpenter's idea, you are to rely there, not upon that mercy for which we all hope, but on your own merits in convicting that ward. Don't you think the gentleman rather failed in the argumentative portion of his point? It seems to me he would have done better to take you somewhere else for trial. I have somewhere heard or read a story from one of those transcendental German writers, which tells us that when the Almighty designed to create man, the various angels of his attributes came in their order before him and spoke of his purpose. Truth said, "Create him not, Father. He will deny the right, deny his obligations to thee, and deny the sacred and inviolate truth. Therefore, create him not." Justice said, "Create him not, Father. He will fill the world with injustice and wrong. He will desecrate thy holy temple, do deed of violence and of blood, and in the very first generation he will wantonly slay his brother. Therefore, create him not." But gentle mercy knelt by the throne and whispered, "Create him, Father. I will be with him in all his wanderings. I will follow his wayward steps, and by the lessons he shall learn from the experience of his own errors, I will bring him back to thee. And thus, concludes the writer, learn, O man, mercy to thy fellow man, if thou wouldst bring him back to thee and to God. Gentlemen, these lawyers have endeavored to induce you to believe that it is a duty you owe, even to mercy yourself, to convict this prisoner, that you have nothing to do with mercy, that there is a governor somewhere, a good, kind-hearted man who may exercise it if he chooses, but that you have no right to show mercy. And pray, what are you? Yesterday you were but men, just men, kind men, and merciful men. Tomorrow, when you have left this jury box, you will be the same again. But according to the ideas that have been advanced, you must divest yourself of this attribute when you enter here, and become men of stone, mere mathematical jurors, with no more feelings and sympathies than if you were marble statues. Is this right of trial by jury? Is this the principle our fathers contended for, fought for, died for? If it be, I can only say it is not worth the struggles that have been made for it. It is a merciful law, gentlemen, you are called upon to administer. I desire to see you do your duty. I desire that the law should be obeyed and enforced, but in the matter of the facts you have the exclusive right to judge. I agree with the gentleman that you have no right to show mercy where the facts will not warrant it. But it is your duty alone to consider these facts, put them together, and upon them found your verdict. In examining these facts, may not one judge of them more kindly, and hence ascribe better motives than another? The consideration of the facts and the causes that produce them is the proper place for mercy to be applied. The law says the murderer shall be punished, but it is your province to ascertain what constitutes the murderer. You have a solemn duty to perform, and I want you to perform it. I want you to perform it like men, like honest men. I ask your sober judgment on the case, but it is right for the judgment to be tempered with mercy. It is according to the principles of law, one of whose maxims tells you it was better for 100 guilty men to escape than for an innocent one to be punished. Is not here your commission for mercy? It is alike your honest minds and your warm hearts that constitute you the glorious tribunal you are, that make this jury appears one of the noblest institutions of our country and of our age. But the gentleman would make you a set of legal logicians, calculators, who are to come to your conclusions by the same steps a shopkeeper takes to ascertain the quantity of coffee he has sold by the pound. That may be a jury in name, but it is in nothing else. But I wish to call your attention to another fact that figures in this case. Mr. Carpenter, with more adroitness than Mr. Gibson, but with less scrupulousness, has attempted to create a prejudice against this prisoner by speaking of his family as aristocratic, as believing themselves better than ordinary mortals. I suppose I feel no personal offense at this, for I have always belonged to that class usually called poor men. But in this country, no man can be above a freeman, and we are truthfully told that poor and content is right enough. Do you not see the object of all this when the gentleman speaks in his peculiar tone of ward house, and tells you that a ward had insulted, a ward had been whipped, and therefore the stain must be wiped out with blood? Do you not detect the low, unjust, unrepublican attempt to create a prejudice against this prisoner? What right have they to do this? The charge is personally an outrage upon him. The assumption is false, and we all know that before our laws, every man, whether he come from the cabin or parlor, whether he be rich or poor, holds the same position, has the same rights and the same liabilities with all other men. Why then attempt to excite this low, vulgar feeling towards Mr. Ward? Why seek this, to prejudice your minds against him and his? I am sure that if the gentleman expected any response to such low envious sentiments in your hearts. He made a grave mistake. There may be those who hate all men who are unable to imitate. But you, I presume, are willing to see all your countrymen enjoy any position they have honorably obtained in whatever manner they please. End of section 29. Section 30 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler. Kentucky, 1854, Part 22. In conclusion, gentlemen, I beg leave to call your attention to an important consideration, bearing on the whole case and affording a key, I think, to the heart of this young man. I allude to his general character and disposition through life. I need not call your attention to what we have shown it. It is all perfect in your recollection. I have no occasion to exaggerate. He has shown in the clearest and most conclusive manner a character of which you or I or any man living might be proud. As in boyhood, so in manhood. His riper years only exhibited to the world the amiable and lovely and genial traits of the boy, more illustriously developed in the man. I am one of those who believe in blood and inconsistency of character. Show me a man that for 20 or 30 years has been kind and honest and faithful in all the relations of life, and it will require a great deal of evidence to induce me to believe him guilty in any instance of a gross and outrageous wrong. You have seen the character of this man from his earliest childhood, so kind, so gentle, so amiable, ever the same at school and at college, in the city or in the country, among friends or strangers, at home or in foreign lands. There was no affected superiority. You see how mechanics and artisans have been his constant associates and friends, with health impaired and with literary habits, never seen in drinking saloons or gaming houses. His associations with men of all classes, he has ever been the same mild, frank, and unoffending gentleman, respecting the rights of others and only maintaining his own. This is the man you were called upon to convict. His act was an unfortunate one, but it was one he was compelled to do. And though he has been misrepresented and reviled and wronged, I trust it will be your happy privilege, by a verdict of acquittal, to vindicate his character in the eyes of all good men, and restore him to that family whose peace, happiness, and honor are at stake on your verdict. Your decision must cover them with sorrow and shame, or restore them to happiness that shall send up to heaven, on your behalf, the warmest gratitude of full and overflowing hearts. Gentlemen, my task is done. The decision of this case, the fate of this prisoner is in your hands. Guilty or innocent, life or death, whether the captive shall joyfully go free or be consigned to a disgraceful and ignominious death, all depend on a few words from you. Is there anything in this world more like omnipotence, more like the power of the eternal, than that you now possess? Yes, you are to decide, and as I leave the case with you, I implore you to consider it well and mercifully before you pronounce a verdict of guilty. A verdict which is to cut asunder all the tender cords that bind heart to heart, and to consign this young man in the flower of his days, and in the midst of his hopes, to shame and to death. Such a verdict must often come up in your recollections, must live forever in your minds, and in after days when the wild voice of clamor that now fills the air is hushed, when memory shall review this busy scene, should her accusing voice tell you that you have dealt hardly with a brother's life, that you have sent him to death when you have a doubt, whether it is not your duty to restore him to life. Oh, what a moment that must be! How like a cancer, Will that remembrance prey upon your hearts? But if, on the other hand, having rendered a contrary verdict, you feel that there should have been a conviction, that sentiment will be easily satisfied. You will say, if I erred, it was on the side of mercy. Thank God, I incurred no hazard by condemning a man I thought innocent. How different the memory from that which may come in any calm moment by day or by night, knocking at the door of your hearts, and reminding you that in a case where you were doubtful, by your verdict you sent an innocent man to disgrace and to death. Oh, gentlemen, pronounce no such, I beseech you, but on the most certain, clear, and solid grounds. If you err, for your own sake as well as his, keep on the side of humanity, and save him from so dishonorable a fate. Preserve yourselves from so bitter a memory. It will not do then to plead to your consciences any subtle technicalities and nice logic. Such cunning of the mind will never satisfy the heart of an honest man. The case must be one that speaks for itself, that requires no reasoning, that without argument appeals to the understanding and strikes conviction into the very heart. Unless it does this, you abuse yourselves, abuse your own consciences, and irrevocably wrong your fellow man by pronouncing him guilty. It is life, it is blood with which you are to deal, and beware that you peril not your own peace. I am no advocate, gentlemen, of any criminal licentiousness. I desire that society may be protected, that the laws of my country may be obeyed or enforced. Any other state of things I should deplore. But I have examined this case, I think carefully and calmly. I see much to regret, much that I wish had never happened, but I see no evil intentions and motives, no wicked malignity, and therefore no murder, no felony. There is another consideration of which we should not be unmindful. We are all conscious of the infirmities of our nature. We are all subject to them. The law makes an allowance for such infirmities. The author of our being has been pleased to fashion us out of great and mighty elements, which make us but a little lower than the angels. But he has mingled in our composition weakness and passions. Will he punish us for frailties which nature has stamped upon us, or for the necessary results? The distinctions between these and acts that proceed from a wicked and malignant heart is founded on eternal justice, and in the words of the psalmist, he knoweth our frame, he remembereth that we are dust. Shall not the rule he has established be good enough for us to judge by? Gentlemen, the case is closed. Again I ask you to consider it well before you pronounce a verdict which shall consign this prisoner to a grave of ignominy and dishonor. These are no idle words you have heard so often. This is your fellow citizen, a youth of promise, the rose of his family, the possessor of all kind of virtuous and manly qualities. It is the blood of a Kentuckian you are called upon to shed. The blood that flows in his veins has come down from those noble pioneers who laid the foundations for the greatness and glory of our state. It is the blood of a race who have never spared it when demanded by their country's cause. It is his fate you are to decide. I excite no poor, unmanly sympathy. I appeal to no low, groveling spirit. He is a man. You are men. And I only want that sympathy which man can give to man. I will not detain you longer, but you know when it is right you should. The terrible suspense in which some of these hearts must beat during your absence. It is proper for you to consider this, for in such a case all the feelings of the mind and heart should sit in council together. Your duty is yet to be done. Perform it as you are ready to answer for it, here and hereafter. Perform it calmly and dispassionately, remembering that vengeance can give no satisfaction to any human being. But if you exercise it in this case, it will spread black midnight and despair over many aching hearts. May the God of all mercy be with you in your deliberations, assist you in the performance of your duty, and teach you to judge your fellow being, as you hope to be judged hereafter. Another word, gentlemen, and I have done. My services in this case were volunteered. I had hardly expected that so unimportant a fact could excite attention or subject me to reproach. What? Shall all the friends of this young man be driven from him at such an hour? I had known him from his boyhood. I had known his family from mine. And if, in the recollection of the past, in the memory of our early intercourse, in the ties that bound us together, I thought there was sufficient cause to render it proper, whose business is it? What does it concern but my client and myself? I am a volunteer. I offered my services. They were accepted, and I have given them in this feeble way. I thank you kindly for your attention during my long and uninteresting discourse. I only ask that you will examine this case carefully and impartially, for in your justice and your understanding I have deep and abiding confidence. Mr. Allen for the Commonwealth. Gentlemen of the jury, in consequence of illness and debility, I shall not detain you as long as those who have preceded me. The law and the facts have been gone over and repeated again and again. I have every confidence in your intelligence and watchfulness, and doubt not you are as well posted up in the testimony as the lawyers. But let me assure you that your entertainment has passed. I am exhausted, and speak to an exhausted jury. I follow one of our most talented and eloquent men in one of his ablest efforts. While you accept that, you will not reject a feebler effort. Before entering upon this case, I wish to make a few personal remarks. The circumstances attending this case have produced a great excitement throughout, not only Kentucky, but the Union. There has been much speculation about the verdict you would pronounce, also about the course I should pursue. I have been pronounced both the enemy and friend of the prisoner. The fact is, I am neither. I have never met him half a dozen times in my life. But were he either friend or enemy, I think I could administer the law as it requires and march up to the line of duty, even if my steps crushed my heart's strongest impulses. I appear before you as the agent of no man. I am not hired, but appear in the discharge of an official duty. As to the manner I should discharge that duty, I have received no hint from friends or enemies of the deceased. My first duty as attorney for the Commonwealth is to lay down the shield of the law in favor of the prisoner. He must be presumed innocent until he is proved guilty, by such testimony as admits of no reasonable doubt. And here, permit me to say that I differ with Mr. Crittenden in the definition of a reasonable doubt. You may doubt the truth of a witness, his means of knowing that whereof he testifies, etc. But having admitted that, you cannot entertain a reasonable doubt of the fact that testimony establishes. Indeed, it is impossible. The jury should have certain knowledge of the guilt of the prisoner. You must attain that through the information of others. If 100 men swear to a certain fact, and you believe them, there is still a doubt. There is a difference between belief and knowledge. Is the doubt still lingering a reasonable one? Though the law does not presume that every killing is necessarily malicious, yet if the fact of the killing be established, it requires less evidence to establish the malice than to establish the killing. I shall now examine the various positions of the counsel for the defense. The first great bugbear is the public press has inflamed the public mind, that the Louisville Courier and Democrat have poisoned public opinion all over the country. This I deny, but if the charge were true, other papers have not been silent. The Elizabethtown Register and New York Herald have contained articles in favor of the prisoner. What was their object? To influence the public mind in favor of the prisoner. I have the same right to make this assertion than they have to make theirs. But both classes of papers have failed. Never was there a jury so easily obtained, showing them in what has been called the Commonwealth of Pardon. Public opinion has not been poisoned, but it is said that since this trial commenced, inflammatory letters have appeared in those papers, calculated to excite the public. The public are not trying this case, and those letters are excluded from the jury. Mr. Marshall took the position that Ward had a right to attack Butler because Butler had called his brother William a liar. And yet, if this is so great a crime in a teacher, who stands in the place of a parent, what shall we think of Ward himself, who goes into the schoolhouse and calls Butler himself a damn liar? How much worse is Ward than Butler? Besides, the character of Butler is admitted as being good, pious, and honest. Then he believed the truth of what he uttered. Yet Matt calls him a liar. No provocation can excuse such words to such a man. As to the whipping of William, we have not been permitted to show its justice or its extent. Again, Mr. Marshall states that we charged Ward with wealth to excite your prejudice. We have shown that from his position, wealth, and influence, he was able to present his case in its strongest light and to procure counsel and witnesses. That is all the object we have had in referring to his wealth. In the heat of argument, we cannot always be particular in our expressions, and may say something to hurt the prisoner's feeling. It is necessary to say disagreeable things, but I shall try to use decorous language. Mr. Marshall has laid down the law, and just to show you how his law sounds, divested of its elegant expressions, I will give it in common language, and it is thus. A man has a right to shoot a fellow if a fellow tries to whip him. That is it, in plain language. Further, he says, if a man is pushed back by another to an obstacle, he may shoot, stab, strike his opponent, no matter who began the scuffle and who is in fault. This is a part of the glorious Kentucky law, as yet unsoiled by printer's ink. What is to be the effect of this law? You and I think differently about a proposition. The common law and the statute should decide the matter. But we refer to the Kentucky law. You are young and stout. I am weak. I slap you. You run me back. I pop you because I am run to the wall. It is not necessary to dwell longer on this law or on Mr. Marshall. Governor Helm tells us that a man of good character like the prisoner could not have intended murder. A better character than the prisoner has proved I never heard. Yet the human heart, who can judge it? This good character is no proof against guilt. Character only goes to make clear what is doubtful. Dr. Webster of Boston proved by ministers, lawyers, and doctors as good a character as that of the prisoner. Yet he committed murder and confessed the crime. But it is asked, what was the motive of Ward to go to the schoolhouse? A code is obtained in Kentucky, not confined to Louisville, but extending throughout the state. It is called the Code of Honor. If you look in a particular way towards a person, approach a woman supposing her to be an acquaintance and she is not, tread on another's foot, they are legitimate causes for this code. It contains this peculiar feature, that a man is judge of his own wrongs. Under this code, Ward thought an injury had been offered to his family, and he goes to force an apology, and if Butler refuses, he is prepared to take his life. From this code, this difficulty arose. Butler was unwilling to explain. The words he used to the little boy were not an insult, because he stood in the place of a father. It was his duty to punish crime in the boy and tell him of it. Boys should be punished as well as men, and this case shows the importance of children being whipped. Mr. Wolfe says he has given injunctions that his children should not be whipped. It is a pity that such commands should be given. I am conscious that I owe much to the numerous floggings I received, and perhaps to these the fact should be attributed that I stand here an advocate, not a prisoner. It is said Matt Ward had a right to go because he had been delegated. The father had no power to delegate his authority. Besides, Butler did not know he was delegated. Had the father gone, he would have stepped into the private room and received the explanation. But Matt insists that he is the one to go. He was young and his father old, as if his father could not talk as well as he about the difficulty. Governor Helm says he had a choice of pistols when he purchased and got the smallest, that therefore there was no murderous intent. He got a pistol, competent, easily concealed, handy for use, a good shooter, and a self-clocker. Ward was not a braggadocio, didn't want big pistols to flourish about, kept his weapons concealed till time to use them. We have a right to infer that he anticipated a close fight. Butler was a peace man. There would be no duel. For a close encounter, this was the right kind of pistol. But Mr. Wolfe says he never saw anything like the course pursued by the prosecution. Now it is for you to judge whether they have acted fairly or not. But they are brought here, he says, by the rattle of shekels of silver. Every lawyer takes a fee and does the best he can. There has been no unfairness on the part of the prosecution, but I might retort the charge on the defense. What could the Commonwealth have done in this case if not assisted? An ordinary man, rich, opposed by 15 or 18 lawyers, the pick of the Kentucky bar. What could he have done alone? There are no distinguished men on the part of the prosecution, and if they have quoted the law correctly, there is no matter for explanation. The right of self-defense has been referred to. It is the right of nature, cannot be taken away, an inestimable right that all should enjoy. But still under pretense of self-defense, one should not go, draw out an attack, and then kill. Be careful not to permit such an instance to go unpunished. This right of self-defense should not be thus trifled with. But Mr. Wolfe says, if a person slander you or your family, and you go to him, curse him, and he attack you, cannot you kill him? I answer no. If a person slander you, you have redress in the law. That is the remedy, full and ample. It punishes him and restores your character. No violence is recognized by law, except in self-defense. But further, under this code, when a man is judge in his own case, goes, takes the law in his hand, curses, and then shoots, if he can do it in one case, he can in another. The principle won't do, gentlemen, for the government of a great nation. But there has been an awful assault made on the witnesses in this case, especially on the boys. It is said they have told only what they heard. Severe remarks have been made about Sturgis. He is an estimable man, not very brave, rather inclined to retire from danger. They say he has corrupted the boys that they have come down and told what they have heard. Mr. Crittenden says he believes much in blood. So do I. The parents of these boys are respectable, and many of them distinguished by high positions in society. Yet it is said they had let Sturgis influence their boys, so that they asserted a falsehood. Yet you know nothing of Sturgis. He was brought down as a witness in this case, and would have appeared had Bob been on trial. He knows nothing of this case. When necessary, we shall produce him, and he will show Bob's connection with the matter. Much stress has been laid on Quigley's testimony and on his statement that Butler pushed Ward back. There is a dispute between the counsel respecting his testimony. I have taken notes of his testimony, and in his direct examination he says Butler pushed Ward back to the door. But in his cross-examination he said Ward stepped back but one step. This does not support Bob. Benedict says Ward leaned back. There is a mistake about the position Bob sustains in this matter. We do not assail him. He assails the boys. But take all their statements if you choose to set aside the 13 boys and take Bob. It is your privilege. You know the situation. If Matt is acquitted, Bob goes free. He stands as a witness swearing for family honor, for a brother's life, and for his own. The boys have no interest, are respectable, and when they and Bob differ, which will you believe? But they say Knight cannot be believed, because he withdrew some things on cross-examination, which he stated in the direct. But this is on evidence. On his direct examination, he stated all he knew. On his cross-examination, he was told to state only what he heard. If he had been trained to a story, he would have stuck to it. like a Grayson County tick. Mr. Crittenden said he had not accused the boys of being trained, but of being unconsciously so influenced as to believe things had occurred differently from the reality. Mr. Allen, then it is admitted they are not suborned, that they are only simple? Mr. Crittenden again explained. Mr. Allen, the boys are admitted then to be honest and reputable, but they have been influenced by Sturgis. Now the defense knew what these boys testified in the police court, and if they had testified differently here, the defense could and would have shown it. The little differences in their statements showed they had not been trained and confirmed their veracity. Differently situated in different parts of the room, they saw the transaction in different lights and tell it just as they saw it. Their testimony makes out a perfect whole, complete in all its parts. The boys contradict Bob about the running back and the striking. The boys swear positively they saw nothing about a blow, but merely laying the hands on the shoulder. They contradict him about his going up the aisle, menacing the boys and frightening them. They contradict him about the position of the parties. The question is, whom you will believe. The boys have acknowledged good character or Bob, barely admitted as a witness. But Mr. Crittenden says the boys were too particular about Ward's right hand. I will tell you how they came to notice that. William Ward had said Matt would be there in the morning and give Butler hell. The boys wanted to see what his preparation was for giving him hell. Again, the defense say that Dr. Thompson cannot be relied on because his testimony conflicts with Barlow's. Yet when we offered to prove his good character, they admitted it at once, though Mr. Wolfe afterwards asserted that they brought several witnesses to prove Barlow's character, and we but one to prove Thompson's. This was ungenerous after admitting Thompson's character, and thus precluding us from bringing witnesses to establish it. But Barlow was contradicted by old Mr. Ward, by Thompson, and by Knight. This man Barlow is the one who killed himself by his testimony, and Carpenter preached his funeral sermon on Friday last. His conversion was remarkable. One day he proposed to head a mob to take the prisoner from jail and hang him. The next day he is his fast friend. What caused this conversion? I will not say he was bribed, but it is highly probable he expected something, and most likely he expected more than he will ever get. And now, which of the two, Thompson or Barlow, will you take? Yandell does not contradict Thompson. His impression is that Butler indicated that Ward cursed him, and then raised his hand to strike him. Thompson had asked the question and was listening to the answer, and Yandell was not so particular. Barlow says the conversation took place before Caldwell and Yandell came. Thompson and Knight say that it occurred afterward. Mr. Crittenden says that no words used by Ward could justify Butler in striking him. Yet, if Ward used these words for the purpose of inducing an attack, he is not justified in shooting. The attack does not even reduce the crime from murder to manslaughter. Mr. Crittenden has told you that the object of trial by jury is a merciful one, that the judge, understanding the law and bound by it, might condemn, where the jury, actuated by the impulses of warm and generous hearts, might acquit. But you are sworn to decide by the law and the evidence. I would say to you that your hearts are not to try this case, but your judgment. Pluck out your hearts, if possible, and change yourselves into pillars of stone. In what part of your oath did you swear to be merciful? It is the law as recorded in the books that is to guide you, not that glorious unwritten Kentucky law of which you have heard so much. I feel and realize the position of all the parties in this case. It is melancholy and your duty may be unpleasant, but life is full of unpleasant duties. It is not strewn with roses. In the discharge of my official duties, I am sometimes called to prosecute warm, personal friends, but I have to march up to the line of duty, and I expect you to do the same. If you should decide that the prisoner is innocent of the crime, and form that decision from the law and the evidence, you can say you acted honestly and in the discharge of your duty, though you should ascertain hereafter that you were mistaken in the fact. But should you decide from mere human feelings and let a guilty prisoner loose, you would condemn yourselves as having inflicted a grievous wrong on society. End of section 30. Section 31 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 23. I will now take up the evidence for the defense, and the evidence of the prosecution not contradicted by the defense, and shown from that you are bound to convict. It is proved and undisputed that the prisoner brought the pistols on the morning of this occurrence, but his counsel say he was intending to go on a journey south. But why had the pistols bought at this particular time? It has been proved and is undisputed that he had formed the determination to call on Butler. Is it not a fair inference that he bought them as preparatory to that call? The main fact being established, it requires less proof to establish the subordinate facts. His main intention that morning was to call on Butler, and he bought these pistols and had them loaded. Is not his intention plainly inferable? But they say he told his father and mother that he feared no trouble. Now this may mean that he, as a brave man, did not fear trouble, however great its probability. But grant that he meant he did not expect any trouble. If he really had expected trouble, would he have told his father and mother of it? Would he not have practiced a little pious fraud? Certainly he would, if he expected a fight or duel. He would have concealed it as long as he could. But the discerning eyes of his mother pierces through all his disguises. She sees he is excited and tells him to be calm. But he still tells her that he is calm. He goes off taking Bob with him, telling him on the way not to interfere unless Sturgis did. This shows his mission was not one of peace. Did he expect Sturgis would interfere in his civil conversation? He expected trouble. His was not a friendly one. Sturgis, as the evidence has shown, was not a man to attack anybody. Ward had undertaken to do a certain thing, and he knew that might lead to trouble. In that trouble, brought about by himself, he knew angry and malicious feeling might be excited, and malice formed on a contingency is as fatal to the prisoner as if he had harbored it in his bosom for months. His abrupt remark to Butler at the schoolhouse that he wanted a conversation with him indicates no peaceable feeling. Butler asks him into a private room. Ward refuses. He did not want an explanation unless in the presence of the school, and an explanation that would satisfy him would degrade Butler and ruin him in his profession. He then asked, which is the worst, the contemptible puppy who begs chestnuts and then lies about it, or my brother who gives them to him? This is a charge against Butler and against the boy, too. Butler says there is no such boy there. All this transpired in the presence of the school. It shows that Ward went there to put an assault on Butler and degrade him, and thus ruin him. And if Butler resisted, then he would shoot him. Ward asks again, why did you call my brother a liar? Butler refused to answer this insolent question. Ward asks, is your mind made up? Butler says, it is. Ward then says, you are a damned scoundrel and a coward. The defense say that Butler then struck him. Admit it. What else could he do? Insulted in his own school, in his own house. What should he do? Ward knew what was coming. Throughout this Commonwealth, such words are always considered the trumpet call to battle. They are only used when a blow is meant to be invoked. Practically, they are the commencement of the quarrel, no matter who struck the first blow. Ward, after using these words, cannot rely on the illegality of the blow to screen his subsequent conduct. To support this, let us examine the law. Mr. Allen read authorities to show that the act, as shown by the evidence, was not excusable homicide. He quoted from Wharton, Roscoe, and Archbold, and from these concluded that no man has a right to slay for a trespass to property or a mere assault on his person. There must be an apparent design to take life or do enormous bodily harm. He then read from the same authorities to show that the act was murder, not manslaughter. In reading these authorities, he commented on them and showed they reduced the killing from murder to manslaughter only when done in sudden passion or great provocation, and then continued. What is the provocation in this case? Bob says Butler had pushed Matt back to the wall. Admit this, and the killing is not then justifiable, as he brought on the attack. There was no necessity to kill Butler to save life or limb. He must have retreated as far as he could, and been without fault himself. He had no cause to believe that he was in great danger of bodily harm, and if he did believe so, there was no good ground for the belief. Ward knew Butler would not hurt him, that he was a man of peace. Besides, Bob was there, armed, to protect him. There were no menaces against his life. There was no danger of bodily harm, and he was not without fault himself. The presumption of the law is, it was done with malice, and this presumption is strengthened by the purchase of the pistols, his excited manner in going to the school, and his manner while there. Thus far I have examined the cases presented by the evidence for the defense, but I cannot consent that it shall be thus tried. With so many good witnesses of our own, I insist on their testimony being received. No one doubts a single portion of the testimony of the boys. They are not contradicted. Allen and Gudgel do not contradict them. Allen only testifies that Worthington nodded assent to something. He cannot tell what. All that can be made of it is that Worthington does not remember any such conversation. Gudgel thought he recognized Benedict as the boy he met in the alley, but it has been shown he was mistaken. The boys are fully confirmed, and their testimony shows the excited manner of Ward, his insulting remarks. It shows that he was not struck until he struck, that he was not pushed back, but just leaned back, and that there was no necessity for him to kill Butler, to save life or limb, or prevent any bodily harm. Their testimony is confirmed by Thompson, and as for Barlow, let him rest in peace. I am no turkey buzzard, and shall not disturb his carcass. He killed himself by his own testimony, and though the defense have applied a strong galvanic battery to his remains, they have produced but a few awkward contortions bearing no resemblance to those of life. He is past resurrection. Let him alone. Now let us suppose the facts were just as they have been proved up to the time of shooting, and at that identical moment that Butler had killed Ward, instead of Ward killing Butler, and that Butler was now on trial for the act. We have shown Ward's intention to make the call, his purchase of the pistols, his excited manner, his insisting on going instead of his father, his manner in the schoolroom, his insulting questions, his calling Butler a damned scoundrel, his drawing a pistol, and just then suppose Butler shot him, and was now on trial before you. You would be bound by the law and the evidence to acquit Butler. There cannot be two justifications for the same deed, and if you would acquit Butler, you must convict Ward. And now, gentlemen of the jury, I must close. I have argued the case fairly, and so have my associates. We have made no fierce accusations against the prisoner, nor against any of the witnesses, not warranted by the facts. You must discard all appeals to your feelings. I have made no appeals. You have looked on that monument of grief, the widow of the deceased, and have seen the great effort she made to control her grief. I have imitated her example. I have presented the case as it is. You must try it by the law and the evidence, and decide whether the prisoner is guilty of murder or whether he is guilty of manslaughter or whether he is innocent. Cast away all excitement and administer the law under your oath. Your merciful feelings have been appealed to. What claims has the prisoner on you for mercy? He is surrounded by friends, rich and influential. He has had the benefit of all the counsel and all the witnesses he wished. I have seen a case where a jury might administer mercy. A poor Dutch boy, ragged, cold, freezing, stole a coat to preserve life, was arrested. A stranger in a strange country and a language, without friends or relatives, depended on the court for his counsel. He presented a case for a merciful construction of the facts. The case before you is entirely different. The prisoner has powerful friends and has brought a host of witnesses. The mercy he showed to others is his only claim for mercy. The charge of the court. Judge Kinchlow. Gentlemen of the jury, the cause to which you have, with commendable patience, given your attention for 9 days past, is at length submitted to you for your decision. But before you retire to your room, I conceive it to be my duty to direct your attention to the issues made in the progress of the trial, and to caution you against permitting certain matters which have been casually alluded to in the argument of counsel to influence in any degree your verdict in the cause. You are constitutional judges of the fact, the usual course of practice in criminal cases in this district, that of reading and discussing the law before the jury by the counsel, having been adopted in this case, will relieve the court of the necessity and to some extent renders it improper to enter into a discussion of the various principles of law applicable either directly or indirectly to the facts proved in the case. The killing not being controverted, it will be your duty to determine whether it was perpetrated under such circumstances with such malice as to constitute the offense murder. Malice, expressed or implied, is an essential ingredient of this crime. There can be no murder without it. Malice has been defined and explained to you, and numerous cases have been read where a certain state of facts have been determined by courts of justice to indicate that acts were malicious or otherwise. These judicial decisions are properly to be regarded as illustrations of the legal idea of malice. In some of them, the distinction between the two classes of cases is almost imperceptible, and in understanding those cases properly, you will have to bear in mind the definition of malice, so as to make a just application of the principles of the law to the present case. If you find the killing to have been done maliciously, as charged in the indictment, you will return the verdict guilty. Although you may believe from the evidence that the killing was not done maliciously, yet under the indictment in this case, you may find the prisoner guilty of manslaughter, if the facts proved in the case shall, in your opinion, justify such a verdict. The distinction between murder and manslaughter has been explained to you at large. The grand distinction is, in murder the act is prompted by malice. In manslaughter it is perpetrated in sudden heat of passion, without malice. If from the evidence you believe the killing in this case was done, not in self-defense, but in sudden heat of passion without malice, the crime is manslaughter, and in such case you will have to determine the length of time the prisoner should be confined in the jail and penitentiary of this state, a period not less than 2, no more than 10 years. If you believe from the evidence that the act was done in self-defense, the law excuses it, and it will be your duty to find the prisoner at the bar not guilty, and you will return your verdict accordingly. Thus 3 distinct propositions are submitted for your consideration, viz., whether the act was done maliciously, and therefore a murder, whether in sudden heat of passion, without malice, which constitutes manslaughter, or whether in self-defense, which the law excuses. And to the proper solution of these questions, I urge upon you, in your retirement, a calm, patient, and impartial investigation of the facts proven in the case. If upon such investigation you have reasonable, not fanciful or imaginary doubts whether the act was murder or manslaughter or in self-defense. It will be your duty to acquit the prisoner. Some facts not before you as proof have been occasionally alluded to by counsel on either side, such as the supposed causes of a change of venue, newspaper publications on the subject of the prosecution, etc. But these should not, and I presume will not, have the slightest influence on your minds. You will now, gentlemen, retire to your room, and under the sanction of the oath you have taken, calmly and impartially consult and deliberate together, and return your verdict according to law and the testimony in the case. The jury retired to make up their verdict on the 8th day of the trial at about 5 p.m. End of section 31. Section 32 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Matthews F. Ward for the murder of William H. G. Butler, Kentucky, 1854, Part 24. The verdict, April 27th. At about 9 o'clock, word was received from the jury, stating that they had found a verdict. The prisoner was immediately brought in, and after he had reached the courtroom, the jury, under the charge of the sheriff, came from their room and were conducted to their seats. By this time, intelligence that they had come to a decision had spread so rapidly that the courtroom was densely crowded with people, and the oppressive silence that prevailed indicated the deep interest that was felt. The court, gentlemen of the jury, have you agreed upon a verdict? The jury, we have. The court, what say you, gentlemen? Do you find the prisoner, Matt F. Ward, guilty or not guilty of murder, as charged in the indictment? The jury, not guilty. The court, do you find him guilty of manslaughter as charged? The jury, not guilty. Footnote. They afterwards stated that when they entered their room to make up their verdict, 11 were in favor of acquittal. The 12th was in doubt, caused by what he understood to be a portion of the testimony of Quigley. When he was convinced, however, that his memory had been imperfect or erroneous on that point, he coincided with his associates. End of footnote. This announcement was followed by an outburst of applause from the spectators outside the bar, but the demonstration was promptly checked by the court. The prisoner was borne from the room by his friends in a fainting condition. The verdict was recorded by the clerk, and the jury was discharged. The Commonwealth attorney entered a nolle prosequi in the case of Robert J. Ward, Jr., and he was immediately discharged from custody. Footnote. The Cole reported the trial contains the following addendum. The news of this verdict was received in the city of Louisville, as it has since been throughout the state of Kentucky and over the entire Union, with the greatest indignation. In Louisville especially, where it was published on the morning of Friday, April 28th, the excitement immediately produced was intense. But little business was done on that day or the next. All men seemed to think that an indelible stain had been fixed upon the fair fame of the state by the mockery of a trial that had been had, and the iniquitous verdict that had been rendered, and the oldest, most substantial, and most respected citizens demanded a public meeting that the city of Louisville might cleanse itself of the disgrace that would otherwise rest upon it. In the newspapers of the Saturday morning appeared the following notice: a meeting of the citizens of Louisville, favorable to the erection of a monument to the memory of the late lamented Professor Butler, is requested at the courthouse on Saturday evening, April 29th, at early gaslight. Pursuant to this call, the largest and most respectable assemblage that had ever convened in the city gathered within and around the courthouse in an early hour in the evening. The number present has been variously estimated at from 8 to 12,000. The West Room in the second story of the building was filled at a very early hour. Several old, universally known, and generally esteemed citizens had been requested to act as officers, but the press was so great that the principal of them could not effect an entrance to join those who were earlier in their attendance. Some delay in effecting the organization was thus induced, and during its continuance, Sherrod Williams, on request, addressed the meeting. Mr. W. fully recognized the justice of the indignant feeling that had moved, as it were, a whole community, and expressed his own deep sympathy with it, but deprecated violence against personal property, and besought people to content themselves with the warm and decided expression of their sentiments with reference to the crime that had been committed, and to the mockery of a trial that had been had of its guilty perpetrator. Mr. Williams was listened to with the most respectful attention, but the crowd outside, which was continually augmented by fresh arrivals, became impatient to know what was going on within. It was therefore agreed to go below, but when most of those who were upstairs had got down, anything like a satisfactory organization there was found to be impossible. It was therefore proclaimed that the regular meeting would organize above, and that resolutions should be reported and passed. They would be sent down for ratification. On returning to the large room above, General Thomas Strange was chosen president and Mr. George Anderson secretary. General S. made a brief but appropriate and forcible address on taking the chair, at the close of which, on motion, John H. Harney, Theodore S. Bell, Bland Ballard, W. D. Gallagher, W. T. Hagan, Edgar Needham, and A. G. Munn were appointed a committee to draft resolutions. While this committee was absent, the Reverend J. H. Haywood was requested to address the meeting, which he did with his accustomed beauty and effectiveness. Upon the return of the committee, Bland Ballard read the subjoined resolutions, which were received with the most decided approbation and carried by a unanimous vote of the assemblage. The citizens of Louisville assembled in public meeting for the purpose of giving expression to their opinions respecting the trial and the verdict of the jury in the case of the Commonwealth versus Matt F. Ward, recently tried in the Hardin County Circuit Court, to submit to the public at large, but more especially to the citizens of the Commonwealth of Kentucky, the following resolutions as expressive of their views of the matters herein referred to. 1. Resolved, that the verdict of the jury recently rendered in the Hardin County Circuit Court, by which Matt F. Ward was declared innocent of any crime in the killing of William H. G. Butler, is in opposition to all the evidence in the case, contrary to our ideas of public justice, and subversive of the fundamental principles of personal security, guaranteed to us by the Constitution of the state. 2. Resolved, that the criminal laws of this Commonwealth should be so administered that every citizen may feel secure from insult, injury, and violence, both in person and in occupation, and that the omnipotent power of public opinion should at once be so directed as to discountenance and condemn all attempts to thwart the ends of public justice, and to cause the practical realization that manslaying is in fact the highest crime known to society. 3. Resolved, that the published evidence given on the trial of Matt F. Ward shows beyond all question that a most estimable citizen and a most amiable, moral, and peaceable man has been wantonly and cruelly killed, while in the performance of his regular and responsible duties as a teacher of youth, and notwithstanding the verdict of a corrupt and venal jury, the deliberate judgment of the heart and conscience of this community pronounces that killing to be murder. 4. Resolved, that the charge of vindictiveness and cruelty preferred against the citizens of Louisville by a portion of the counsel for the defense of Ward is a vile and unmerited slander, and we proclaim that each and every imputation cast upon our esteemed fellow citizen, Dr. D. D. Thompson, and our neighbor's children, the pupils in Professor Butler's school, is utterly groundless and unjustifiable. 5. Resolved that the public press of this Commonwealth should be so conducted as to be recognized as the conservator of the public morals, and that a failure of any portion of the press to rebuke and condemn an atrocious crime against society tends to debauch the public virtue and to destroy the public morals. 6. Resolved that in the death of William H.G. Butler, his family have lost a most devoted, affectionate, faithful son, brother, husband, and father, the cause of education, a most accomplished friend and an advocate, one whose talents and acquirements placed him in the front of his useful and honorable profession, and that society has lost one of its purest and best members, whose life is unspotted by a single blemish, as gentle and noble a spirit as ever breathed. 7. Resolved that in token of our respect and affection for, and as an evidence of our appreciation of W. H. G. Butler, we will at once take measures for erecting a monument to his memory, and to present to his widow a substantial token of our regard for her. 8. Resolved that we regret and condemn every manifestation of disorder, and we exhort all good citizens, by their reverence for law, by their own self-respect, and by their love of the virtues of him whose loss we deplore, to abstain from violence to persons or property, and from every disregard of law and order, remembering that society cannot exist without order, and that he, whom we revered when on earth, was incapable of meditating harm to anyone, and that every wrong committed will wound his pure and lovely spirit. As soon as the resolutions were passed, the committee retired with them to the crowd below, where they were read by Sherrod Williams and carried with equal unanimity. After the committee left the meeting above, resolutions were moved and carried, requesting the two wards to leave the city, inviting Nat Wolfe to resign his seat in the state senate and follow them, and requesting John J. Crittenden to resign his place in the Senate of the United States, to which he was elected by the legislature of Kentucky last winter. By a portion of the immense crowd outside, another meeting was organized by which another series of resolutions was passed, equally condemnatory in their tone with those passed by the regular meeting in the courthouse, as to the trial and the verdict, and much more sweeping in their references to individuals who had rendered themselves obnoxious in different ways by the connection with the trial, several of whom were singled out by name for public censure. By a large number of persons in the courthouse yard, after the regular meeting in the West Room had adjourned, effigies were hung up and burned of Matt F. Ward, Barlow, the false witness, the members of the Hardin County jury, and a number of other persons who, by their acts, had subjected themselves to the deep displeasure of the people of Louisville. Earlier in the evening, a crowd of men and boys gathered in front and at one side of the private residence of Robert J. Ward, doing considerable damage to the conservatory with stones, and with the same missiles breaking some of the front windows. While this was going on, effigies of Matt and young Robert Ward were strung up in front of the door. These were afterwards set on fire, when some person unknown caught one of them up and threw it against the front door, which was thus set on fire. The alarm was at once given. Several engines were soon upon the spot, and after encountering a somewhat decided but by no means stubborn opposition from the men and boys near the house, the flames were extinguished. As the closing sheets of this report go to press, a week has passed since these occurrences took place. No one pretends to defend or excuse the lawless depredations committed upon the private residence of Robert J. Ward. Every good man condemns them as wrong, uncalled for, and reprehensible. But the heart of the whole city beats with one pulse, and nobly responds to the manly, decided, and conservative tone of the series of resolutions embodied in this closing narrative, as passed by the meeting of citizens held in the courthouse. End of footnote. End of section 32.
Section 33 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of Archibald McArdle for assault and battery, New York City, 1822. The narrative. Peter Krabeck was walking along the Bowery in New York City in the fall of 1822 when he heard the screams of women in an adjoining store. Like a chevalier of old, Peter rushed to the scene and entered the store. He found it was a real case of imprisonment. 2 young women were being held by the storekeeper and admonished that they could not leave until they had given him good money for a counterfeit $5 bill, which he said they had passed on him that very morning. Both the women denied the charge and were in tears, and their condition so excited the sympathy of Peter that he told the storekeeper to let them go. A quarrel ensued, which ended in the storekeeper seizing Peter by the throat and otherwise treating him roughly. For this, Peter haled the merchant into court on a charge of assault and battery, and he was promptly convicted and fined, the court ruling that the merchant had no right to detain the women and Peter had a right to try his best to release them. The trial. In the Court of Quarter Sessions, New York City, December 1822. Honorable Richard Riker, Recorder. Jacob B. Taylor, Henry Meade, Alderman. December 18. Archibald McArdle, who was charged with committing a violent assault and battery upon one Peter Krabeck on September 5 last, was put on trial. He pleaded not guilty. Mr. Maxwell for the people. Mr. Sampson and Mr. D. Graham for the prisoner. The evidence. Peter Krabeck. Am the prosecutor in the case. On the afternoon of September 5th last, my attention was attracted by a crowd before McArdle's store in the Bowery. I asked what it was and was told that McArdle had violently taken 2 women into his store. I went in and found him in a discussion with 2 women, whom I afterwards learned were Mrs. Clark and her sister, Miss Jemima Johnson. The women were crying and called upon me for help. Prisoner said that they should not leave until they had paid him good money for the counterfeit $5 note he said they had passed on him. He said that in the morning they had been in the store, bought some goods, and given him a $5 note in payment that he afterward discovered to be bad. He saw them passing a few minutes after, went out on the sidewalk, and brought them in. They both denied his story. I believed them and expostulated with the prisoner and demanded that he let them leave the store. He said he would not until they paid. We had more words which ended in the prisoner taking me by the throat and trying to strangle me. I broke loose and went out and had him arrested. Miss Johnson and Mrs. Clark testified that the prisoner was mistaken. They had not been in his store that day. He dragged them into the store and kept them more than an hour against their will. Mr. Petrie. Miss Johnson came into my store in the Bowery to purchase a ball of cotton and offered me a $5 counterfeit note in payment. She had on a straw bonnet and white spencer. Am certain I could not be mistaken. Mr. Miller. Am a storekeeper in the Bowery. Miss Johnson came into my store and offered me the same note that was afterwards received by defendant. Am certain she is the same woman, and am certain it was the same note. A number of respectable witnesses testified that Miss Johnson was lately from Middletown, Connecticut, and was entirely unacquainted with the city, that she had no such dress as described by Petrie and Miller, also that she was a young woman of good character, and that the witnesses must have been mistaken in the identity of Miss Johnson. The court to the jury. Any person has a right to arrest a felon and bring them before the proper authority. It is indeed the duty of the citizen to do so. But then this power cannot be trifled with, as it appears to have been in the present case. The defendant seized Miss Johnson, in company with her sister, Mrs. Clark, by the arm, in the street, charging her with passing a counterfeit bill upon him. He took them into his store, and there confined them for the space of nearly an hour, telling Miss Johnson if she would pay him in good money the amount he alleged he received from her, he would let her go. If not, he would send for an officer and take her to the police office. This mode of proceeding was clearly irregular. It was the duty of the defendant, if he believed the woman guilty, to take her immediately to the proper authority, or if that could not be done, to secure her in his own house or some other place until he could send for an officer, or take her himself. But in this case it does not appear that the public good was his object, but on the contrary, private interest. He offered to let her go if she would pay him $5 for the bad bill. Now it is certain he had no right to force her into his house and detain her there for the purpose of receiving the $5 for any consideration. The jury returned a verdict of guilty, and the prisoner was remanded for sentence. End of section 33. Section 34 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of John Hanlon for the murder of Mary Mormon, Philadelphia, Pennsylvania, 1870, Part 1. The Narrative. In September 1868, there lived in Philadelphia on 5th Street near the corner of Diamond Street a young, newly married man named John Hanlon. By trade he was a barber, but not a very skillful one, as he had acquired his whole knowledge of his art while a soldier in a camp at Alexandria. The house where Hanlon lived was an unpretending 3-story brick, one of a number of the same kind of houses in that block. His mother and sister occupied the upper portion of the house, while Hanlon, who had but lately married a girl of beauty and pleasing manners, he being at that time 22, while she was scarcely 17, kept the first and second floors for his own use. On the first floor was his barber shop, approached from the street by a flight of 3 stone steps, and its door was ornamented on either side by 2 short poles, painted in red, white, and blue stripes, and ornamented at the top with a golden acorn. In a little street immediately behind Hanlon's shop there lived a widow named Mormon and her 5 children, the youngest only a little over 6 years of age, being known among the neighbors as, quote, little Mary Mormon, end quote, a term of endearment and affection, for they all loved the little girl. One Sunday evening in September, there were seated on Mrs. Mormon's step a number of young girls, among them little Mary. The mother left the house for the evening church service, and Mary, a little while later, accompanied by one of her young companions, went down the street, and just at the barber's pole a man asked them where a certain street was. Mary told him, but her companion ran away, as she saw the man take her by the hand and lead her into the alley. When Mrs. Mormon returned from church, she could not find Mary, and the children said that they had not seen her since she went around the corner with a strange man. The alarm was given, the bellman proclaimed the loss in the streets, and the city police and detectives were soon making searches. No trace of the child was found until 2 days later, when the body was discovered in a vacant lot some distance from the houses of Hanlon and Mrs. Mormon. The child had been dead for at least 2 days, the physicians testified. The underclothing was stained with blood. There were bruises on her arms and wrists and neck, and an autopsy revealed the cause of death to be strangulation, and that her person had been grossly violated. The activity of the authorities bore no fruit for some time, and though several men were arrested on suspicion, among them John Hanlon, all of them were discharged for lack of evidence, and the crime bade fair to remain undiscovered and unpunished, when more than a year later the key to the tragedy was discovered through the act of the perpetrator himself. In November 1869, a man calling himself Charles C. Harris was tried and convicted in Philadelphia and sentenced to 4 years' imprisonment for an assault on a young girl. Taken to the Moyamensing prison, he was discovered to be John Hanlon, the barber, and at the suggestion of the detectives, another convict named Dunn was put in the same cell with him to find out, if possible, if he were the murderer of little Mary Mormon. The ruse was successful. Within a few weeks he had told the whole story to his cellmate and had confessed that he was her murderer. He was taken back to Philadelphia and put on trial for the murder. The story told by Dunn was the powerful evidence against him, but it was substantiated in all its material points by a number of other witnesses, and he was convicted and hanged. The trial, in the court of Oyer and Terminer, Philadelphia, October 1870. Honorable James R. Ludlow, Honorable William S. Pierce, Judges. October 31. John Hanlon having been indicated for the murder of Mary Mormon, a girl of only 7 years, the trial came on today. District Attorney Shepard and H. S. Haggart for the state. B. H. Brewster, John P. O'Neill, and P. F. Carroll for the prisoner. Considerable time was consumed in impaneling a jury, a good many of those summoned having either formed or expressed an opinion, or having conscientious scruples in respect to the death punishment. The jurymen finally selected to try the case were T.C. Christman, foreman; Hart Judah, John Collins, H.J. Van Tile, C.P.B. Jeffries, James F. Bradfield, Thomas Cragmill, Joseph Winpenny, John Little, Thomas J. Lippincott, Jeremiah Riley, and George Turner. The case for the state. Mr. Haggart to the jury. The child, Mary Mormon, who was killed, was but 6 or 7 years old. She lived with a widowed mother, was enticed into an alley by the defendant, was barbarously outraged by him. She was strangled and her body concealed in his cellar for a time, and afterwards thrown into a pond at 5th and Dauphin Streets. The defendant was arrested on the charge, but there was not sufficient evidence then to hold him to answer. He was afterward arrested on a similar charge, and while imprisoned in the same cell with Michael Dunn, the prisoners became confidants, and the defendant told his companion that he had perpetrated this offense. This led to investigations which clearly proved the guilt of the defendant. The details would be given by the witnesses. Dr. Shapley, am a physician, made an examination after death of the body of Mary Mormon, found the child rather large for her age. There was mud and sand upon her garments and upon her hands, legs, and feet. Her feet were bare. There were wounds upon her head, lacerated about half an inch long and an inch apart. There was another wound about an inch long, parallel with the other of similar character, and another at right angles with it, about half an inch long. They had been caused by a blunt instrument, one without a sharp or cutting edge, as by a stone, stick, or club. They might have been caused by blows or a fall. There were slight bruises on the wrists and ankles, and also wounds with scratches on the chest and neck. The most severe bruises were under the ears and down the neck. These bruises and scratches might have been caused by the hands. Her person was torn and lacerated externally. The stomach, bowels, and liver were in a healthy condition. Her person was greatly ruptured. The underclothing was bloody and stained with mud. The face was of a dark color and swollen, indicating strangulation. The same cause produced the appearance of the blood on the brain. The cause of death was strangulation. She had been dead at least 24 hours. Putrefaction had not set in. Think she had been dead from 1 to 3 days. Mrs. Mormon, am a widow, have 4 children yet, am the mother of Mary Mormon. She was 6 years, 3 months old. I lived then in Orkney Street, below Diamond. John Hanlon lived in the first house on 5th Street, below Diamond, lower side, nearest the Delaware. He was a barber. I saw my little girl Mary the last time about 7:15 on Sunday evening, September 6, 1868. I went out and she left me at the corner of Orkney and Diamond Streets when I went on to church. Came home about 8:30 or 20 minutes of 9. Asked if my children were all here. My little girl Annie told me, "No, Mommy, Mary is not here and I can't find her." Went to hunt her around 5th Street, asked the neighbors if she was around. They said she was there about 10 or 20 minutes ago. Went about with a bell about 2 squares up and down, went to the station house. Came home about 1 o'clock. She was not there. Made no more search that night. About 6 o'clock next morning, went to the station house, but could not hear if she was here or there. Neighbors and police officers helped me to search. At 12 o'clock, I went to the mayor's office. He sent me to another gentleman who told me I should have patience until 10 o'clock next morning. The lieutenant was to meet him then, and he would give him instructions. Went to 5th Street and Susquehanna Avenue, on the very lot on which Mary was found. She was not there then. It was in the afternoon. Don't know that I was at the pond, but I was all around the weeds. Then went home. On Tuesday morning about 6, I first heard that her body was found. Mrs. Hobie first told me. Mr. Kessler, Mr. Crest, Mr. Recht, and all the neighbors helped me in the search, with a little boy who went with my boy to the station house. Mr. Hanlon did not assist in the search. When I last saw Mary, she was in the best health. Had on a pair of drawers, camis, little hoops, white petticoat, and light dress with pink stripes. No hat or shoes. Dress is shown. That is her dress. In my search, I passed Hanlon's home about 20 minutes or 9:45. Caroline Dinglacker lived at northwest corner of 5th and Diamond Streets when Mary was missed. Was with her that evening at Mrs. Mormon's steps when Mary was there. I had a coach with Mrs. Bush's baby in it. We went away together, pulling the coach. We went down 5th Street. We stopped by Hanlon's barber pole. The man had his foot on Hanlon's step. He asked me if I would tell him where 5th and Dauphine Streets was. I said no. He asked Mary, and she said yes. He took Mary by the hand and took her in the alley. I called her several times, and she would not look back. I took the coach to Bush's and looked back several times, but did not see her come out. I took the baby home and ran right across the street from Bush's, went toward our house, looked over at Hanlon's. The barber shop door was standing wide open, but I could not see in it. It was dark, could not see up the alley. There was nobody in it. Stopped and looked up. Was afraid to go on that side. When I got to our house, went in, pulled off my shoes and stockings, and went to bed. Then looked out the window and saw a man go up the alley, Mr. Hanlon's alley. The man had on a straw hat, a black one. Did not know him. He had dark clothes on. He had a striped shirt on. Mr. Haggart, which man? Mr. Brewster objected, as this was practically leading and directing the witness. Mr. Haggart said he did not intend to lead, and he agreed that he was only entitled to ask which man, which the counsel for the defendant admitted to be right and proper. The witness has spoken of 2 men, and I want to know which she is describing. The court admitted the question, but suggested that disputed questions should be reduced to writing and submitted to the court. Caroline Dinglacker. I mean the man who asked me to go to 5th and Dauphine Streets had the dark suit and striped shirt on. The man I saw go up the alley had the dark straw hat on. The man that I saw when I looked out of the window had the dark straw hat on. The man that spoke to me had a cap on and had whiskers too. Did not see Mary after she got up the alley. Did not look there. Did not know the man who spoke to me. Did not see Mary again that evening. Went to bed after looking out the window. The witness was cross-examined at great length by the counsel for defense. A number of other witnesses testified to seeing a man sitting on Hanlon's step on the evening of the child's disappearance, but they did not know who the man was. As to the time when they last saw the child with the man, and as to the time of the discovery of the body, they were Samuel Belger, Emma Bush, Martha Conthe, George Custer, Officer Fluke, J.N. Giberson, Anna Lepp, George J. Link, Carolyn Laudman, Isabella Martin, Anna Mormon, Mr. Perkins, and Alfred Walton. November 3rd. Michael Dunn. Am a pardoned convict and the prisoner who was also confined there. Made a confession to me at that time. Before I was convicted and imprisoned in Moymansing, I did not know prisoner, knew nothing about him nor heard of him until he came into my cell. Never knew of Mary Mormon's death till he told me. Whenever I came into the city, always lived at number 233 Front Street. Was in the city about 5 times and lived there before conviction, by the depot of the Camden and Amboy Railroad. On Front Street at a tavern. These 3 times were at the end of 1867 and beginning of 1868. Was there at Russell's in October or November 1867, and then about the end of December 1868, or beginning of January 1869. Also in February following. Lived in New York when at home. Had lived there 4 months. Lived there before that in Sing Sing prison. Served my time out. Had been convicted of going into houses to commit robberies in the daytime. Came from Liverpool. Was born in Manchester, but lived in Liverpool. Was sent to sea by the British government. To Australia. Want to tell the truth. Had a year's mitigation of my sentence. Had no property. Lived by stealing. Came here to steal and did steal. Was sentenced in England to 5 years for stealing rings from jewelry stores. Was arrested here in July 1868, tried in August, pleaded guilty, and was sentenced. Did not know Hanlon was coming into my cell until he came. Mr. Daniel, one of the keepers, brought him. Was the 29th of December on a Wednesday. Had an almanac, but made no mark on it. He was there every day except on Sundays, until the 1st of March. Mr. Smith and Mr. Tryon came into my cell over a trunk of clothes that had been stolen from me. They told me they were detectives that had been looking for my trunk. Mr. Smith said, "Mike, what would you think of a man who would commit an outrage on a girl and afterwards murder her?" He looked at my work and said I was making a good shoe, asked me how I would like to have a partner in my cell. I said yes. No one besides Smith had been there before except prison keepers bringing food or work or a razor to shave. They had no conversations with me. Was not told Smith and Tryon or anyone was coming to see me. Mr. Tryon said the body of a girl was found on a dunghill. That's all he said. They were with me 10 or 12 minutes. Nobody came to my cell after that till Hanlon came 2 days after, except the keepers. I never saw Hanlon before that day. Did not tell him of the interview I had with Smith and Tryon, nor what Smith said about the girl. My wife is in New York in Sing Sing for 5 years. Was not told to speak out candidly in court. Was at work when sent for this morning. Did not know before that I was wanted. Smith, Taggart, and Tryon all saw me in prison. They said I might be wanted. I said any man that would do that ought to be hung. He then asked if I would like to have a partner. Told him my head keeper had promised me one at the beginning of the year. Smith did not say I should have as a partner the man that was accused of the murder of the girl. No one but Hanlon was in my cell until he was brought in, except the keepers. The keepers did not speak to me on this subject. Saw Smith the Sunday week after that, about 2 or 3 o'clock in the afternoon. I was brought down into the office of the prison. Mr. Fleming, my keeper, brought me down. He said nothing to me. I told him I wanted to see Mr. Smith. Was not told to get a confession from Hanlon by the detectives, nor did they arrange with me to get a confession from him. The counsel for the prisoner objected to the witness being allowed to testify to the confession, but the objection was overruled by the court. Michael Dunn had been living since August 15, 1868, in Moymansing Prison. Did not know the defendant Hanlon before he came into my cell, 29th of December, 1869. He remained there till the 1st of March. Had conversation with him during that interval. The first time he spoke of me of the killing of Mary Mormon was on the Saturday after he came in. He told me he had been charged with the murder of Mary Mormon. I asked how old she was. He said between 12 and 13 years. The next conversation was on the following Thursday. He told me he was the man that did it. He told me that on the Sunday the murder was done. I did not dress myself up that day. At 3 o'clock in the afternoon, I crossed over to the Lager Beer Saloon, Fisher's. I left there at 7:30 o'clock, crossed over to my own house, and sat on the steps. In a few minutes I got up and went to the corner of 5th and Diamond Streets. I asked Emma Welsh first to show me the way to 4th and Dauphin Streets. She was playing with Mary Mormon and another little girl by the side of a cigar post. But she knew me. She said, "You know where 4th and Dauphin Street is as well as I do." I then went into my own house and fixed myself so that my own mother would not know me. Then went out the back way into my alley. It runs between my house and a cigar store. Stood there till I got a chance to get Mary Mormon into an alley. A party seen me standing there, but did not know me, as I had whiskers on. Got her in the alley. At this time Emma Bush was not there, but the other girl was there, and she seen me seize Mary Mormon. The next day she said it was a man with whiskers on. That is why I stood my ground. In a minute or two after I got her into the alley, a man came through the alley. At this time I had her standing up against the fence that separates the yard belonging to the cigar store from the alley. I did my best not to let the man see her. He hit up against me in passing, did not know this man, and am damn sure he could not swear to me. The man went on through the alley somewhere. I opened the gate leading into my own backyard and took her into my privy. I caught hold of her by the neck. The more I hurt her, the more she tried to holler, and the more tight I held her. When I was done, she was dead. Everyone thought she had been cut with a knife. I did not cut her. Carried her across the yard to a small window that led into my cellar. The lid goes up and down. It has no latch to it. I put the body through the window and put down the window again. Took off the whiskers and went upstairs. It was 8:30 o'clock when I had her in the privy. She was about 9 years of age. She had auburn hair and blue eyes. He told me 3 different ages at different times. He said I had hardly got upstairs before Mary Mormon's mother came to look for her in front of my house. My mother went downstairs to Mary Mormon's mother, and they both went to find her. I also went, but did not go far. I turned back. I went into my own house, into the cellar, to see if she was quite dead. She was dead enough. I covered her up and left her in the cellar. The cellar was never used for anything hardly. There was only some rubbish in it. I was pretty full of lager beer, but I knew enough to try and get the body anywhere away from my house if I saw half a chance. Went into the house and opened one of the shop windows a little and peeped through the shutters to see if the coast was clear. Someone or another was going about all night till it got too light toward morning for me to take her away, so I still left her in the cellar and cleaned myself up as if nothing had happened. Did not go to bed, although I felt sleepy. At breakfast time I ate a little, cleaned myself, and went downtown. Had anyone found the body, they would not have found me. Went home again and had a little dinner. Was bound to get her away that night, Monday night. Tried 3 or 4 times before 2:30 o'clock. Seen the coast was not clear until between 3 and 4 o'clock. Got the body and went out my back way. Turned to my left, crossed over to Diamond Street, then turned again up Diamond as far as 6th, and turned up 6th. Went into Dauphin and then turned again. Saw a man on the opposite side, got behind a cart. Don't think he saw me, then threw the body down on a spare lot. crossed over to either 5th or 6th or Susquehanna Avenue, and a logger beer woman saw me. I came down her side of the street and saw a light in the window and someone standing at it. Got away home as soon as I could. It was now after 4 o'clock, cleaned myself up and fixed up my shop. But as soon as the body was found that day, I was suspected. Knew the spots were watching me, and for 3 weeks, no matter where I went, 1 or 2 of them were watching me, and they gave it up and left. That was all he told me that time. He told me next he could not kill her in the privy. It was in the cellar that he murdered her. He hurt her to keep her from crying. He put her in through the cellar window and went to get some hair oil. She began to cry, and I caught her by the neck until her crying was done. When I was done, her crying was done, he told me when he carried the body out of the cellar. That was all he told me then. He told me at another time he got the body and put something in front of it when he went out. He said my back was turned to my left, crossed over Diamond Street, then turned up Diamond Street again. All was clear until I was crossing at Susquehanna. There I met Charlie Mass. He spelled the name for me. I thought it was Mace, and told him we had a prize fighter in England of that name, and he said no, Mass, and spelt the name on a slate. He said I had a pair of light plush slippers for which I gave $2.50. The way I was dressed and fixed up, I thought Charlie would not know me. No, Mass was going to the stable to feed his horse, so as to get to the market to buy things, as his mother keeps a grocery store. He only lived a few doors from where I met him. If I was going out of Diamond Street, I turned up 6th and was going straight ahead. Mass was going at an angle crosswise. At the time I met Mass, I had the body in my arms. One on to Dauphin Street, and then to where I put down the body, near to a pond of water on the spare lot. I hardly had it out of my arms until I saw a man coming. Then I ran and got behind this barn, a little distance from the place, waited a minute or two, then I went down 6th Street and Susquehanna Avenue, and a lager beer woman seen me. She was opening her shutters from the inside. I held down my head and threw up my arms like this, crossing them over his face, so she could not recognize me. I asked him who did his washing. He told me his wife at first, then the washing all went out. He told me 3 different ages of the child. He told me Mary Mormon was only 6 or 7 years old. I told him he was a liar. He said that was her age. He asked me if I was in his place, what I would do. He had friends and money and influence. I told him I would get my friends to see Charlie Mass and the lager beer woman and try to get them to keep their mouths shut. He said, I have plenty of time to do that if I am to be brought up. He asked me did I think the detectives would settle it for money. I told him I didn't know. How often, he said, can a detective search your house? I told him whenever they had a warrant, I supposed. He said this Taggart is a fly man playing sharp. I said Taggart was marking thieves from New York. He said I've got good mind to send for Smith at any rate. I said please yourself and you'll please me. He got a shoemaker's hammer and knocked on the door. I told the keeper he wanted to see the assistant superintendent, Mr. Howard Perkins. The next morning he told me he saw the man in his cell, and I think it was the next night Mr. Smith saw him in his cell. He told me the next morning when he came he had seen Smith. He showed me a pipe Smith had brought for him. He said if he had taken her through the cellar door, it would have been on the kitchen side. That's the reason he put her through the window. His mother, wife, or sister might have come down into the kitchen and seen in. He said there was a little passage between the kitchen and back cellar door where they kept coal and some old bottles. He said his mother went out with Mary Mormon's mother that night he went to, but returned. He said something about his mother going to visit Mrs. Mormon at her house. He told me the officers watched him for 2 or 3 weeks. He did not say he spoke to them, but said they followed him, once to his brother-in-law's and once to his lager beer saloon up to the steps. He told me his wife asked him on Monday morning where he had been all night. He said, fell asleep below and have only just woke. On Tuesday morning she asked him again, where have you been all night? He said, Annie, I got into a muss with 2 police officers, for she saw some blood on the bosom of his shirt. He said, on the day the body was found, I went over to Fisher's Lager Beer Saloon and stayed there till 12 o'clock, just to hear the conversation, what would be said about it, and I said, as they're said. They told me they had arrested some man with whiskers on, he said. That made it look well for me. He said there was a subscription made up for Mrs. Mormon, and he gave some $2, that he went the day after the body was found to see it at Mrs. Mormon's house. He said he had 2 pairs of slippers, one light, one dark, both plush. He had the light pair on the night he took the body, he said. A very strange man came into my shop. I put him down for a spot right away because he tried to get into conversation with me about the murder. I turned it off to the weather. The cap, he said, they tried on my head was mine, but they can't prove it. After the Germantown affair happened, I told my wife and mother that I was suspected of the murder of Mary Mormon, so as to have things fixed up if I got arrested for it. John Shriver. About 20 minutes to 9, I saw a man in the alley near Hanlon's house, as described by Hanlon to Dunn on the night of the child's disappearance. Charles Mass. Saw a man on the morning the child's body was found carrying something heavy in his arms. He was on 6th Street going toward Susquehanna Avenue. Was a middle-sized man about 5 feet 5 inches high, rather slim. Did not know him. It was 3:30 or 4 o'clock. End of section 34. Section 35 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of John Hanlon for the murder of Mary Mormon, Philadelphia, Pennsylvania, 1870, Part 2. November 5th. The courtroom was crowded today, and the entrances were thronged with people anxious to get admittance. The prisoner looked restless and excited, but under the circumstances few men would have been as self-possessed as he was. His young wife and sister sat as usual near the counsel. John N. Giberson. Am a brickmaker. The morning on which the body of Mary Mormon was found, I was going on the Germantown road to my work between 3 and 4 o'clock. I saw a man 25 yards ahead of me after I had crossed Diamond Street. I was on the east side, the man also. He was about 6 doors ahead of me. Near Germantown Road and 6th Street, the man seemed to be carrying something heavy in his arms across the left breast. He was walking pretty sharp, was apparently barefoot. He made no noise. Cross-examined. The man went up to Susquehanna Avenue on the east side of 6th Street. I went 5 or 6 paces above the bend on the avenue, and at an angle to the old foundry. At Germantown Avenue and Susquehanna Avenue, as I was crossing, I saw Charles Mass in front of his house. About 20 paces above Susquehanna Avenue, I lost sight of the man. Had my back to him. He was about 5 feet 5 inches high. He was slender-built, did not know him. Did not notice his dress, did not see his face. Emelina Welsher. In September 1868, I kept a lager beer saloon at the southeast corner of 5th and Susquehanna Avenue. Remember the finding of Mary Mormon's body. Got up in the morning and was opening my shutters when I saw a man coming from the brickyard to my pavement. When he reached my pavement, he turned down 5th. He run down a few pavements, and then I shut my windows. I looked out into 5th Street. He ran down 5th Street on my side. I did not see him in the face or take any particular notice of him. He was dark-dressed. I could not tell exactly what time it was, but it was toward morning. Cross-examined. He did not run, he walked fast. I think it was about 4 o'clock. I did not hear the man before I saw him. I only saw him, could not hear him. My little girl cried at that time. I could not tell. Anna Emery. Saw the body of Mary Mormon on Tuesday morning, September 8, first at 20 minutes past 5, lying at the side of the pond. My business is that of dressing and laying out the dead. It was covered with a piece of carpet. Next saw it at the 18th Ward Station House on Trenton Avenue. Saw the injuries upon it. These are the clothes the child had on when found. Clothing produced. About 2 o'clock on Tuesday the body was removed to Mrs. Mormon's. I never left Mrs. Mormon's from Monday evening until after the child was buried. On Wednesday morning, the morning the child was buried, Hanlon passed into the house with the crowd. He passed in the front door and out at the back, and as the rest of the people did. The body was lying in the front room. The crowd passed in to look at the body, and Hanlon was among them. I raised for Mrs. Mormon $26.72 from the crowd as they passed through, but I don't remember whether he gave any money or not. Mrs. Mormon, recalled. There was money raised by contribution for me. After I had paid my expenses, it left $4.35 in my hands. The neighbors and others did this. Could not tell whether John Hanlon or any of his family subscribed anything. Alderman Hines. I was alderman of the 19th Ward when the body was found. Detectives Tryon, Taggart, and Levy engaged in the investigation. They worked in my neighborhood several weeks. After investigating the matter for several weeks, it was dropped. During that time, a number of arrests were made. All the parties then arrested were discharged except one who was held to bail for open lewdness. The men brought into the office were generally men who had black whiskers, did not know Hanlon by sight, first came to know him about the time the murder was committed, saw him frequently after that up to the time of his arrest. Don't know what name he went by in December. I first learned of what Shriver could testify about the time a true bill was found in this case. Never saw Michael Dunn until I saw him in court. Never had any conversation with him. Am familiar with this locality. In September 1868, there was a brickyard on the southwest corner of 5th Street and Susquehanna Avenue, and a lager beer saloon on the southeast corner. William Quester. Am a butcher. Remember the morning when the body of Mary Mormon was discovered. Had been to a watermelon party the night before. Left the house 20 minutes before 4 o'clock the next morning. I crossed the lot at Susquehanna Avenue about 10 minutes to 4. I crossed from 6th and Tyson Street to 6th and Susquehanna Avenue. After I had crossed 6th Street, I saw a man. I stood on the edge of the path and didn't know whether to go over the path or not. He stood on the lot, pretty close to the old house. He walked around the old house, and I went on. He went to the north of the old house to get around. I passed on. After he walked around the old house, I saw no more of him. I went pretty smart when I passed the lot until I reached 5th and Susquehanna Avenue. Then I started on a little run. The man was, I thought, about 50 yards ahead of me. It was pretty dark. I did not overtake or pass him, or see anything more of him. Cannot describe the man's appearance. Cross-examined by Mr. Brewster. Heard of the murder the same morning. Was at home at my mother's house about 10 minutes past 6 o'clock. Told my mother I saw the man and no one else. I did some time after. I could not say when. I did tell, I don't know who, did not take notice. This thing was a subject of general conversation all about the neighborhood. The nearest I saw this man was about 50 yards from me. Joseph Neal. Was an officer on the police force in September. Remember the death of Mary Mormon. Was detailed then with the others to take charge of the matter by Lieutenant Whitcraft. Saw Hanlon. No detectives were along with me. Had a little conversation with Hanlon at that time. He wanted to know what kind of looking men the detectives were, and how they were dressed. He asked me if they had a right to go through houses. I told him that depended on the nature of the case. To a juror. Think that was about 5 o'clock, just after the child was found. It was in Hanlon's barber shop. Hanlon knew me, had my uniform on, never took notice what he wore on his feet in the barber shop. He asked me as he was shaving me. Samuel Grant. Was an officer of the force in 1868. Was detailed in reference to this matter. I was kept on duty about 7 weeks. Mr. Tryon. Was detailed for duty in this matter with several others by Mayor McMichael, some 4 weeks. Was not in the house of Hanlon. Saw Hanlon only once before, 1st of March. I told him nothing but what I heard. Sometime in March I saw him. I communicated that to Alderman Hines. First learned then that Shriver knew of the case. Mr. Taggart was one of the officers detailed by the mayor to investigate this case. Was in the neighborhood about 3 weeks. Saw Hanlon frequently. Was not in his house. About the latter end of last December, I first learned that Shriver knew anything about this case. I never saw him until the stand here. Have seen Dunn 2 or 3 times. Did not communicate to him any of the facts of this case. Was not at the house of Mary Mormon's mother on the day of the funeral. Don't recollect seeing Hanlon that day. Mr. Smith, am a detective, was detailed to investigate this affair. Was engaged 3 weeks. Saw Hanlon. Was not in his house until after it was over. Saw Dunn several times. Did not communicate to him any of the facts of the case. Was not at the Mormon house the day of finding the body. Can't say I saw Hanlon that day. Mr. Perkins. Am assistant superintendent in the convict department of the county prison. Hanlon came in the convict department 9th December 1869. Dunn came August 15, 1868. Was present at several interviews between the detective officers and Dunn. Did not communicate to Dunn at any time any of the facts relative to the killing of Mary Mormon. No one but detective officers had access to Dunn to my knowledge. None but religious newspapers are allowed to be given to convicts, and these not by visitors or friends, but by the prison society. All letters in and out are inspected. They are opened and read. To my knowledge, no communication was made to Michael Dunn of the disappearance and death of Mary Mormon. None whatever, sir. Alderman Francis Hood. Am an alderman of Philadelphia. Know the defendant. On 25th November 1869 at my office, he gave me the name of Charles C. Harris. The business which brought him there did not have any connection with the present case. Did not see him again after that until I saw him in this court on Monday last. November 7. The crowd today was even greater than the previous days of the trial, and the excitement of the spectators was equally as great. Edward K. Tryon. I at no time communicated to Michael Dunn any of the facts relative to the murder of Mary Mormon. To Mr. Haggart. 1 week ago I first learned that a man was seen to go behind the old building on the lot. I learned it from Alderman Hines. Did not see the witness William Quester until I saw him here upon the stand. Prior to the confession, had not heard that a man had seen a man go behind the old building upon the lot at 6th and Susquehanna Avenue. A week ago I first learned that the witness, John Giberson, had knowledge of the transaction he has related. Learned it from Alderman Hines. Mr. Haggart offered the plans and clothing of the child in evidence. He said that he had given in all the evidence that they now had with the exception of a witness who might not arrive until late in the day, or perhaps tomorrow. The Commonwealth would like to close, reserving the right to examine the witness whenever he might arrive during any stage of the case. Judge Ludlow. We are to understand with the reservation of examining that one witness? Mr. Haggart. Yes, sir, with that understanding we close. Judge Ludlow decided to accord the Commonwealth the privilege of examining the witness, but stated that the defense could make their objection when he was produced. Mr. Haggart, we will now close without any reservation, leaving the application for the admission of the evidence of the witness at the close of the defense. Judge Ludlow, very well, the Commonwealth now closes without any reservation. The defense. P.F. Carroll, junior counsel for the prisoner, arose and opened the case for the defense. He said the Commonwealth had exhausted a whole week in presenting their case, had presented a great many isolated facts, which, but for the statement of the infamous witness Michael Dunn, would not have thrown the slightest ray of light on the matter. He would prove that the prisoner was not where he was said to have been by the prosecution, and in fact would establish a complete alibi and vindicate the prisoner's innocence. He would prove that the witnesses examined in corroboration of Dunn's statement gave entirely different statements when the occurrence was fresh in their minds, and they were examined before the coroner, and they would produce witnesses who testified before the coroner and were not examined here to prove his innocence. In short, he would prove that at the time of this occurrence, Hanlon was in bed and remained there all night. John Fisher. Resided on September 8 at the southwest corner of 5th and Diamond Streets. I sell liquor. Remember the night that Mary Mormon was missing. There were several in my bar room that night. Hanlon was there from 7:15 to 8:15. He had on a white shirt with brown stripes, no hat, no coat, sort of light pants. Think they had a stripe down them. He had no coat on when he was at my place. Had lived at that house 4 or 5 months before that. I don't live there now, lived there a couple of months after the occurrence. Cross-examined. Mine was an old dwelling altered into a bar room, the lower portion. Hanlon was in from 7:15 to 8:15 o'clock. Knew the time because I ran out of beer at 9 o'clock. Hanlon had 5 or 6 drinks during that time. He had on his working clothes. Did not see him again after leaving my house that evening. He was in the habit of visiting my house, but not daily. I think he was there when the report came around, the day the child was found. Do not remember Alderman Fields being in my house that Sunday evening. Don't remember Mr. Strawhauer being in there. Did not remain in the barroom all the evening after Hanlon went out. Kate Hanlon. Am going on 18 years of age, am a sister of John Hanlon. My father and mother are alive. In September 1868, they resided 2055 North 5th Street. My father, mother, brother John and his wife, my sister, and a smaller brother, and myself lived in the house. Mrs. Steinmeier is my sister who lived in the house. On the first floor there is a barber shop fronting on 5th Street. Back of it there was a small kitchen. There was nothing back of it. Outside was the yard. Upstairs there was a front room facing on 5th Street. Then there was a back room in the 2nd story. In the 3rd story there was a front room on 5th Street. Then there was a back room, and that was all. There were 2 rooms in the 3rd story. There is a cellar to the house. It had a gravel floor. The entrance to it was from the back kitchen. The front room was used for a barber shop. My brother John carried on the business. He was married at the time. He occupied the back 2nd story room. He occupied it for a sleeping apartment. His wife also occupied the same room. Mrs. Steinmeier, my sister, occupied the front 2nd story room. The front 3rd story my father and mother and little brother occupied. The other room I slept in. The back room in the 3rd story. Remember the Sunday evening on which this little child was lost. I think there were 13 in the house on that Sunday evening, leaving my brother out. Ellen Quinn, Kate Quinn, Johnny Quinn, Barney Quinn, Annie Quinn, Owen Hanlon, John Hanlon, my father, Bridget Hanlon, my mother, Annie Hanlon, John's wife, Mrs. Steinmeier, Jenny Steinmeier, and myself. There were 2 babies, Jenny Steinmeier and Johnny Quinn. They were both babies. During that afternoon and evening, Mrs. Quinn, Ellen Quinn, Kate Quinn, Barney Quinn, and Johnny Quinn came there. They were there that night. My sister, Mrs. Kelly, and her boy came there to visit. Her first name is Mary. She did not remain there all night. Was sitting on my steps the early part of the evening, the steps of my house. My brother, John Hanlon, passed me and went over into Fisher's Lager Beer Saloon. That is on the corner of 5th and Diamond. It was kept by the witness last up on the stand. Can't say how he was dressed. He had no coat or hat on. He returned that evening. Saw him return. Saw him standing by his bar window from where I was sitting. Saw him come across from Fisher's. He passed me on the steps and went into his shop. That is all I saw of him. When he passed me going into his shop, he had no coat or hat on. Don't remember the color of his pantaloons. It was a good while after dark. The next I saw of him was the next morning at the breakfast table. He breakfasted with me. His wife, my mother, and my little brother, Mrs. Quinn and Ellen Quinn, breakfasted with him. My brother John passed me while I was sitting on the step into the house. He passed me going out in the early part of the evening. He passed me going in, can't say what time. Coming from Fisher's when he passed me, he had no coat on. When he came to the breakfast table next morning, he was in his shirt sleeves. He had on light pants. His shirt was not soiled or bloody. Think I saw him that evening. When I went to bed, I do not remember seeing John. Next saw him on Tuesday morning. I saw him when I was going up to see Mary Mormon, when she was found. My father was in the house on Sunday afternoon, lying down on the settee. Retired at nearly 11 o'clock on Sunday night. Was out in the yard on Monday morning. Was in the water closet. Saw no blood there. I saw none in the yard. Could not say what time I went into the yard on Monday morning. It was before breakfast. The cellar was not used for anything but a little bit of kindling wood. After John went in, Mrs. Kelly and her little boy and my mother and Mary Quinn passed out while I was sitting on the steps. It was about 11 o'clock or a little before when I went to bed that night. Can't remember where I slept. There were so many in the house. Did not hear any noise in the house from the time I went to bed until I got up. Cross-examined. My mother, Mrs. Kelly, and the little boy went out first. Mrs. Quinn did not go with them. I can't say where they went. They went up to Diamond Street. My mother was gone 10 minutes. When she came back alone. Mrs. Kelly and the boy did not come back. Mary Quinn did not go out with them. She went out after my mother returned. I could not say how soon after. My mother went out about 3/4 of an hour after my brother went into the house. Mary Quinn did not return. Was sitting on the steps when my brother went into the house. There was nobody in the barber shop when I went to bed. When I got up the next morning, the barber shop was open. Could not say what time we had breakfast that morning, the usual time. That was from 6 to 6:30. My mother generally opened the barber shop and swept it out and then called John if anybody came in. After my mother passed me, John Hanlon's wife was the second one. She went in, did not see any blood marks upon my brother's clothing. Saw my brother John on Monday evening in the barber shop. It was before supper time. I did not see him when I was going to bed. I saw him on Tuesday morning when I was coming down 5th Street and he was going up 5th Street with Mrs. Steinmeier. This was early in the morning when the child was found. The barber shop was open at that time. Did not see my brother on Monday morning before I saw him at the breakfast table. November 8. The excitement was as manifest as before, and the court found it necessary to call upon the mayor for a detail of policemen to keep the entrance open. Mary Quinn. Am 18 years old past. Recollect the night that Mary Mormon was missed. Was at Hanlon's that evening. Got there between 6 and 7 in the evening. Stayed by the door till dusk, and then went into the barber shop. Picked up a weekly paper and sat and read it. After I sat there some time, John and John's wife and his mother passed through. His wife asked for a lamp, and I heard them go upstairs. I heard the footsteps. A good while after that I went into the yard. Did not see John Hanlon that night after he passed me coming in. Cross-examined. Am first cousin to John Hanlon. Was not upstairs that evening. No one was in the barber shop with me. John's wife did not come in until she came in with him and his mother. She went out to the kitchen, was reading the chimney corner, was in the yard, was in the water closet. Can't tell the time of the evening I was out there. When I got in the barber shop again, Mrs. Kelly, her boy, and John's mother went out. Remember these occurrences because I made an engagement to go out with my cousin, Kate Hanlon. Before I went home, I heard the child was lost. There were bells in the street that evening. Have not heard them on any other Sunday night. There was great excitement. That is the way I remember, because I remember on that evening I was to go to a young lady's house. That is the reason I remember so particularly. When I heard that John was suspected of it, they asked me if I remembered that evening, and I said I did. I had no talk with John of it. It was a long time after John had been arrested. They asked me what I knew about it, and I told them what I told you. Told his mother, and when the lawyers asked me, told them. Saw no other persons that evening except John, his wife, his mother, and Kate. I think when I went through the kitchen I saw his father lying on the settee. Did not speak to his father. Mary Kelly. John Kelly is my husband. Have been married 7 years. Live at 2059 Germantown Avenue. My husband is a liquor dealer. I have a family, 1 boy living. Am John Hanlon's sister. He was a bar after he came from the Army in 1866 or 1867. Set up business in 5th below Diamond. He lived there in September 1868. My father, mother, 2 sisters, 2 brothers, and John's wife composed the household. The second-story front room was used as a sitting room. There was no bed in it. There were 2 rooms in that story. The back room was used as a bedroom. My brother John and his wife used it to sleep in. There were 2 rooms in the 3rd story. They were used for sleeping rooms. The yard was paved. There was a goat house in it. There were 2 gates each side, a kitchen door, 2 windows, a cellar window, and a water closet. 1 window from the end of the barber shop and 1 from the kitchen. The window from the barber shop was over the cellar window. The other was pretty near it. Was at John's house on the night of September 8th, 1868. Went from my own house. It was after people went to church. Took my little boy to my mother's. My sister and my cousin were sitting on the step. My sister Kate and Ellen Quinn. Asked them where my mother was. She was just coming out in the barber shop. Had some ice cream and went upstairs with my mother. Went up to John's room, that is, the back room of the 2nd story. He was in bed and his wife was getting undressed. I called my sister out of the other room, Mrs. Steinmeier. She came from the 2nd story front. My mother went downstairs for saucers for the ice cream. My little boy went alongside of the bed, and my brother John lifted him up. Then we all eat some of the ice cream. My mother, my sister Lizzie, Mrs. Steinmeier, John, his wife, and myself. Sat a few minutes, then I went downstairs and went home. Lived about 3 doors below Diamond Street, just around the corner from 5th Street. I first spoke of this affair after John was so accused of it, when I seen it in the papers. Bridget Hanlon. Live in Jersey. My husband is alive. We are living at Millville. Am the mother of John, the prisoner. He is 22 years of age. Married. Could not say how old his wife is. 16, I think. In September 1868 was living at 5th and Diamond. My husband was living there. He was a laborer at that time. John and Lizzie and Kate and Owen were in the family, living with me in this house in September 1868. Remember the Sunday evening on which Mary Mormon was missed. At that time, Mr. Hanlon, me, Lizzie, Kate, Owen, John, his wife, Mr. Steinmeier, Jenny Steinmeier, Kate Quinn, Johnny Quinn, Barney Quinn, and Annie Quinn were there. John's wife was there. Mrs. Quinn is my sister. John was at dinner. He went out near night. He returned again to the house. When he returned, I saw him at the corner of 5th and Diamond. John came across from Fisher's until 5th Street. Came down and went up the front steps, and I came after him. He went back in the kitchen. His wife asked me for a lamp. I got the lamp, handed it to his wife. He and his wife went upstairs in the back 2nd story. When Mrs. Kelly came with the ice cream, John and his wife, Mrs. Kelly, Mrs. Steinmeier, and me ate the ice cream. Went down for saucers and spoons. We then came downstairs. Mrs. Kelly asked me to go to the corner with her. Went with her to the corner of 5th and Diamond. We stood there a few minutes and she went home. I stood there a few minutes and I came down home to my house. My husband this afternoon was lying on the settee in the kitchen. He had a sprained knee. He was on the settee pretty near a week with a sprained knee. There was little kindling wood in the cellar. It was nice and clean, a little gravel, a nice floor. It was not bricked. There were no bricks at all. When John went out of the house, he was dressed in his shirt sleeves. His pants were a kind of a light, with a stripe down them. When he returned, saw him in the house. He was in his shirt sleeves. When I saw him on 5th Street, he was in his shirt sleeves. He had no coat on. He had no hat on. When we got back to the house, he had the same shirt on. That night, myself, my husband, Mrs. Steinmeier, John and his wife, Kate, Owen, Mrs. Quinn, Ellen Quinn, Barney Quinn, and John Quinn slept in the house. All these Quinns came there on Sunday afternoon. Saw John next morning in bed, about 5:30 or 6. Used to clean up the shop and sweep it in the morning, would put the kettle on and then open the shutters of the shop, and then go and waken John. Wakened him that morning. He got up. He was dressed the same as he was the night before. He eat breakfast with me that morning. He was dressed the same as he was the night before, in his shirt sleeves. We have breakfast about 6:30 generally. Was out in the yard this Monday morning. Was in the water closet this Monday morning. Was in the cellar this Monday morning. There was no blood or traces of it in the cellar, in the yard, or in the privy. Did John's washing. Tuesdays were my wash days. I washed shirts, washed the following Tuesday, the Tuesday succeeding this Monday, always washed on Tuesday. His washing was never given out. Washed the shirt that he had on the Sunday night and Monday. Believe he wore it on Monday. Washed it the next Tuesday, that is the Tuesday following the next Monday. Saw no blood marks on his shirt. There were none on it. He had no blood on his pantaloons or any of his clothes. He wore the same pants on Monday that he had on Sunday. There was no blood on them. There was none of his clothes missing. Mrs. Conathay's house was in the same lot. There was a fence between the yards. The 2 water closets were together. A lath and plaster wall separated the 2 water closets. End of section 35.